Good morning, good morning, good morning. It is Wednesday. It's February 26th. I always have to look at my phone to remind me, what day it is and what day of the week it is, because we need all of the things. But today we're going back to live court, except today we are zooming to Tallahassee, Florida. Finding a link for this today was not the easiest thing ever that we've done, but I will tell you, the court feed is a little spicy. It has like a ringing, like a low tone ringing in the background. We have tried. There is nothing we can do. We're going to make sure that as we get into witnesses, we have closed captions. But just so you know, that does exist. It's just bad court audio. If you want to miss this one, I'll summarize it later. I understand. Today, we're talking Donna Adelson. I briefly covered the motions that we're going to hear today, but today, because it's motion day, we're going to see witnesses, including Donna Adelson. If you don't know what this case is about, I'm going to do a road so far after we roll the intro, and we are going to get into it. But I'm very interested to go to court with y'all today because, oh boy. And even though we tried to start stream early, I was still running late, but we're still earlier than we normally are. So huzzah, just huzzah for all of us. Let's roll the intro. Let's talk about Donna Adelson. And you guys, court today, grab your snacks. I'm ready for it.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not Let's get into it.
So if you are not familiar with this case, I totally get it. But this case is a multi-part saga, and Donna Adelson may or may not be the last prosecution that we see. The victim in this case, Dan Markell, was a law professor at FSU. He was murdered almost 10 years ago in his driveway. So far, the two gunmen have been prosecuted. The middleman has been prosecuted. Charlie Adelson, the son of Donna Adelson, has been prosecuted. And now Donna Adelson is being prosecuted. Core to today are Donna's conversations with Charlie Adelson after he was convicted. What was going on? Well, family law. Wendy Adelson, the daughter of Donna, sister of Charlie, was going through the custody battle with Dan Markell over the kids. It seems, as alleged by prosecutors, that the defendant in this case, Donna Adelson, wanted the grandkids to be closer to Miami and not up in Tallahassee. And it looked like court was not going well in favor of Wendy Adelson to be allowed to move the kids. So the solution there is to keep fighting in family law court, or Donna get a pied-à-terre in Tallahassee. Nay. What we've seen so far from the other prosecutions is that they decided that a hitman was the answer. Narrator voice. It's never the answer. You're going to get caught. And that's why we're here today. Donna Adelson was on a jail call with her son, Charlie, and was talking about finding a country with no extradition, and then got arrested in Miami International Airport while trying to vacation on a one-way ticket or flee to a country with no extradition. It just depends on which theory you believe, the state, the phone calls, or what Donna says. And Donna says they were just going on a vacation one way. Today, Donna would like to not continue to be in custody. She also would like that phone call where she's talking about fleeing the country to be suppressed. The argument on suppression is that the jail call, well, the line cut. And so when the line cut and Charlie disappeared, then the government has to stop recording your call because the line cut. They're arguing that essentially it is an illegal wiretap and an overstepping of the government bounds. And if you've been here a minute, you're like, Girl, don't you have to have a reasonable expectation of privacy to even have a search and seizure Fourth Amendment claim? And essentially, doesn't wiretapping fall under search and seizure? Yes, yes, yes. Yes, yes, yes. The beginning of all jail calls say something to the effect of, "This call is being recorded." It says more than that, but it always says, "This call is being recorded," every single time. So Donna, through her lawyers, argued that she put the phone down and it should have just hung up. And I don't know if she's just like, "Oh, I just put the phone down." But the line was still open and you could hear their conversation. I covered that on a podcast. We'll link it again down below. So Donna is a special defendant, and we're gonna be chatting about that today to see what the court has to say. I really like this judge a lot. He's been decisive. I've only seen him look like he was about to lose his mind the day that this trial was supposed to start last September. And then there was this massive issue with attorney conflict because Donna Adelson wanted the same lawyers her son Charlie had, but Charlie didn't agree to waive the conflict. And everybody just kept going despite all of you. Everyone who covered this case, everyone's like, "Isn't that a conflict?" It's like, it doesn't seem like a waivable conflict, but if they waived it, I'm sure they checked. Well, Charlie Adelson didn't waive the conflict because he's going to be a witness for the government in the next case. And so Donna had to get all new lawyers. She was pissed. The judge was pissed the day of trial. And everything blew up. Donna's also mad because custody is not delightful and she would like to be able to stay home and on an ankle monitor while she awaits trial. But she's charged with murder and conspiracy to commit murder and fleeing. She's not charged with fleeing, but it's going to be used as a government theory. Also, there's a lot of water. You're going to be shocked. Emily, there's water near Florida. I know. But even if they argue that she turned over her passport, I think her desire to flee is going to be pretty high. I don't think she's going to be a threat to the public. I do think her risk of flight is massive. And her husband is still out of custody. Her daughter has never been charged. There is some type of an immunity deal because right after the ex-husband, father of the grandchildren, was murdered, and Wendy Adelson was told, and then the police were like, "Do you have any idea what could be going on? Like, this is a law professor. Did he have like clients that were mad? Is there beef of some kind? There's a divorce. What could possibly be going on?" Wendy said something to the effect of, "Oh, my brother joked about hiring a hitman." Interesting. That is interesting statement to law enforcement, Wendy. So we are getting into now there were two trials for the middlemen. There was one plea. So fifth trial in this case. This is going to be the fifth trial in this case. And I think it's going to be a really interesting one. I did not cover the trial of Charlie Adelson. Once they arrested Donna Adelson, I was like, all right, that's it. I need to know. I need to know everything. We're following that. We're on it. Law nerds have slated this case in. Probably for June. We're going to figure it out. So we're going to go to court. We're going to get into motion to suppress and a motion for bond. I suspect bond will be denied. I'm very interested to see where they go with the motion to suppress. I also suspect we're not going to get very far in the motion to suppress. I don't think you have a reasonable expectation of privacy. If there is case law specific to this situation, which there probably isn't, I will be interested to see it. But we've still got two more people that may or may not be charged in this. Oh, and some of you may remember she was the one that laundered the money and it was still wet when she paid in cash and kind of smelly. This is that one. We haven't heard that she Googled luxury prisons for rich people like Corey Richins, but I'd love to know what her Google said because, she is the one who literally washed with water money It also tells you that Donna doesn't watch a lot of TV. Like, girl, what are you watching on TV that you actually think that's going to work? What did you think was on it? You're going to wash away your fingerprints. That's not how laundering money works. But it was one of my favorite details about this case. I was just like, yep. So we're going to court, and we're going to see the witnesses. There's going to be a break in the middle. The lawyers took a break. Guess what? We're going to zoom. We're going to zoom. Avi Callie, right? No, Cial. Not me remembering the Ozark intro where he's washing the money. Right. Oh, Donna. All right, y'all. I think we just need to fly to Florida, specifically Tallahassee, and head to court. Emily, have you ever been to Tallahassee? Do I have to drive through it to get to Orlando? Maybe. Because we always stop. There's like 3 Buc-ee's that we always stop at. I don't think one of them's in Tallahassee. Emily, do you map your drive from Middle Tennessee to Orlando by the Buc-ee's? Obviously. Is there another way? I mean, there's the 2 in Georgia. Is there any other way to do it? Cleanest bathrooms. Look, no matter what size cup you get, they will sell you the crunchy ice. And sometimes it will keep me from all of the candy on long drives. I just need the chewy ice. Buc-ee's is like 50 cents, girl, whatever size cup you need. We got the chewy ice for you. Thank you very much. EDB Air only has first class. The whole plane is first class. Low lighting, no heavy scents, soft, cozy seats. No, it's more like a PJ. It's all first. Yeah, I think we need some introvert seats where it's like, don't anyone sit next to me. Just like the center is just a single seat. Like, don't sit next to me with like a little like covering around it. And then some seats for people who want to be social. Yeah, we get to make it what we want. So EDB Air, you guys are getting miles today. Let's go to Florida. Again, I'm going to apologize about the sound. We're going to switch feeds. The one feed misses the beginning of court. So we're going to switch feeds to a feed with closed captioning after we get past the intros. But I didn't want to miss a minute. I didn't want to miss a minute. I told you about the background noise. It's not you. It sounds like there's an alarm going off in the courthouse. It really does. Also, Donna has also been complaining, or her lawyers have been complaining, that they can't hear her on the jail calls with her because her breathing is so bad and she needs medical attention, and her hearing is so bad because she has very small ear canals and she needs to be out of custody to go to the ENT, amongst other things. But she's already got the poor me face going today. Emily, it doesn't sound like you have a lot of sympathy for Donna. No, I don't. I have sympathy that jail's hard, but I think she thought she was never going to get caught. We've seen a lot about this case, a lot about it. So it does. It sounds that's exactly what it is. Pickled sweets. It sounds exactly like the emergency broadcast tone. I'm going to zoom us forward a little bit. I think Donna is probably nervous. I can have some empathy for the fact that custody's hard, but also, she's like, I never saw myself ending up here. Yeah, you probably didn't. Yeah, that's probably right. But washing money's not going to do it for you. So
Doctor will move things along, and sometimes they will not.
I like this judge so much.
Sometimes your doctor will move things along, and sometimes they will not.
Okay, thank you.
It looks like they're going to be calling to order in just a second. I heard the judge. Oh, no. Just lawyers lawyering. Doing all their pre-hearing stuff. That's a lot of pre-hearing. Hold on. All right. They haven't called to order yet. There we go. That should be the call to order. There we go. Emily, you said you wanted to see all the stuff before. Yes.
All right, good morning, Mr. Toomey.
Good morning, Judge.
Wow, that
Getting
sucks.
everyone's set in the courtroom and also getting the Zoom set as well. We are going to start at 9:15 as was scheduled today. I was speaking with the attorneys at sidebar before I turned on the Zoom, and Ms. Dugan let me know of the issue that you had with a separate hearing at 10:30. If we need to take a break as to the suppression hearing, which will start first, we'll take your client's
Very
testimony at
compassionate of
10,
the judge.
and that way it should not cause you any difficulty with moving on with your day.
I appreciate it, Judge.
All right. For everyone on the Zoom as well, the audio will remain up and running. However, there will be a still frame over my face. I'm sure as riveting as it is to see me talking, nothing else is going to be occurring over Zoom. It is all going to be taking place in the courtroom. So you understand if you hear things, but you don't see anything going on.
It's normal. That's very kind of the judge to say
We'll
you have
get
another hearing in
started
another
at
court. Don't worry.
9:15, as we previously stated.
We tried to make the court hearing mono as it got pushed out through StreamYard. If you are only hearing court in your left ear, it is the court feeds. All of them are mono, but we will be switching feeds. Excuse me. We tried to fix it on our end as best we could. We are really at the mercy sometimes of the pool camera. So they'll be calling to order. But yeah, it's if this is what it sounds like the entire trial, it's gonna make me crazy. I'm hoping that for trial we will have some better setup. But even getting these hearings streamed has been difficult. They are not always covered. So finding streams of these hearings has been a challenge. All right, it looks like they have a bit of a delay before they call to order. So, or another delay before they call to order. We're gonna zoom.
Parties at
There we go. Good morning, Your Honor. Let's call to order. They're gonna start with the suppression hearing, and with the suppression hearing, we're gonna get witnesses. Remember, the key of the suppression hearing is that jail call.
Everyone can be seated.
Looking for my Donna Adelson notes. It's been a minute since we've been in
We're
court
here
on this
this
case.
morning in state of Florida versus Donna Adelson, case number 2023 CF 3226, on the defendant's motion to suppress and also the defendant's motion for Arthur hearing or to set bond. Parties may make their appearances.
Sir, Catherine Dugan on behalf of the state. Eddie Evans is here on behalf of the state as well.
Joshua Zellman on behalf of Mrs. Adelson.
Jackie Fulford on behalf of Mrs. Adelson.
The issue that the court previously addressed with the parties at sidebar concerning Smiley versus state, and also how the burden of proof is to operate in a motion to suppress alleged wiretap statements.
And we know this from covering the hearings in Idaho, what the burden is, and the court is going to break it down. So we're going to roll with the court while the court breaks down the burden. But this is like in an anti-slap motion where there's like a two-part burden where it's like first you have to meet this threshold and then it shifts over. That's what the court's going to be explaining.
Is there any argument from either party concerning those?
No, Your Honor.
No, sir.
We're not
Very
explaining.
well, Mr. Zellman, as the defendant has the
I'll be
initial
explaining.
burden under that appellate holding.
No, Emily, you'll be explaining. The defendant starts with the burden and then the prosecution has to rebut that if the defendant has met their burden. There we go.
You may proceed.
Your Honor, defense's first witness is going to be Jason Newlin with the state attorney's office. I'm told he's on his way down.
So the first witness is from the state's attorney's office. What's perfect is that this is a great time for us to switch our feeds. Is it going to make that tone in the background go away? Unfortunately, no, I'm sorry, it's not. But we should have closed captioning so that I don't have to gain up the audio. And for those of you that are like, but Emily, it's on mono sound. I know. there's only so much we can do. And unfortunately, I do not have the means at this moment. I'm not forestalling that in the future to just have our own shit in the courtroom. God, wouldn't that be lovely? One day we'll make it happen. All right, let us continue. And yes, members, I see you asking, we will have a members only live. Time is still TBD. I will post it. Do not worry. All right, let's get into the hearing.
Investigator Newlin, you can come back to the witness stand.
I was trying to grab those closed captioning to move
Please
them.
raise your right hand, sir. Do you swear or
His
affirm
name is
the
not Merlin.
testimony you're about to give will be the truth?
I swear.
You may take your seat. You may examine when you're ready.
Thank you, Your Honor. Morning, sir. Can you please introduce yourself to the court?
My name is Jason Newlin, Jasonnewlin.
And how are you employed, sir?
I'm an investigator with the State Attorney's Office here in Tallahassee.
So you're sworn law enforcement?
Yes, 21-something years.
Okay. And as part of your duties with the State Attorney's Office, have you been trained?
Law enforcement with the state attorney's office, that's not unusual. Even the district attorney's office in LA had like district attorney investigators who are sworn law enforcement. So not an attorney, a law enforcement branch of the state's attorney's office. And Law Junkie, welcome. We did a brief road so far at the beginning. Murder, conspiracy to commit murder are the main charges.
In reviewing calls made from the Leon County Detention Center. Okay. And is that through Securus?
So this is
It
going
is
to be
now,
the
yes.
defense doing the direct examination because they have the burden
How
at
does
this
that
hearing.
system record inmate calls?
How does it record? That's usually proprietary stuff, but I know the inmate they register an account, they set up a password, and then to complete a phone call, they have to go through a process of using their PIN, calling the number. Each party is advised the phone call will be recorded, subject to monitoring, and then the called party has to accept a phone call before it's completed.
Before the call can be connected.
How are jail
between the two
calls
parties?
made?
Correct.
And you indicated that they're given, the inmates are given, it's a PIN number?
The inmates pick their own PIN number.
Okay. And the inmate has to enter that PIN before they die.
At some point during the process, yeah.
So there'll be an inmate ID that'll track how inmates are making calls. And then when you go to request calls, and different states can do this differently, but when you go to request calls, you generally search by the inmate's ID. I would imagine that now systems can also search by voice. And if they can't, they're probably getting close because you will see inmates, and we've seen this in the Diddy case, you will see inmates using the IDs of others so that their calls don't get picked up as easily on the system. So if the inmate ID is like 12345, you make a request for inmate 12345, and then you get all of the calls they've made. But if they're using inmate 789's code number, often in exchange for commissary, if you're using the other inmate's code number, then when you run 12345, you won't get 789's calls. So then you have to figure out what other pins an inmate is using when they're trying to make sure their calls aren't being heard, which again, we have seen that going on in the Diddy case quite a lot. Linda said, do they have minutes? Yes. Oftentimes though, they will put in their numbers and call collect, but yes, they do have, they can have money on their phones or they can call collect. It really just depends. And yes, this is why Murdaugh was always doing stuff. Yeah, Murdaugh was also trying to avoid it. So it can be a game of whack-a-mole trying to find what calls are being made. And it's all how calls are being made within the jail system is a whole other situation. And there are other proprietary systems that we've talked about in the Diddy case. It's a whole situation. It's a whole situation. Cena asks, is there a limit on what people can put on an inmate's account? It depends on the case. We've seen cases like I think in R. Kelly where those accounts are essentially portions of them are taken for restitution, but there's probably varying limits depending on the system because they don't want to keep too much money on your books and they never want books to become like a money laundering like actual situation, but those can also be garnished for restitution if restitution is ordered in a case. So we can talk more about that, but we'll never get through today. And I do unfortunately have a hard stop today. So I'm going to try to get us through court, but I know the background noise is a lot.
And is that intended to ensure that the calls are tracked by the inmate making the call?
That's the intent.
Do you know whether or not an inmate's PIN can be used more than once simultaneously for calls? So if an inmate is using their PIN to make a call, that call goes through, can someone else use that PIN?
I do not.
And the Securus system, its digital system is the quality is very clear, correct?
Sometimes it's rough.
That depends on the inmate and the called party.
And the device used, you have the tablets and you also have the phone booths themselves.
Now this system, it's designed to intentionally record these calls, correct?
Yes.
And it records those calls from call acceptance to termination.
Correct.
When does the call terminate?
Usually when both parties hang up.
Did you hear what he said? When does a call terminate? Usually when both parties hang up. Oh, we fixed it. Audio is better all of a sudden. Yay! I went with counterintuitive and tried unclicking a button, and it worked? Yay. We were trying. I figured I would try just one more thing. If that just one more thing worked, I'm so happy for it. So high fives all the way around, guys. Yay. I'm glad to hear it. So when both parties hang up is going to be part of the issue. Streaming is dynamic. That's not the answer the defense, by the way, that's not the answer the defense wanted. When does a call terminate? When both parties hang up and the defense is like, shit. Also, just because we didn't do it yesterday and it's been needed all week. Let's go back to court.
Now, are you familiar with the Securus Call Platform, SCP?
I'm familiar with how we access it. I'm not familiar with the intricacies of Securus, though, no.
Right, but you've been trained on accessing that in order to collect the calls.
Yes.
Now, are you familiar with a feature that Securus offers that they call covert alerts?
I'm familiar with it.
Did you create any covert alerts concerning Charlie Adelson, Donna Adelson, or any other individual that Charlie Adelson called?
I've never created one for any case.
Now,
can you explain to us what the covert alerts are? Because they sound sassy. I want to know what the covert alerts are.
To Charlie Adelson's conviction, did you create a report that's 24 pages in length based on the calls that Mr. Adelson was making from the jail?
I did what I refer to as an extraction of the Securus information for a specific time period, and it produced a report.
Your Honor, may I approach the witness?
You may.
I'm going to approach and show you what's been marked as, for identification as defense 1. Take a look at that. Do you recognize that document?
The call on the system is pretty damning.
I do.
For Donna, so I'm not surprised they're fighting
That's
us.
an excerpt of that, correct?
Correct.
Aside from it being reduced in size to reflect what is relevant for the proceedings today, is that an accurate reflection of the report that you generated?
I believe it is, yes. If this is going to be the same one we've had prior communication about.
Yeah, this is, I emailed you two different excerpts, one last week and one, I believe, 2 days ago.
Judges
Yes.
closed caption.
I
don't want to block the closed caption with my face, like we're going to ride right on, right on the edge of my...
Is there an objection to defense one?
No, sir.
Defense one is admitted at this time.
If you can give that to the judge, and I'll give you a copy.
I like this judge so... The affect is so good.
Now, there's a phone call.
All the time, we're going to get it all done, you guys. We're all here together.
Has been referred to as the open line call, correct?
There is, yes.
And that's a call that was made,
Okay, so they're calling it the open line call. Great.
July 7th, 2023 at 14:57:01. I believe it's call 562 on that report.
And yes, they pull all your jail calls. When they say this call's being recorded,
Familiar
someone's
with that
going to
call?
listen
Yes, I am.
to them. There's no amount of slickness that's going to get
You have an
people past it.
opportunity to listen to that call.
I have.
Recently, I glazed over it a couple days ago, but not the entirety of the call. I just wanted to make sure I had the same call again.
Okay.
Sir, if you start talking about glazing this early in the morning, the law nerds are absolutely going to lose their shit. Can we go with glanced over it? Not glazed over it, please. For all of you just coming in, it's a motion to suppress regarding the phone call between Charlie Adelson and Donna Adelson ahead of her trial starting in June. Yes, her trial is starting in June. It's going to cause some timing problems. Who knows? We'll figure it out.
And may I approach the witness, Your Honor?
You may.
Sorry, Your Honor, let me correct myself. It's not July, but November 7th, 2023.
So the date was corrected. Appreciate it. Great. Hold on, that was me. Sorry, chat. I was messing stuff up. I was pulling up chat in a separate screen. I needed both screens.
The second file on this flash drive, labeled jail call enhancement for assessment. You recognize that to be the jail call at issue?
If this, I believe we sent this to Keith McElvain to see if he could enhance the open portion, yes.
And then the second.
So do you recognize this? Yes, we sent to see if we could enhance the open line portion because it does sound like the phone is like being held or is down. The phone's clearly away from the speaker's mouth and there's background conversation going on while the line is open to the jail call. So that is why they tried to enhance it. For all of you asking, is Koberger in June? No, Dave Matthews is in June. Dave Matthews is in June. Koberger's in August. But also we've got April, May, and then June. I might have to do Donna on a bit delay when I travel a little bit, but we'll figure it out together. This trial will probably not be groundbreaking because this trial's happened. A lot of these witnesses have testified 4, 5+ times. So we'll get there.
Call.
I forgot to grab my cardigan. Now I'm cold.
One identified.
So if you hear my heater, I
Monday.
apologize.
Number 547. 6:38
I don't think they'll play much of the audio today.
November
We'll link-
8th of 2023.
We'll link me covering it down below.
Yes,
It's hard to hear. They'll play it in trial.
You got a chance to review that call as well.
that one I did review.
Why is my heater fighting with me? I love this.
I'd like to start with the open line call, which is call 562. Would you agree? Thank you. Would you agree that that
All
call,
the things today.
according to this report, Exhibit 1, is 26.12 minutes in length?
Yes.
I'd like to play. Your Honor, I'd move into evidence.
play it.
Call number 562 as defense 2.
Any objection?
No, sir.
I'd like to just play approximately approximately 8 minutes of that call. May I publish?
You may.
Play the call. Play the call.
Hello, this is a prepaid collect call from an incarcerated individual at the Leon County Jail. This call is not private. It will be recorded and may be monitored.
This call will be recorded. I'm going to try to turn this up a little bit during this portion. This call will be recorded.
If you believe this should be a private call, please hang up and follow facility instructions to register
If you believe this should be private, hang up and use the attorney call line.
this number as a private number. To accept charges and consent to this recording, press 1. To respect these releasing security. You may start the conversation now.
Investigator Newlin, that recording that was just, the recorded voice that was just heard, is that the recording that you referred to earlier in your testimony?
The notification to both parties
Yes.
that you're being recorded, yes.
I heard what you said as the chief, and then it just went
He was supposed to the same guy who said he was going to call Dan back for a copy or whoever called him back. But Chief's back, and he's the chief of the whole jail. Just come by and check me out. So what's that? He has not been there yet. He has not, but the psychologist, PhD, whatever. Yeah.
Donna is on the recorded jail call talking to Charlie Adelson right after he is convicted. So he's talking about having the psychiatrist come check him out because they are probably trying to determine after the conviction if he needs a watch. That doesn't surprise me. So this is the audio of the jail call. It's harder to hear because they are playing it in open court, not over a PA system. Again, I will link below the video where I cover this audio, and we will continue with it, but we've got closed captioning, so we'll get close.
She came by, and I took her phone, and I was walking her boat, like, so I was looking outside the window, you know, into town into the hot, and it's like, you're sitting at like a box, one, yeah, the thing I sat on, I had before, but I could look out the window into the hot, here, it's like a box, yeah.
He's saying that he used to be able to look out a window from his cell to the pod, and now he's in like a box, and he is not happy with his accommodations and the fact that he's going to be transferred to prison from local custody.
So like, you can't see, there's a mirror, they can see in and you can't see out.
That was user error. I'm sorry, chat. That was just awful. That was me. That was so bad. I was just trying to pause it. So he's talking about the watch pod that he's on because there's like a one-way mirror and they can see him and he can't see them. After a conviction, I think almost everyone is put on a watch for a period of time because after a conviction is when shit gets real. And so they put people on a watch, and he will be in a room where he doesn't have the ability to like break a toilet off a wall and harm himself. So, all right, let's continue.
I don't have a private line. So they mean you're himself dead.
All right, I'm going to try to catch us back up to the call. We weren't that far into it.
All
right.
Charlie is no longer on the call. Correct?
All right, this is after the call drops.
All right, it sounds like if it's not today.
That's her talking on the call. Back up a little bit more.
File.
That's too far, Emily.
An incarcerated individual at
It's just that I was waiting for that. And
Close enough.
I figured the chief. Yeah, they came from 104, and then, you know, all the Navy, all. I got 33% off of my phone. 40 in the afternoon. It's okay, we're 15%. So you switch the little battery and take her on, and then I probably get that. it's like, you just isolate them. You see it, yeah, over of course, yeah, and that's all. It's like, if you do it, it's the opposite of what I would be at home. Right, in the situation. I know. Sorry, it sounds like if it's not today, they'll do it tomorrow, but hopefully today. But then you're the rest. And I just like, it's bad enough all this happens now, like, take it out and what was around and all. I know that this is, sort of like a solitary. I mean, I get why to do it, but this is like.
When he's saying it's sort of like solitary, again, he's talking about the watch after being convicted.
The company is a day, like a plastic box. I go over my mattress upstairs and go down here, and my bed sitting in a box. It's like a 3 feet by 6 foot box for all around the center of the room. Where I used to walk back and forth, middle. I just like walk up and then around the bed and back. But kind of the same story, like I tried on the phone before, not till 6:30 that phone.
The beeping is also part of the jail call, so that beeping is also on the call.
Yeah. And I'm like, just checking in. Okay, just checking in with me. Okay. I thought there. Yeah.
Even the closed captions are like, we don't fucking know. We don't fucking know. So again, I have a podcast link that we will link where I cover some of this jail call. It's going to be difficult to hear. We're going to just keep going through it. For those of you commenting on defendant's breathing, it's something she's been complaining about in motions. So I don't know if that is a medical condition, if that is anxiety, if that is feigned, but it's part of her motion for bail that she's had persistent difficult breathing, and that's part of the reason she should be bailed out. So in court is the day for it. That's a bit different than what we saw the last hearing on her Zoom call. It was noticeable on the Zoom call that her breathing was quiet, not loud. It didn't look aggravated. So it could be medical. It could be stress. It could be whatever. But yes, it is something she's complained about in her other motions. So she does have a bond motion. It would benefit her if the court can see that she has a medical situation when she's in court. And it also might just be the situation.
It's like, they work hard. It's going down happy. I thought he had left. Thank you unless you're there. I get to write up. So whatever it is, if they open up an inquiry, they ask the judge. Okay, the investigation came up. He said that's maybe the kind of thing. 9 months from now, the juror writes something stupid. Wow, and they investigate and they find out, like,
She also looks
and then they
stressed.
find out something, and then you open it, and then it gets possibly lead to an appeal. I think what he got, the judge let a lot of stuff in to the case. And he did.
He's saying the judge let a lot of stuff in. He's now talking about the evidence coming in at trial and his thoughts about the evidence coming in at trial. All I caught from that last sentence was appeal. How awkward is it sitting in court with the same judge? Because yes, that is the same judge as in Charlie's trial. While he's on the jail call talking about the judge letting a bunch of stuff in, while the judge is sitting there looking at you. She's having this conversation about the judge, who's now the judge in her case, while he is dead ass sitting in the courtroom listening to this call. Sitting there just like, he said what now? However, judges know. Judges know. They know that people are going to talk about them like that. They know it. But still, you never, It blows my mind still that people think that these calls will never be heard. I've listened in my career, I listened to so many jail calls, and everybody's out here like, they're not going to listen. Yeah, they are. Yeah, they are. Especially if you have a DA that's nosy. And most of us that are good are. We're curious. We want the chisme just as much as everybody else. I want to know what's on your jail calls. I want to know how many people you're telling are the only one you're talking to. I want to know.
Like a guy, Hank, Anderson or whatever. It gets harder to judge rules on the issues that are in the trial. The more likely there's down the television. Here the judge is in favor of the defendant. The more likely there's down the television. Yeah. You see what I'm saying? Yeah, I do.
You get what I'm saying?
So, my general feeling, this is just my feeling, I'm not a lawyer, but my feeling is that he ruled, if anything, he gave the other the benefit of the doubt because he didn't want to be the television. Yeah. So that was the argument. Well, I mean, he made that comment to me that the judge ruled in our favor a number of times. He let us bring stuff in. Either said it or I heard it, that he meant it that there's not going to be, what things to say that we're not all. I mean, you have to either say that the judge did something.
When Donna was on this call, Charlie had just been convicted. She, in my opinion, based on everything I've seen in this case, was getting ready to run and was getting things wrapped up so she could run, getting money wrapped up, estate, stuff like that so she could run. And I think she thought confidently that she could, that she had enough money, that they weren't going to come get her yet because they hadn't come and gotten her yet, that when they didn't arrest her, when they arrested Charlie, that she was probably going to be able to get out of the country and not get got. And so I wonder what it's like for her to sit in court listening to the call that she thought was going to be one of the calls before she ran. And she's sitting there being like, this is my speculation. Well, fuck, that didn't go how I thought it was going to go. Right. Because they're listening. And this call where she's talking about fleeing precipitated her being arrested. They knew she was flying because they heard on the call and then they were able to check. So yes, everybody asking, this call was before she got arrested at Miami International, after her son was convicted. There was a gap in time and she thought she was going to get out. And we watched the arrest video together with a little bit of Schadenfreude, but we watched the arrest video together at Miami International. She is at the gate getting ready to get onto the jetway when she gets arrested. She is standing at the jetway, ready to leave, like feet in front of the jet. You can see the jetway in the body cam arrest video. So she thought she was out. And then she was like, what is this about? Ma'am. You know what it's about.
You're due process. You're going to do anything improper. Things not right. But there's a reason for wanting to trial. If there was an appeal, would it have to be in Tallahassee? If you move it. I don't understand why they wouldn't let you move things.
I don't understand.
It's blatantly, I mean, look, I have, I didn't say this to you before I picked up the phone, but there's a lot of things that we have to do, and we've got a very tight time frame. So one of them involves taking care of some things for Roman, taking care of some things through Steinberg. I've been on the phone all day, and Susan.
It is hard to hear you guys.
She's going to gather everything up and I'm going to drive down. So she and Rick got here about, 10 minutes before you called, so that she could work with us. We've got a couple of hours of stuff to take care of for Roman. So, working on that, and
Well, that was a sigh.
You're going to be okay. You're going to get out of that stupid room. Once you do, you'll start to feel a little bit better. I know that. And
she said once you're out of that stupid room, you'll feel a little bit better. She's talking about the solitary room where he's being observed. She's now in solitary because she was attacked in custody. So she's also now in solitary. So this is probably hitting different for her sitting in court.
Tell you, I'll speak again. Okay? So, and then I'll let you know what time to call him. Can you hear me, George? Shit. You can't hear me again, right?
Prosecutor Newlin, at that point, according to recording, Mrs. Adelson realized that Charlie Adelson is no longer on.
All right, we're going to get to Charlie Adelson no longer being on the phone. For those of you asking about the timing, November 6, 2023 is when Charlie Adelson was convicted. He was sentenced in December. She was arrested right around November 15th, 2023 and indicted November 15th, 2023. So it was right in that less than 10-day window between Charlie getting convicted and her getting indicted and arrested in 2023. She's been in custody since November 2023. She was supposed to go to trial in September of 2024, and then it got bumped because of the attorney issue. Which
Correct. That's
was
what it appears.
basically her fault. in my
Now,
opinion.
referring back to defense one, that was call 562.
See, I think they should play the moment that the call gets disconnected so everyone can hear that the call is still beeping. Just me.
At 15:07 or 3:07 and 7 seconds, does Charlie Adelson attempt to call his mother back in call number 561?
He does.
And then at 15:08, 3:08 and 51 seconds, does Charlie Adelson attempt to call his mom again in call number 560?
He does.
So Charlie's trying to call her back, and it seems that she still has the line open. So Jennifer K in the chat asked, do they need a conviction of Donna in order to get Wendy? I don't know if they have enough to prove that Wendy knew or had conversations. Remember, there were undercover officers involved in this. There were other recorded conversations involved in this. There was direct communication between Donna and the middleman who had either been dating Charlie or worked at his dental office or both. And so there were direct ties. I think it's harder when you have less direct ties in a conspiracy to commit murder and solicitation of murder case, because there is room where you cannot prove the conspiracy and agreement. So I don't know that there is enough to bring Wendy in. I think that's why she got the immunity for testimony, in case she said anything that might indicate she had direct communication. But I don't think they're going to be able to get to Wendy. And I have really mixed feelings about that, because if they also arrest Wendy, and I don't know what Wendy knew. I don't follow this case closely enough to know. But if they also go after Wendy, the kids involved in all of this lose their father to murder. Their uncle and grandmother have been convicted and are being tried for the murder of their father. And then they also lose their mother. And it seems that the Adelson family is also keeping them away from their paternal side of the family. So they don't have a paternal side of the family that they are well connected with. And so it's not a case where I really want to see them stretch that far if it's not clear. because the kids in all of this are, it's heartbreaking. And so I don't know. I don't know if that's the better result at this point, because in all of these cases, and I've seen too many family law cases go bad. Family law is incredibly dangerous. People do not act like themselves. And murder is never the answer. But there are too many cases where people decide that that's the answer. And it's heartbreaking. The Corey Richins case is same. It's heartbreaking. And it's always the kids that suffer. It's like, we're doing it for the kids. No, you're fucking not. You're doing it for you because you have no emotional regulation. You're not doing it for your kids. If you're doing it for your kids, you're going to figure out a way to work through it even when it fucking sucks. So the whole thing pisses me off. Emily, you've got strong feelings about this one. Yep, sure do. I'm feisty about this one. Feisty about this one. It makes me so mad. Just, we're going to keep listening to these calls.
And then at 15:13 or 3:13 and 25 seconds, does Charlie Adelson attempt to call his mother the fourth time in call number 559?
So Charlie's trying to call and call and call and call.
And then at 15:13, 3:13 and 51 seconds, does Charlie Adelson attempt to call his mother
This case makes me
fifth
spicy.
time in call number 558?
He does.
And then again, at 15:22 or 3:22 and 33 seconds, does Charlie Adelson attempt for us to call his mother back in call number 557?
He does.
Were calls number 557, 558, 559, 560, or 561 successful?
They were not.
And why is that?
I do not know.
Is that because his PIN was already in use?
I don't know the answer.
So he's asking about why those calls didn't go through. I have an answer. It's pure speculation. Could I testify to it on the stand as personal knowledge? No. Here's my speculation. The calls didn't go through well because the line was still open on Donna's phone. So.
To you that Charlie Adelson had been disconnected by 15:07 and 7 seconds, or 3:07 and 7 seconds.
Yes.
Now, call number 547.
Donna might not have realized a call was coming in,
Defense 1.
or it might not have popped up on her phone. I don't know. But she really may have taken her phone when Charlie disconnected and put her iPhone down and just put it down and not realize that she didn't push the button. Would I love to say that my parents would never do that? Yeah, I'd love to say that. Is that accurate? No. My dad's almost 80. There's times I get emergency alerts and I'm like, Dad, what are you doing? He's like, oh, I had my thumb on the thing. I'm like, of course you did. Of course you did. So do I believe that it is entirely within the realm of possibility that Donna thought she hung up the phone by putting it down? Yeah, I do. Totally do.
That call was made at 6:38 in the morning?
Yes, it is.
And you indicated earlier in your testimony that you listened to that call recently.
I skimmed through the initial 60 plus minutes to the portion where we had a situation as the call we just listened to.
So, Your Honor, I'd like to introduce Defense Exhibit 3 and publish. And I'm only going to publish very briefly.
Any objection from the state?
Yes, sir.
Defense 3 is admitted.
Thank you, Your Honor.
Hello, this is a prepaid collect call from an incarcerated individual at the Leon County Jail. This call is not private. It will be recorded and may be monitored.
This call is not private. It is being recorded and monitored. Florida's going to tell you every which way. California didn't used to. They might now. It just would say this call is being recorded. This call is not private. It is being recorded and monitored.
If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept charges and consent to this recorded call, press 1. To thank you for using.
To accept charges and consent to this recorded call. Ma'am, a lot of you in the chat are asking, does it matter that the conversation was after she thought the call was dropped? That is the defense's entire argument. She thought the line hung up. And so they're saying after she thinks the line hangs up, then she thinks she's just in her home without the open line. But the law is not really going to err on the side of her mistake, because then it can be gamified, right? Can you see a circumstance where somebody's like, no, I thought that it had dropped. No, I thought we had hung up. That's on you. You have the control. You have the phone in your hand and you can click end. So that's not on the state. They didn't overstep. Her mistake does not equal government overreach on a search and seizure. So that's going to be her argument. I just don't think it's going to be an effective argument. But yes, you guys, that's going to be her argument. All of you have issue spotted very well today. Good job, law nerds. Good law nerds. Well done. Very wise. Hydrated. Smart.
Again, in defense 3, did we just hear that recording saying that it was going to be a recorded call?
Yes.
Okay, one more question. Emily, stop pausing. Elisa Southern asked a great question in the chat and said, wasn't there a lawyer there? Can't they claim privilege even if it's not their family attorney, as it could be considered a consult? No, but I like where your head's at. I like that you guys are like, where does this fit in? Here's why. It's not a private conversation. There are like 4 people in the room. So an attorney-client conversation with a third party in the room is still not privileged because there's a third party in the room. Unless somehow the lawyer represents everyone in the room, which was not the situation here. So no, they can't claim privilege. And I like the thought. I love the question, but no. It's just like if you have a conversation with a lawyer and then tell your bestie, oh my God, my lawyer said this, it can violate privilege. Like your bestie would never dime you out, but it could violate privilege. So whenever I see people saying, oh, my lawyer told me, I don't mind my lawyer advised me not to talk about the case. That is a rote response. But anything getting into specifically, once you start sharing it, if you start texting, my lawyer said this, my lawyer said that, it starts violating privilege because now you've shared it with a third party. Unless you have spousal privilege. Spousal privilege can be a situation. So that's different. Spousal privilege varies by state. I wouldn't count on that one either, unless you've had an attorney consult about it.
I'm going to fast forward and I'll start this at 57 minutes and 13 seconds.
Look, here's the reality. Most people aren't good at crime. I see all of you in the chat talking about it. A lot of people aren't good at crime. The people who are really good at crime often don't get caught until they get greedy. Good fraudsters often don't get caught until way down the line because they get greedy and they get lazy and they get complacent. They're like, nobody's going to catch me. No. They get caught in their own rhodomontade, don't they? But most people are not good at criming. It's just the reality of the situation. It really is. So don't crime. Don't crime. The people who are good at criming, Emily, don't help people crime better. There are people that are better at criming than others. Normally, like most things, they have taken an apprenticeship track and don't learn that shit on their own. There's like an apprenticeship track and they learn. So it's a whole different thing. Donna has had everything, it seems, go her way. And she entered a world she doesn't know much about.
What else can we have done? Anything else that we could have done that we didn't do? And now we had the best. So we had the jury, so we had the best. And we had Tallahassee.
Oh, is this the call where she talks about how much she fucking hates Tallahassee? I think it might be. This, if you live in Tallahassee, I don't know if you'll be offended, but she does not think much of Tallahassee. I think that's this call where she is clearly upset and is very devastated about everything. Scorpion, I'm going to hold your question. It's really good. I'm going to try to get through some of the calls, or we're never going to get done. She's crying in this call.
So at that point in time, approximately 58 minutes, a little bit past that, do we hear Donna realize that Charlie's no longer on the call?
It appears, yes.
She's in this part of the call, she's like kind of just going on and on and on with her emotions, and then realizes that Charlie's not still there. But she is on and on and on about it, just talking unobstructed. I wondered if Charlie meant to hang up, or if he was like, if I just put the phone down, I can just let her go and also distance myself from it. I have so many questions about the nature of this relationship after everything that went down with the lawyers. I have so many questions. She also doesn't want to be in Tallahassee at all. Oh, my coffee's now cold. I mean, I can imagine. Charlie's like, I just got convicted. Why are you crying at me about your flight to Vietnam? Stop.
I can't, so I'm supposed to hold Dad, but that's right.
What we're listening to now, Investigator Newlin, is approximately an hour, 2 minutes, and 50 seconds is when that portion of the recording started. At this point, we're at 55 seconds.
I don't have a private line.
Tori, I had myself eating my coffee.
Or they're going to hear me tell it. They might as well hear you. I mean, what's the option? Or are they cutting him? No. No, not necessarily. But I hope that there's business friends that possible to be close to run about and involved.
I think I got the wrong timestamp there. Just give me a moment.
I know, I left my Amber mug on my desk. I have it. Xena Warrior said, I thought there was a time limit for calls. These calls were collect. So you're not going to have you've got 3 minutes left. They didn't have to put money in advance. So these are collect calls so they can stay open. Tara, if they give her bond, she'd have to stay in Tallahassee. I'm going to keep answering over the blank portions of this because I'm afraid to fast forward because then we're going to lose stuff.
That we wanted to him to, we'll talk about in more detail later. So our focus first, you need to come here, but I realize that most of everything we can do.
Lauren asked in the chat, how is this still being recorded by the jail if it dropped on Charlie's end? We don't exactly know if it dropped on Charlie's end. It says Charlie's no longer there. Charlie could have put the phone down and walked away. If it's an iPad, he could have left it on and walked away. Charlie's no longer on the other end, but the phone call doesn't terminate. And the witness on the stand, who is from the state's attorney's office, said, look, normally the calls disconnect when both ends disconnect. So the connection stayed open for whatever reason, because we don't know what Charlie did on the other end. Charlie might have just put the iPad down and put it on mute and walked off. We just don't know. He's no longer responding, but the line is still open. And then she's got other people at the house that she's talking to. I suspect, and this is purely my speculation based on listening to this call and seeing what was going on here, is that they were wrapping up, and she talks in this call, not in the portion they played, but she talks in this call about getting money taken care of and getting things moved around. They are trying to wind up their lives well enough so they can bounce out of the country and not come back. That's what it seems like to me. So there are people at the house, it seems, helping her do that. So there are multiple people she's talking to, her husband and then friends.
I'll have to tell them. We'll be in the country. They're not recording my phone. If they are,
Charlie tried to call back,
They're not
but I don't
recording
know if
my
he
phone, that's what she
disconnected
just said on the
or was
recording,
trying to call
correct?
back on a different
Followed by something
device.
if they are, something.
Hey, Joe, there's a lot of
As with the
there's a lot of iPads at this point in custody for communications, texting, email, and all kinds of things. So that is a very common way. They're not all just bays of like payphones like they used to be, because especially since 2020, a lot of in custody inmates appeared in court via like iPad call. So iPads got rolled out pretty regularly. CW said, how often did you hear calls like this? Where somebody was planning to flee? Not very often. Where people were being nasty? More often. Where somebody was playing everybody who would put money on their books? Often. Where people were talking shit about me? On occasion. But where somebody was planning to flee? No, that not often. Not often.
calls on November 7th, after disconnected at about 58 minutes into that call, did he attempt to call back in call number 546 at 7:38 in the morning?
I gotta catch up with you here. So that call was the call on November 8th.
Correct. So we were talking about call 547. That's the one that was just
Right.
introduced.
Okay, so at 6:38, that call was made.
So 546 did,
Yes.
and that would be on July 8th,
November 8th.
I'm sorry, November 8th, 2023 at 7:38 in the morning.
Yes.
And did that call connect?
Does not appear.
Call number 545, November 8th, 23 at 7:40 in the morning. That call connect.
Does not appear to.
And these are call number 546, 545, 544. Those are from Charlie to his mother.
So it looks like
Correct.
Charlie is trying to call back
Call
in whatever
number
way he's doing that.
543, November 8th, 2023 at 7:44 in the morning. Did that call connect?
So 3 is, there was 7:44, 7:45. Neither one of those connected.
Okay, so 544, 543, those did not connect.
They did not.
And those were from Charlie to his mother.
Yes.
And then call number 542 at 7:52 in the morning.
Did not connect.
Call number 541 at 7:54 in the morning.
Did not connect.
Now I want to take a step back.
Counsel. These motions to suppress sometimes, I'm sitting here like, why is nobody ready? You know the questions you need to ask. You know you need to ask about the calls.
Call that Charlie Adelson made was to his mother's cell phone,
My
correct?
tolerance for long pauses has gone way down. It's just,
That is-
it's me. It's probably the background noise that my brain's trying to buffer out to.
Yes, that's what it appears to be.
Okay. And you've been on your cell phone when a call drops, correct?
Yes.
Okay. Now, there could be a number of reasons for that, right?
Yes.
It could be because of tower issues.
Sir, is he a cell phone expert? What are we doing? Sir, you've been on your personal cell phone when it drops. Do you know exactly why a call drops? No, I don't know. There was a time I had to call my cell phone provider and be like, why are my damn calls dropping? They're like, oh, it looks like we don't have the bands connected to your new phone properly. I'm like, what? What? Because all of a sudden my phone started dropping in a place when I drove that it never dropped before. Because there's like only 2 different routes to get to Starbucks. And I was always dropping my call while I was talking to Judge Abby in the morning on our way to Starbucks, which is what we do. So there's a million reasons a phone can drop. And sometimes you're sitting on the other end being like, hello? Hello? Hello?
Because of
I'm not a
battery
cell
issues?
phone expert. I don't fucking know.
It could be numerous issues, yes.
Or it could be that the person on the other end just hangs up.
Could be.
Those are termination of those calls, correct?
For one end of it, at least.
Hanging up is not nearly as satisfying now that you don't have the phone to like
To you,
sling down. It's incredibly satisfying. Be dramatic about
Does
it.
the call continue or is it just a stop?
A little too technical for me, to be honest.
Not an
Well,
expert.
You've been on the phone and realize that somebody's not there. You look at your phone, it says call failed,
Yes.
Not always.
or there's just nothing on your screen.
Usually when the call,
I'm not a tech expert, but when somebody drops on the other end, I've never seen call failed on my end. I'm just sitting there going, hello? Hello? When it drops on my end, sometimes I'll see call failed, but not when the other end drops.
call fails, you get a beep beep and it's done.
But that's if it fails on your end, correct?
Oh, thank you, counsel.
Yes.
Good job.
So you've been on the phone, on your cell phone, talking with somebody. You didn't realize that they got disconnected. You're still talking, right?
Yes.
Just a moment, Your Honor.
Oh my God. You guys are right. After how organized Alessi was yesterday, the man didn't leave a breath of space. Also, Alessi argues like an appellate attorney. It's a whole different level of prep. It's different. It's different than this. This pace is very slow. And if the sound wasn't so bad, I'd speed it up. But the sound is so bad, if we speed it up, we're not going to understand anything.
Calls 561, 560, 559, 558, 557, as well as calls 546, 545, 544, 543, 542, and 541. Those don't connect with Donna Adelson because Securus is still recording, correct?
That's too technical for me. I don't know why they don't connect.
Is Securus still recording?
It is, yes.
Nothing further, Your Honor.
He's not a tech expert. He's like, I pulled the report. This is the law enforcement officer. I'm sorry for this pause. Sorry.
Cross-examination.
This is the law enforcement officer that pulled the report on the jail calls. I don't know. This is what the report says. There was this call. It lasted this amount of time. Then there were these other calls that didn't connect. That's all I've got.
So,
Is there anything else? I've got emails to answer.
when a call is
This is now the state doing cross-examination. The defense bears the burden on their motion to suppress. So the state is cross-examining.
made from Leon County Jail to a person receiving that call, both parties are alerted that that call is being recorded before that the person receiving the call can accept the call and talk to the inmate. Is that right?
That's correct.
Okay. And it also lets the receiver of that call know that they need to hang up in order to not be recorded, right?
Correct.
Are there hundreds of calls between Charlie Adelson and Donna Adelson while Charlie Adelson was in custody at Leon County Jail?
I would say there's thousands.
I know that
Thousands
you
of
haven't heard
calls.
all of the thousands, but in most of the calls that you've heard, besides the two we've heard today, does Donna Adelson properly hang up the phone at the end of the call?
Yes, the ones that ended properly, yes.
Okay. And the defense showed you while Donna Adelson was still on the line.
Not wild Donna Adelson, while Donna Adelson was still on the line.
her and Charlie's previous call on these open line calls, that there appear to be several attempts by Charlie Adelson to try to call her back.
Correct.
Valkyrie Art said thousands of calls. Who calls somebody that much? A, I'm not surprised in this case. B, I imagine Sarah Boone also has thousands of calls. I also want to know if Sarah Boone and Donna Adelson ever end up housed together. I'm just curious. It could happen.
Her phone is still on the previous call, and
So
she's not looking at her phone. Could it be that she doesn't see that the Leon County Jail is calling her, is attempting to call her back, like she doesn't see her call waiting because she's not looking at her phone?
That's a possibility.
And in one of the recordings the defense plays, she says she seems to be not sure that they're recording her. She says, they're not recording my phone. If they are, and then it was cut off.
I think that's different. On the call, Donna Adelson says they're not recording my phone. I think Donna is talking about whether or not her cell phone is being tapped, not the jail call, because at this point, there had been ongoing investigation. They had seen that there were undercover recordings from Charlie's trial. So I think Donna felt confident that her cell phone wasn't being wiretapped. And it seems that her cell phone was not being wiretapped at this point. I don't think she was talking about the jail call in that, but that's my thoughts on it.
No, there's more to that conversation.
Right.
Okay.
We didn't hear.
In that part that we heard, does she seem to be unsure whether her phone can be recorded or not? When she says they're not recording on my phone, if they are.
Yeah, I'm not following the question here.
Okay.
I would object to calls for speculation.
I think it's talking about wiretapping.
Clarify your question before an objection or answer is given.
Let me just ask then, the portion that you were played by defense counsel, in that portion, did Donna Adelson say, they're not recording my phone if they are?
Yes.
Okay. On the open line call, that the first one that the defense moved in, that where Donna Adelson talks about fleeing to a non-extraditable country, and information in this case from November 7th. If Donna Adelson had properly hung up, would the recording have stopped?
Yes.
And we would
there
not
it
be
is.
able to then hear the conversation that occurred in her home.
No.
Did law enforcement, or did law enforcement do anything to keep her from hanging up?
No.
And when I say law enforcement, I mean the state.
No.
So the point of those questions...
Have you ever had a call?
And again, this audio. The point of the questions were, did law enforcement actively do anything? No. Donna didn't hang up the phone. The line kept recording. She was having conversations in the background. This was on November 7th. She gets arrested at the airport and indicted. What did I say earlier? Let me pull it back up. On November 15th. So this is right after Charlie is convicted and she's having all those conversations. So they didn't take any affirmative steps to tap her phone. They just grabbed what the system automatically recorded, and it automatically recorded because she failed to hang up. So that's the argument against this motion to suppress.
With a friend, where all of a sudden you can't hear the person, and they no longer are able to hear you.
Yes.
And the call has still been pending there on your phone. It wasn't call failed.
Yes.
Would you then need to hang up the phone to ensure that the person on the other end wasn't just hearing your conversations as you went about your day?
Yes.
Thank you.
Before we move into redirect, Mr. Zellman, I do have a question. I'll allow both parties to follow up. Just to get a new one, based on the records that you have in front of you, are there any instances or do you have any knowledge of there being disconnected calls prior to November 7th of 2023?
Not at this moment. I would have to go back and look.
Both parties may follow up as the court's question if you desire to do so.
I love this judge so much.
Briefly.
He's just so easy.
So, as you sit here today, you're not aware of any other similar situations happening in the thousands of calls.
Not in the ones that I've listened to, no.
But you could pull a report that may or may not show.
Oh, his sleeves and jacket situation's going to bug me. I don't know if you can pull a report to show when Charlie's phone disconnected, if it kept recording, if you don't listen to it. I don't know how they would know that the call recording was longer than maybe what was tracked. I don't know if you could see that.
Call consistent with what we presented here this morning.
Yes, I can go pull a report. Yes,
And if that's what the court is asking, you could do that.
I can.
Okay.
I mean, you could see the calls that disconnect.
Now, when an individual such as Charlie, an inmate makes that call, makes a call,
We're on redirect
he's
now.
using his PIN as we established earlier, correct?
Yes, he's using his PIN when he makes a call, yes.
Now, I'm going to show you, are you familiar with the Next Gen Secure Communications Platform?
Next Gen Secure. I
So
guess
when-
not.
He's like,
When
what?
you download the calls and it goes into a folder on a drive or your computer, you have to click on the Show CD icon, and that pulls up a web browser, correct?
So you're talking about when I extract a
Yes.
set of calls, it gives us an email, it gives us a download, and the download has 3 or 4 folders in it.
Yes.
And those folders contain all kinds of stuff, so yes.
Your Honor, may I approach?
You may.
This is not marked.
We all now want to know if there's metadata attached to the calls.
You familiar with
They
that?
normally come in a pretty thorough report with
I've actually never looked at this.
dates, times, and a bunch of numbers.
Now, earlier we talked about call numbers 547, 546, 544, et cetera, et cetera. I'm going to show you call number 562 on this document. Take a look at defense 1. Is the information consistent with what is on defense 1?
This one indicates call part. So there's a little bit more details in here.
So
And
it's call number 561, 560, 559, did that indicate account in use?
He's trying
does.
to orient himself to the report in the format that he hasn't seen.
Now, during the portion of Defense Exhibit 2 that we listened to, prior to Mrs. Adelson realizing that Charlie is no longer on the call, is there any discussion about the phrase non-extraditable country?
In the 11.7 or the 11.8 call?
11-7.
Oh, I'd have to go back and listen to it
They
again.
should have
I
a
know it was
transcript of the
talking
call.
about getting out of the country and stuff like that, but
They should have a transcript of the call. They should just have a transcript of the call and then give the transcript of the call to the judge and then res ipsa loquitur. Like the transcript just speaks for itself. Here's the transcript. Control F. But she was talking about getting out of the country. Is that different than non-extraditable country? Maybe.
I'd have to go listen to it again.
At any point in any of those calls, and this is probably more relevant for the bond, does Mrs. Adelson indicate she's not returning? Does she say she's not coming back?
No, but the 11.8 call, she did say that she's going to have to tell Wendy we are leaving the country. There was no indication of coming back from that.
Just a moment.
The one-way ticket
Nothing
also is
further, Your Honor?
a strong
You
indication.
may step down.
And the getting trusts and
To accommodate Mr. Toomey, we will take the one witness as to the Arthur aspect of this at this point.
damn. Everything just glitched.
Mike Hayden.
There we go.
to invoke the rule for any witnesses that are here for the bond hearing.
That's fine. Please step outside and do not discuss your testimony with any other party if you are here for the bond portion of the hearings today. Please raise your right hand.
They are calling a witness out of order. There are 2 hearings on docket today. There is a bond hearing, also called the Arthur hearing, and the motion to suppress hearing. So they are taking a witness out of order, and the out of order witness is going to just the bond portion of the hearing. So then they did a motion to exclude or a sequestration and asked any other witnesses there for the bond hearing to leave. So that's what's going on. So now we're taking this witness out of order to handle part of the bond hearing, and we'll see who it is and what they have to say.
Do you swear or affirm the
We're all gonna
testimony
find
you're
out
about
together.
to give will be the truth? You may take your seat. Please speak loudly and clearly, Mr. Hayden. You may examine Ms. Dugan when you're ready.
State your name and spell it for the record, please.
Yes, Mike Hayden.
This is also why the prosecutor is now asking the question. So this is a prosecution witness for the bond hearing. So a witness for the state on the bond hearing, Mike Hayden. Out of order.
Mikehayden.
And where do you work?
I work for Yes Care at the Leon County Detention Facility.
Can you say that one more time?
Oh, at the Leon County Detention Facility.
Okay, and what do you do there?
I'm the health service administrator
How long have you been health service administrator there?
since January of 24.
Can you tell me a little bit about your education, your training, and experience for your position?
So I'm a registered nurse. Corrections. I've had 5 years of experience in healthcare administration. So starting progressively from director of nursing. So
Remember, sorry, sir, for the pause. One of Donna's complaints is that she cannot get adequate health care within the detention facility, and therefore she needs to be allowed out, or at a minimum, allow private practitioners or doctors to come in to treat her. One of the things is that she has very small ear canals, and they are not flushing her ears properly. So she is having a hard time hearing her lawyers when they are on like Zoom calls. The answer to that is your lawyers can go to the jail. Like your lawyers can go to the jail. I imagine her lawyers are probably not local to Tallahassee, and that's part of the problem. So this is the healthcare administrator who I imagine is going to testify, and this is speculative because we haven't watched this yet, that Donna can get the healthcare that she needs within custody, but there's a process for it. So,
administrator. I'm currently a travel health service administrator for the company.
Okay. What type of medical treatment can be provided at Leon County Jail?
So we are basic life-saving, so we are limited to advanced life-saving, but anywhere from wound care, chronic care medications to emergency management.
Are there people in...
Sorry, I'm having a hard time hearing.
I apologize.
Mr. Chairman, I'm just going to
All
mute
of
you
us.
for now if you need to get involved in some way.
So he said they are a BLS facility. Most jails also have a contract with local hospitals. We heard this a lot with Dr. Russell in the Karen Reed case, where Dr. Russell was talking about working at Men's Central Jail in Los Angeles, or working with Men's Central Jail in Los Angeles and working with everyone who is transported to County USC, the level 1 trauma center facility. When I did search warrant duty, we often had search warrants where people had to be transported out of custody into the hospital setting to retrieve things that they had hidden within themselves. And that was not an uncommon type of search warrant, but you can't just go searching for things that people might have internally pocketed without a search warrant. So they would get transported to the hospital. So most custody facilities, and again, prisons are different. This is local custody. Most custody facilities have contracts with hospitals to transport people out for medical care that can't be given in the medical facility. BLS, not Bureau of Labor Statistics, basic life saving. Basic life saving. So they can, give medication and patch up wounds and do CPR, but then they take people out to the hospital for other stuff. And they can do that.
Or make an objection of some sort. At that point, you may unmute. Please continue, Ms. Dugan.
Are there people with very serious medical conditions in Leon County Jail or who have been in Leon County Jail, even as serious as cancer? Okay. And the medical staff, does Leon County Jail have up there on site?
So we have dental assistants, we have dentists, LPNs, CNAs, RNs, we have mental health professionals, psychiatrists, mid-level, so a nurse practitioner and a doctor, medical doctor.
Is there a nurse on site 24/7?
Yes.
The doctor
Right, there's someone on
and
site
the
24/7.
ARNP, those would be the folks that can prescribe medications or refer a person to a specialist. What are their hours there?
So they're Monday through Friday.
Okay, like a normal business hours,
Normal
8 to
business
5?
hours.
Are they on call though, other than those hours?
Yes.
Okay, what about if an inmate's having a medical emergency? They're unconscious, heart attack, stroke, uncontrolled bleeding, what happens then?
So we refer to the outside emergency room. So we're basic life saving. So CPR, we can do CPR and things like that until EMS can arrive and take.
We call an ambulance.
Okay, but anyone can say this person needs to go to the hospital,
Yes.
not even if a doctor isn't there on site?
Correct.
Okay. Do inmates have like a call button in their room where they can alert COs if they are having a medical emergency?
In some of the cells in the medical unit, yes, they do.
Oh, really?
What about non-emergency requests? How does an inmate make a request for a non-emergency treatment?
So they have paper forms, and it's healthcare request forms, and they fill those out and they hand them to the nurse during med pass.
And the nurses are then the people who review those?
Yes.
If the nurse decides that an inmate needs to see the ARNP or a doctor, will they facilitate that?
Yes.
If the nurse decides the inmate needs to see a doctor, are the inmates then able to see the doctor, usually within a day or two?
Yes.
Okay. Even if it's on a Saturday, they might wait to see the doctor on Monday unless it's an emergency?
Correct.
Okay. I guess that's obviously depending on the nature of the request.
Yes.
Okay. In your experience, is that turnaround as far as I have this issue and I'd like to see a doctor, is that typically faster than people out of custody are able to get an appointment with their doctor?
Yes.
Does Leon County Jail provide treatment for elective procedures or things that an inmate would like to have treatment for?
So what we do is wall, and that will be a system of showing medical necessity. So if there's a request, if the patient requests anything, you will see the provider, they'll assess the need, and they push it up to our utilization management team. If there is a need, then they will facilitate.
I mean, if there's a need, it's
So
probably
medical
not
necessity.
elective.
Okay.
Right.
If Donna Adelson was seen by medical staff or is seen by medical staff for a medical necessity that they can treat, will they treat it?
Absolutely.
If it's not something that the medical staff at Leon County Jail can treat, will they get her care from a specialist for that necessity or take her to the hospital for that necessity?
Yes.
Have the medical staff evaluated her ailments listed in her motion to determine whether those are necessities or not?
Well, did he review the motion? I guess so.
And have you had an opportunity to review her medical records before court today?
I have.
Has medical staff observed through any of her appointments any hearing loss that was noted in the medical records?
Nothing noted in the medical records, no.
Have they noted any sort of medical necessity when it comes to having her needing to see a specialist for earwax removal several times a year?
No.
If for some reason that was deemed a necessity in the future, would they facilitate that?
Absolutely.
But at this point,
Well,
they
that's the
said
answer.
they don't notice any hearing loss.
Correct.
Well, it sounds like she didn't complain of it
After
to
Donna
them.
Adelson complained of shortness of breath, was a chest x-ray done?
Yes.
And did it show that her lungs were clear, so to speak, nothing abnormal,
Yes, it did.
a negative x-ray? Was she given
Were you going to answer, or did he just not?
like an inhaler treatment of albuterol, though, because of her complaints of shortness of breath?
Yes, so she's had available, they had ordered albuterol treatment since 2023, but recently she reported that she has kind of an exacerbation or a worsening of that. So the provider, when she listened to the lungs and none of her cleared, she did order a scheduled breathing treatment for a few days. I think it was 5 days total.
Okay, the breathing treatment being the albuterol medication
Yes, to
that you
help make
inhale?
open.
Okay, but they did do a chest x-ray to see if maybe something
addition.
more
You
was
only
at
need to
play
treat her for
here,
anxiety,
and nothing
is
was
my
there.
guess.
Yes, ma'am.
Okay.
And I know. I always tell y'all not to diagnose people, and here
Donna
I am.
Adelson complained of
Just
pain
all in my
her
hypocrisy,
left
but
shoulder arm area. Was an
imagine
x-ray
that's
done of that area as
some of the
well
issue.
to see whether there was any fractures, dislocations, some type of, something that she needed further treatment for.
Yes.
And was there any fracture or dislocation seen on the x-ray? Was that a no?
No.
Did medical staff give her some range of motion exercises she could do to possibly help with her pain in her shoulder?
Based on notes, I think
I mean, there could be a lot of shit wrong in your shoulder without it being dislocated or fractured. To be fair to the defendant here, your shoulder can have a whole bunch of stuff wrong, soft tissue wise. But again, her arm, in her motion, she said her arm was violently pulled behind her back. So her shoulder being broken might not be the issue, but it sounds like they didn't do an MRI to look at that. So it's, yeah, she's not going to feel good being in custody in her 70s. She's not going to feel good. But what they have said is that all of the medical complaints that she has really complained of are common and more likely age related. And she doesn't like being in solitary or in the medical because she's isolated, but she also didn't like it when other inmates put hands on her. So they isolated her, which is what they do. So
limited range of motion was the provider's assessment of it, so there was noted that she had limited range of motion, and that's what indicated the need for the x-ray, just to see, where we were at.
Okay. So they did notice the limited range of motion. They did the x-ray, and the x-ray was negative.
Yes.
she
Okay.
probably just needs PT.
And
Yes.
did Donna Adelson report mild pain to the provider on February 3rd, 2025 regarding her left upper extremity with the limited range of motion?
Yes.
I'm waiting for Donna to be like, I need yoga.
If either of these x-rays, be it the left upper extremity or the chest, showed need for further treatment, that showed that she does have this necessity that needs to be addressed, would the jail have gotten the treatment that she needed?
Yes.
Do
You have the
Let me ask you a
time
couple of
to
other things.
listen to me whine. You can't just leave that hanging there. You can't just
Throughout
leave me hanging
her-
there, counsel.
medical records?
Judge, I'm going to object at this point.
What is the basis?
The basis of the objection is we were provided late last week, with a stack of medical records that are from the jail facility regarding Mrs. Adelson. We inquired as to what the lawful process
counsel,
was used in order
you've gone well beyond the grounds of your objection. This is just argument at this point. What are the grounds for the objection? Discovery? This is a bond hearing. It seems like you were given appropriate notice for the bond hearing. The defense is arguing Donna is not getting adequate medical care and therefore she should be released. The state is saying she's getting the medical treatment that she needs and can get medical treatment.
obtain those medical records, and we never got a response from the state. And before this hearing started this morning, I asked if they were going to introduce the medical records, and they're not. But it's clear that they've had discussions with this witness about Mrs. Adelson's medical records. They did not give notice of issuance of a subpoena so that we could object. We're not aware of any search warrant that's been given. Our client certainly didn't sign a waiver anyway, so it appears that they have unlawfully obtained the medical records of our client, and this witness's testimony should be stricken from the record and no further testimony allowed.
So the grounds are...
Still in response?
The The grounds are what?
Was not aware that they did not get a response from Mr. Newlin about how these were obtained. I can ask Mr. Newlin what exactly his subpoena issuance entailed to get the records. I reviewed them this week since I was in trial last week, and the witness has obviously reviewed them because he's the medical administrator and would have access to them regardless. I am not moving them into evidence because I know if they're moved into evidence, then they're obviously going to be all of her medical records into evidence. I just plan to ask the witnesses about them as far as the certain things that are relevant to the motion.
So we do not have to prolong this, Mr.
The defense brought up the medical treatment in custody. I imagine that the prosecution subpoenaed the jail, as they can do, and the jail provided the medical records because the defense put it in issue. So the jail medical records are not being moved into evidence, but they are going to be questioned about because Donna said, you have to let me out of jail because they won't treat my medical conditions.
Hayden, if you can step down for a moment to determine how the records were obtained.
So they're going to ask
as
how
part
they were
of
obtained.
the motion for setting bond does go to the sufficiency of medical care. In that way, if Mr. Hayden has knowledge of the care that has been given and what has taken place concerning your client, he is permitted to testify to that. As to any other records, if there's a lawful objection that you wish to make, that will be addressed. Please bring in Mr.
I like this judge so much.
Thank you.
Bring in the other dude. Let's ask, how did you get the medical records? Let's clear it up right now. I love the judge. Let's just handle it now. Get this shit answered.
I have a couple of questions I could ask Mr. Hayden while he's on his way down that don't pertain to the medical records.
So we're switching witnesses.
Okay.
Please take the stand again, Mr. Hayden.
Back to the
Just 'cause I know
investigator.
we're on a time crunch with the witness on Zoom.
Nope. Back to Mr. Hayden. I love that the prosecutor's like, while we're waiting for law enforcement to come back down, I can just ask this witness other questions. Like, they are going to use every minute in court. They're just like, we got this. I love that the judge is like, we're handling this now. We're going to clear it up. It's so efficient. It's not can you brief that motion for me? We'll come back next week. We'll deal with it now. I just love it. I love it.
Does the medical staff at Leon County Jail practice evidence-based medicine?
Yes.
And what does that mean?
So for medicine, evidence-based is all the peer review, so past studies. It's what every medical professional should be using in the community. It's just based on prior trial and error resources, studies, research.
Does that mean that the doctors not only aren't just listening to what the inmate is telling them is wrong, but they're also looking at ordering tests, looking at x-rays, observing the patient to see if they also have any other evidence besides.
Yeah, they're going to look for objective signs and symptoms beyond patient report.
What the inmate is saying is wrong.
Yes.
Okay. Why might that be important to do at a jail?
Well, the majority of our patients lack the knowledge or education about their personal health. Many of them have never been diagnosed with things, especially mental health disorders. We found people have cancer and never realized it. So it's important that the providers use the community standards and evidence-based to make sure.
That's not where I thought that answer was going to go at all.
Do inmates at the jail, I guess.
He's more compassionate than I am. Counsel's going towards malingering. He's going towards, so people don't always have adequate access to medical care. So they come into the jail and have not been to the doctor. They have not been diagnosed. They have not been well cared for. So we want to take care of them. Much more compassionate than me being like, people are malingering because they want to be in medical, which is exactly where the DA's going with this for sure. And he's like, no, ma'am, we want to take care of people. He's right. That's not where the DA was going with that question. The DA was going towards malingering, and that also being an issue in custody.
Could inmates at the jail also have a secondary reason or gain as to
That's where she's going
saying
with the
that they have
question.
some sort of medical issue that they may not really have.
Absolutely.
Is that
Yeah.
as far as being able to get out of custody?
He was incredibly earnest and compassionate in his answer, which actually is really nice to see. She was going towards the direction of, in custody, malingering is a huge issue for benefit, and they need to make sure that they are checking that the complaint and the evidence match together.
Being able to go stay in a hospital or a treatment center as opposed to being in custody at a jail?
Or attempt escape, yes.
Okay. And so is that an important reason why the jail staff turns to x-rays, their physical observations through their evaluation of the patient, or any other evidence that they can point to see that there is some medical treatment or medical necessity there?
I can't speak for the jail staff, but as far as the healthcare staff, we use evidence base to ensure that we're providing adequate care.
Okay.
Right. His focus is on care
Does the
first.
jail prescribe narcotic pain medication?
No.
Okay. So
I
the
imagine-
pain medication that Donna Adelson
I imagine that narcotic pain medication would be a huge issue within a custodial situation.
and other inmates receive for pain is over-the-counter type medication.
Correct.
Jail not prescribed narcotic pain medication.
So that is something that usually most jails and facilities don't because it's a currency. It's highly abused and it can cause safety issues within the facility.
So someone could say they need it and they don't really need it to support some type of addiction to it.
Correct.
Or even if they do really need it, it could cause other inmates, they could cause them to be a target.
Oh, counsel,
by
he was
others.
clear. You don't need to reiterate.
I think that's all I have.
Maggie P asked, what if they have chronic pain? It is going to be over-the-counter pain meds, or it is going to be a different type of locked facility, not in the local jail. There are hospitals that have locked facilities where that can be treated. It would not be generally in custody, but that also depends on whether it was previously diagnosed. It also depends on what the issue is. But there are other options. Remember, we're not talking about prison. We are talking about local custody. So people in local custody are pending trial, sentence, plea often, or are generally sentenced to less than a year. So there is a bit more turnover, which can put quite a lot of stress on the local custody system, where if you are in prison for a set or extended amount of time, there's a more routine setup to that, and then there can be different housings. But in local custody, Advil, Tylenol is it, unless you need to be in hospital. And sometimes
Are you
we'll
planning to go any
try to
further
get to the
examination on
hospital.
the line that you were inquiring of before, Ms. Dugan?
No, sir.
Step down, Mr. Hayden.
Get away.
I'm sorry, before you do, please, cross-examination by the defense.
Good morning, sir.
Good morning.
You coming here today, did you have an opportunity to discuss the medical condition of Mrs. Adelson with anyone in the state?
Outside, right here.
Okay, and who did you speak with here?
Female
Female prosecutor
Female
was just
prosecutor,
questioning you? Okay. And the medical records that were provided to the state attorney's office, did you review all of those?
I did.
You did. When did you review those?
Over the course of, just knowing she's a patient of ours.
Okay.
If people have a 2-year plus sentence, they normally go into the prison custody, not local custody. And so the medical system there is different and is set up differently. You're still not going to have narcotic pain meds lawfully in prison. I won't say that that doesn't happen, but you won't have them lawfully in prison. And then again, you can end up with housing elsewhere. It's just really going to depend on the situation, which is why it's hard to answer broadly, because it really is situation by situation. But I'm not going to sit here and tell you that medical care within custodial situations is good.
You you testified, I want to make sure I understand correctly, the prosecutor just asked you about the button being in some units
In the med
where
bay.
if there was a medical emergency, that the inmates could alert the staff that they were having a medical emergency. Did I understand your answer to be that those are in some of the cells in the medical unit?
Yes, ma'am.
Not in the other units?
Correct.
Okay. And you indicated that the way that an inmate is supposed to request medical care is there's a form that they're supposed to complete, correct?
For non-emergent healthcare.
Right.
Yes.
Okay. And do you know how within the staff at the jail those are given to the inmates?
Yes, they're provided by custody staff, and the nurses also carry them.
Okay. Are you aware from the records that you reviewed that Mrs. Adelson actually requested most recently on February the 1st when she was cut on the metal of a washing machine in the unit, that she actually requested the nurse who was present inside the pod in the annex where she was, she requested a form so she could make a request for a Band-Aid, and they said they didn't have any? Are you aware of that?
I'm not aware of that, but I do see that she placed a sick call request and she was seen.
Ms. Fulford, before you continue, I believe you just objected to the state in any way referencing the records that you appear to be cross-examining on now.
I thought you were asking.
I like this judge so much. Counsel, you said you didn't want the state referencing the medical records until we determined their origin and how they were subpoenaed. And now you're asking him about the medical records. What would you like to do, counsel? How would you like to handle that?
Judge.
I am asking you to do your cross. However, if you are going to examine the witness concerning the records you're objecting to the state using, the state, that will be available to the state, all topics that are raised.
Then I don't want to cross until we find out how they got the records, because my cross is all about that.
Please bring in investigator Newlin, Mr.
And now we're
Hayden, you
switching
may step
witnesses.
down. Not yet.
This
Please
judge
step down for now.
is just A, so on top of it, and B, so nonplussed. He's just so even keel. We have seen him have a great sense of humor, but also dry.
Investigator, you remain under oath.
All right. For all of you that are like, wait, what's happened? We're switching witnesses. Yes. We're taking a brief side quest into another witness to determine how the medical records of Donna Adelson were obtained from the jail. So we're switching witnesses for just a brief side quest, and then we'll be back to the other witness.
Dugan, you may inquire as to how the records of the defendant were obtained as to your medical records.
How were the medical records of the defendant obtained?
By subpoena.
Let me go up to the microphone. Who did you subpoena?
Yes Care.
Is that a company who maintains the medical records for the jail?
I believe it's the medical oversight for the Leon County Detention Facility.
And what, do you remember the day that occurred?
So there's been twice that this occurred. We had a hearing previously, several months back, a while ago, after transport, where we had to subpoena the records, and yes, I brought those with them then. And then last week, I got asked to draft another subpoena for records for this hearing, and that was the extent.
Was that by Ms. Kappelman or Mr.
Yes.
Toomey?
My understanding is Mr. Toomey advised Ms. Kappelman to have a subpoena drafted.
Okay, so she's asking him questions, and he says, I need a subpoena, and so then you did the subpoena?
Correct.
Okay. And then was the subpoena sent to Mr. Toomey? Or to Yes Care?
To Yes Care, yeah, which he's the representative.
How long did it take to get the records back after the subpoena was sent?
I honestly don't know if we have them back. I haven't seen them, so I don't know.
Oh, well, that's interesting.
Any other information you can give us about the subpoena process?
That's it.
Okay. Do you know was the defense, if we did receive a copy of the records, would they have been sent to by Ms. Kappelman's assistant?
That's standard. Once we receive it, we'll put it in discovery and provide it, yeah.
Okay. Did you have any conversations in the last week or two with the defense about the subpoena process?
No.
Okay. Anything else from the court?
I have no other questions concerning this. Does the defense have any questions as to the subpoena?
Yes, could I have just a moment, Judge?
So he subpoenaed the record from whoever keeps the medical records for Leon County Detention Center. And he's like, I'm not sure if they were returned, which means someone probably got the subpoena return and put them right into discovery, but we'll see. I'm going to zoom past defense consulting with one
Prior
another.
to obtaining the subpoena, did you give it?
We are now on cross with the defense attorney only regarding the issue of the subpoenas for medical records regarding Donna Adelson. Why did they do this? The defense has argued that Donna needs to be released from custody in part because she's not receiving adequate medical care. So whether or not she's receiving medical care is very much at issue. And the way to show when she has or has not received medical care is by the medical records saying she made a request for medical care and then she got medical care. So
Any notice to the defense attorneys on behalf of Ms. Adelson that you were going to seek her medical?
ma'am, they don't have to. Did you tell the defense attorneys you were going to seek her medical record? You made a motion and said she got a cut on the washing machine and couldn't get a Band-Aid and she needs to be out of custody so she can have the wax flushed out of her ears. You made a motion saying she wasn't getting medical care. Why would they tell you they're going to get a subpoena? Of course they're going to get a subpoena. What? Counsel, what?
Prior to obtaining the subpoena, did you give any notice to the defense attorneys on behalf of Ms. Adelson that you were going to seek her medical records?
No.
Were you instructed to do that by anyone in the state attorney's office?
No.
Is this just typically the practice that you use to obtaining medical records without giving notice to the defense?
From the jail?
No, my understanding was Mr. Toomey said, please provide me a subpoena and I will bring the records with me to the hearing. That's the extent of what I understood to occur.
I don't have anything further of his words.
Mr. Dugan, do you have any other examination as to the subpoena or the obtaining of records?
No, sir.
You may step down, investigator. Mr. Hayden, if you can take the witness stand once again.
All right, we're back to the other witness. We flip-flopped back to Mr. Hayden, the administrator for medical for the jail.
Concerning the examination of Mr. Hayden, I will rule the following. Any knowledge that he has.
The judge is just going to rule right now. The defense raised an issue and said, hey, we have an issue with the medical records. And the judge said, let's hear a witness. And now the judge is going to make a ruling and we're going to go from there. It's just so nice. It's just so nice to see.
Has, based on his independent review of the records as a member of the jail staff providing medical care to the inmates. If he has knowledge of the defendant's records, he certainly may testify on that basis. If the defense is continuing to object to any use of the records by the state today, that will be handled as a separate matter. However, as well, if there is going to be cross-examination as to the specifically objected to records, that is going to open the door on any redirect topics raised. You may
Counsel, you've
continue
been
your
warned.
cross-examination.
That's the parameters.
Thank you, Judge.
That's the parameters, counsel. Now you know. Everybody's on the same page. And he's allowed to review records. We're still on cross-examination. He didn't do anything wrong. They're alleging that the jail is not providing adequate medical care. He is allowed to go through the records and say, on these days, defendant complained of these things, and then we did this. That's what he's allowed to do.
You indicated in your testimony that you, at the jail, the health care that's provided would be for basic life-saving techniques. Is that it?
As far as emergency, yes, ma'am.
Just for emergencies?
Emergencies, yes.
Okay.
We don't have advanced life-saving medications. They have to be sent to the emergency room.
Okay, and you also indicated in your testimony that the medical care provider, the doctor, I guess, who it is,
trying not to
who
cover
may be
counsel's face.
treating an inmate who's requested medical care,
And accommodate
makes their
those beyond
decision
duty.
based on evidence. Is that right?
Evidence-based practice.
Okay, and your evidence-based practice, your testimony was, could be what they observed with the particular inmate and other evidence as well. Is that right?
So evidence-based practices, we use a standard, like community, the same level of care that you would get in the community is what we provide.
I'm sorry?
Use community-based practice, so the evidence is based on evidence-based practice.
And the evidence that you would have is whatever the inmate is providing to you, correct?
Well, so basically what it is if someone has heart failure, there's a system that we use to make sure that that patient is being cared for appropriately based on the indications, what the illness does to the body, things like that. So it's a standard way of practicing medicine.
And based on that practice, then, the standard way of practicing medicine, if someone tells you they're experiencing shortness of breath, you said an x-ray was done because she made that complaint, correct?
She was assessed, and then the provider also added the x-ray to that, yes.
Okay, and that's something that should be done as part of a normal, right? If someone says, I've got shortness of breath, you should get them for an x-ray. That's part of what should.
I mean, not everybody gets an x-ray when they have shortness of breath. Counsel, it just depends on the situation. She was evaluated, and I imagine they went well. One of the things that might be concerned is given her age and if she has a history of asthma. I don't know if she does or not, but they said she had an albuterol inhaler. Maybe we should just double check. So I imagine even though the provider listened to her and said her lungs sounded clear, they said, let's just double check. I don't know if they would have done that in a different situation. They did it with this patient because they thought it was the best. Okay.
Take place, correct? Okay.
They want to find that Donna's not getting the medical care because they're fighting for her to get out of custody. So they're not going to try to make it easy. They're going to be like, but you,
Part of
you
the
didn't
medical
flush
care
your
that's
ears.
provided by your company, Leon County Detention Facility, do you all do steroid injections in the spine?
No, that would be something that would be sent out for a consult to a specialist.
Ma'am, you've got to be under at least some level of sedation for injections into the spine. Don't start wandering into shit I know about. No, you're not injecting shit into people's spine in custody. What?
And do you do that without court order?
To provide care?
Yes,
Yes, we can provide care without a court order.
you do. That's the policy at the Leon County Detention Facility, that if a specialist is required, you will send the inmate out without a required court order if it's a non-emergency
We
situation.
send people out for non-emergency consults
Okay, great.
almost daily. Yes,
Great.
ma'am.
And as far as the hearing issue goes, you said that the decision about not doing the procedure within her ear, that's because you all don't provide it?
Currently, we just got this request, and this is something that is new to us. We never had any history or any records of it.
Ma'am, she didn't ask us to take care of her ears. She complained to y'all about it, but she didn't tell us. And we are not in the habit of just determining from the ether what she needs.
That, when she made the issue, when she put the request in, she was assessed by the provider, and the provider saw nothing on her assessment. Not to say that if there is an actual need, we can accommodate that. We can coordinate her care.
So that was a recent request as far as you understand?
Yes, ma'am.
I don't have anything further.
Redirect examination.
Okay.
Recent as in the request as to the ears occurred in February
Correct.
of 2025.
So reason is, based on her medical history that she reported at the time she was booked in.
Okay. And the doctor did not notice any hearing loss at that time? Or didn't note any hearing loss?
Right, based on the report, on her assessment.
Okay. And every time she's seen, the doctors have reported that her respiratory system that appeared clear. She appeared to have no issue receiving air.
Correct.
And her oxygen levels, her pulse oxygen levels were always around about 98. Is that normal to be like between 96 and 100?
I mean, if her pulse ox is good.
For the cut that she received on Saturday, February 1st, she ended up receiving Neosporin and a Band-Aid for her cut.
Yes, and then they followed up, I believe it was a week after, about 7 days after the initial assessment, the skin protocol was initiated, and they found that there was no signs and symptoms of infection, and at that time she was educated to report any signs or any worsening of the condition.
Ma'am, if it
And
gets
she
hot,
did
let us
receive a
know.
tetanus shot.
Yes.
Just in case.
We don't want it to
That's
smell
all.
weird.
You may step down, Mr. Hayden.
Okay.
Let's resume with the suppression aspect of this at this time.
Judge, may we be excused?
You're excused. Have a good day.
Thank you.
Some of these microphones are
Let's
just...
resume with the suppression portion at this time. Does the defense have any other?
So we're jumping back into the suppression motion. How is the judge keeping this clear? Because judge is judge. So that witness was taken out of order to accommodate their schedule, which is not unusual. There are two hearings today, the suppression hearing and the bond hearing. The bond hearing goes more to the medical treatment in jail. I covered these motions on stream a couple of weeks ago, but the suppression motion is mostly going to whether or not that open recorded part of the jail call with her son is or is not effectually a wiretap. So that's what they are going to be talking about. And I know our mods have been working hard because there's been lots of disparaging of Donna Adelson's looks. Look, prison is hard on people. They're not going to look the way they do when they are out of custody. So yes, it's not easy, but thank you for also sticking to the law and order rules even when it's hard. Look, even when it's hard, this is one of the times when it's hard. Let's continue on.
Other witnesses or evidence it wishes to present as it relates to the burden in this matter.
Yes, Your Honor. Defense will call Donna Adelson.
Please come up to the witness stand, Ms. Adelson.
Wait, damn it, Emily. I went to pause. What did you just say? He just said the defense will call Donna Adelson. Hold on. Well, I'm glad I made a note. Because the defense is calling Donna Adelson. Oh boy. Donna's going to be like, I hung up the phone. $10. I hung up the phone. Okay, Donna.
Witness stand. Yeah.
And yes, this is not in front of a jury. This is just in front of the judge. She is going to be in all the typical restraints. I imagine that's not going to be easy
Please raise
for
your
her.
hand as best as you can. Do you swear or affirm the testimony you're about to give will be the truth? You may take the seat. Please speak loudly and clearly.
Donna's on the
You
stand,
may
y'all.
examine Mr. Zellman when you're ready.
Sorry, Emily, you're too excited. Stop being so excited. Look, they need to know what she believed about the privacy of the phone call. This is necessary. Today's the day I'm not going to complain about zooming in on the defendant. Today's the day.
Good morning.
Good morning.
Can you
And she has
please state your name
glasses.
for the record and make sure you speak in the microphone?
Yes, Donna Adelson.
Ma'am, your defense attorney said that your wheezing was so bad that they can't hear you clearly when you talk to them. Oh, and for all of you in the chat saying we got the app notification, I'm so glad. I'm so glad you got the app notification. That's what we do. We know court days are long, but you don't want to miss what you don't want to miss. And what we don't want to miss is Donna on the stand.
Now, I want to direct your attention, we heard the call earlier. The call on November 7th of 2023 at about 3 o'clock in the afternoon, and for the record, that was call number 561. Do you remember where you worked?
Yes, I was in my apartment in my living room.
Do you remember who was present when you got the call?
Yes, my husband, Harvey, and friends of mine, my attorney, Susan Brotman, and her husband, Richard Chagrin.
How many attorneys did you have at this point? This is the defense cross-examining her. I'm going to see if I can gain her up a little bit.
Attorney, what kind of law does Ms. Brotman practice? Or did she?
She does estate planning.
Estate planning. Estate planning. She does estate planning. She does estate planning. Like planning for your estate to go into a trust that's run by your daughter because A, it has tax benefits, and B, if you're out of the country, then it makes it easier for your daughter to take care of the day-to-day. You mean like that? You mean that? You mean that? For those of you in the chat that are saying escape planning, you are sending me. Estate planning. But I'm not going to tell you you're wrong.
Was Ms. Brotman present at your apartment for the purposes of providing you with legal counsel?
Yes, she was.
And you remember receiving the call from Charlie?
Yes, of course.
And where was Charlie at the time?
So he was in a room by himself. It was after the conviction.
Counsel, honestly, he was in a bad place. He was in a room all by himself. I'm not going to be able to do this. Donna, for real?
Charlie at the time.
So he was in He was in a room by himself. It was after the conviction.
Was he in the jail?
He was in jail.
Okay. What did you do when you saw that Charlie was calling?
Answered the phone?
And you heard the recording that we played earlier?
Yes.
And you agreed for your call with your son to be recorded, correct?
Yes.
As the call was happening, do you know at what point Charlie was no longer on the call?
No, only when because I was talking, and then all of a sudden I asked him something, and I said, "Charlie, do you hear me, Charlie?" And I said it a few times, and he didn't respond anymore. And I knew the call was over.
Now, in the course...
I knew the call was over, or that he was no longer there.
During the time that your son was incarcerated in Leon County Jail, did that happen more than, was that a frequent occurrence?
Yeah, it happens. It happens a lot, unfortunately.
Okay. And would there be times when you didn't realize at first that he was no longer on the call?
Yes.
Where in your apartment were you when this happened?
So I was in my living room.
And you heard your voice on that first call,
The sound is so bad. I was trying to gain it up, but it just
562. When you repeated, Charlie, Charlie, are you there?
Right.
Did you believe the call had ended?
Yes.
And in times prior to this, what would happen after that? What would you do when that would happen?
If he didn't respond anymore, that was it. The call was over.
You hang up.
And what would you do with your phone?
You hang it up.
I'd hang up.
Right.
Now,
boom. You end it.
Same thing with the call on November 8th of 2023, the one at 6:30 in the morning. Do you know at what point your son was no longer on the phone?
I don't. I don't remember the call.
In either one of those situations, or in both of those situations, did you believe the call was over?
Yeah, the call was over. He was gone.
And you went about your business?
Yes.
Now, with respect to the November 7th, 2023 phone call when your attorney, your husband, and your husband were present at your apartment, did you agree for your attorney-client conversation to be recorded?
No.
Did you agree for your conversation with your husband to be recorded?
No.
Counsel.
Of course not.
Now, the following day,
I don't agree with
did you
counsel's
agree
framing.
for your subsequent conversation with your husband to be recorded?
No.
You agreed for the jail call to be recorded, and then you didn't hang up the call. They didn't bug your house. The noise in the background is the persistent noise we've heard the whole time. I don't know if it's the air in the court or what, but it's been ongoing.
Now, you heard the recording. To consent to this call, press 1. Or recording of this call, press 1. Correct?
Correct.
You hung up the phone after those calls were over.
Thought I did.
What other people are there about?
Just a moment, Your Honor.
Her husband's there, and her lawyer's there, and the lawyer's husband's there. If it was just the husband and the lawyer, I might be a little more persuaded.
Time, Your Honor.
The lawyer's husband being there is different. And the cross-examination is going to be narrowed to the direct examination. This is not an open season to just ask Donna, so why'd you hire a hit on your son-in-law? That's not what's going to happen. But it is going to be about the call, her expectations, because this is a suppression motion, and what she thought about the call through the jail being connected or not connected matters for the suppression hearing. So we're on cross. That was quick.
Ms. Nielsen.
Good morning.
So there in the room with you during this call was, you said your
Husband.
one of your attorneys, Susan Brotman, your husband, and then also Susan Brotman's husband.
Yes, that's correct.
Okay. And he was not your attorney?
He was not.
Your attorney?
No, he's not an attorney.
Okay. You were informed at the beginning of that call, this is the one on November 7th that recorded you while they were all in the room. You were informed that you were being recorded if you accepted that call?
Yes.
Okay. And that if you do not want to be on that recorded call, that you needed to hang up the call. Is that right?
Are you saying, does the recording say?
Right. If you do not want to accept that recorded call, you should hang up.
If you do not, yeah, no, I accepted the recorded call.
Okay. And you typically do hang up your calls, you said, after
I mean, I think I
your
did,
calls with
yeah.
Charlie Adelson when he was in custody. All right, but this particular call that day, evidently, you did not properly hang up, right?
Evidently.
Okay. And have you ever forgotten to press the button on a call before?
Probably.
It may have happened. I don't know.
Sure. Has your phone pocket dialed people
don't know.
before?
Has it what?
Pocket dialed people before?
Excuse me, counsel. I vehemently object. What is this pocket dial? Counsel, we will only accept butt dial conversations up in here. Where have we gotten when we are not asking about butt dials? Can we cover a case that doesn't involve a butt dial? No, we can't. Ma'am, have you ever butt dialed? Not a pocket dial, counsel, a butt dial. Back to the butt dials. However, I will say, of all of the pocket dials that I get, my parents, particularly my father, is at the top of the list. So just, as a point of interest, Your Honor, as a friend of the court, that would be a butt dial. And probably for Donna, honestly, it would probably be a purse dial, to be fair, but it's still a butt dial.
When you've been out of custody.
Pocket dials?
Right.
I don't know what you mean.
Like if your phone is in your pocket or in your purse and it accidentally calls someone you didn't mean it to.
I mean, that could have happened, sure.
Okay. And you also could have not pressed the button on your cell phone to end a call before, right?
That's possible.
Okay. It's not quite as big of a deal as it used to be when you would actually have to hang up the phone. Right. Okay.
It was so much more fun.
That's all. Thank you.
Redirect examination.
Briefly, Your Honor. The consent that you gave for the call to be recorded, when did that end?
It ended when Charlie hung up.
It ends when the call ends, counsel.
Or
when you hang up.
Whatever stopped the call. I mean, I don't know how it stopped, but it stopped. When the call was over with Charlie, it was over.
Okay. Nothing further.
It's a fair question, but I disagree with where counsel's going with that. All right. I wonder if they'll call her back for the bond hearing. And I wonder if there's any more witnesses. Remember, there's a motion to suppress her call because Charlie is off the line. The line is still open, and it records quite a lot of conversation about her finding non-extradition countries and
As to the
leaving.
burden up this under the precedent established by Smiley versus State, in order to exclude what are complained of wiretapped interceptions, the movement has a need to show there was a subjective expectation of privacy in their statements, and the expectation is one that society would accept as reasonable. As to
The court is quoting the governing case law here and saying, under this case law, this is the standard. The movement, which is Donna, has to show the subjective thought, and then that expectation has to be reasonably accepted. So I'm going to back it up. Well, the judge is giving us the statement of the law, And then I think we're going to hear argument and then ruling. That would be my guess.
Need to show there was a subjective expectation of privacy in their statements, and the expectation is one that society would accept as reasonable. As to the subjective expectation showing the defendant has met that burden, it now shifts to the state as to whether this is one that is reasonable. Ms. Dugan,
Yes, sir. I have argument.
you may proceed.
May I provide the court with some case law?
So now we're going to
I've got some argument, and then I'll kind of go through each one of these cases. And I provided defense a copy of these.
And again, a subjective belief. Donna got on the stand and said, I thought it was over. That's going to meet the burden. So now it is on the state to say Donna's expectation that the call was over does not meet a societally accepted standard of reasonableness because you consented to the jail call. That's where we're going to go with that.
So in defendant's motion, they first argued that this was, a warrantless search. However, the state's argument is that this is not subject to Fourth Amendment. There's no wrongful state action that caused this defendant to be reported after the inmate was no longer on the call. The only conceivable state action here is the state having this service that allows inmates to make recorded calls. But on those calls, both parties have to consent to be recorded for the call to begin. And if they do not want to be recorded or need to hang up, the state didn't intend to record this defendant's conversation in her home with her husband and friends. And it was the fact that she was recorded was not caused by the state's actions. It was caused by the defendant's actions.
No state action.
The defendant argues that they have a reasonable expectation of privacy in the call, but that would only start once this defendant actually hangs up. And the defendant is the one responsible for hanging up, not the state. The defendant was responsible for the interception of the phone call. It was her failure to hang up that caused that rest of that call to be recorded. It was her action and not the state action that made that happen. The state did nothing to keep her from hanging up the phone or prevent her from hanging up the phone. I think an analogy here would be if someone were to say something incriminating in earshot of a law enforcement officer because they think the law enforcement officer can't hear them. If they can actually hear them, then that's on the speaker because the speaker didn't walk away to talk. That was the speaker's carelessness. The defense also cites Florida Statute 934 and says that the good faith exception doesn't apply because this call was a violation of that statute. But when you look at 934.03, every single subsection of that statute applies to intentional intercepts, not general. I provided several cases to the court. There's nothing directly on point here of this situation having happened just like this in the past.
This is an unusual
but there are a lot of
situation.
cases that deal with inadvertent recordings. One of the first cases I gave to you is Baronet. This is a U.S. Court of Appeals case from the Sixth Circuit that held that police interception of conversations between the defendants that was overheard when a phone that was subject to a court-authorized wiretap was inadvertently left off the hook by the defendant. That was authorized under the plain view exception to the warrant requirement. In that case, the state had an actual Title III wire on the defendant's phone. The defendant was on a call and then didn't properly hang up the call. They left the phone off the hook accidentally. And then law enforcement was able to hear the conversation in the room where that phone was located. So when you compare that to our case, there's obviously, a much different type of state action in that case with a wire.
Because there was actually a wire
But
here.
regardless, this was a recorded line. It was a legally recorded line where they consented to be recorded. Just like in our case, though, the defendant in that case failed to properly hang up, and that allowed law enforcement to hear the conversation in the room. And that was able to be authorized because of the inadvertent nature of the recording. Another was Otero versus State. This is a third DCA case from Florida where a child accidentally activated an answering machine of a home that she was staying at And that answering machine recorded the conversation of the mother and the child unbeknownst to either of them.
I'm going to need to know how old that case is that they accidentally activated an answering machine that was then recording what was being said in the room, because that must have been a while ago.
The third DCA found that admission of that tape into evidence did not violate the statutory exclusionary rule found in 934, because 934 prohibits intentional interception of wire communication. And that taping in that case was accidental, not intentional.
This is
just like
accidental
in our
inadvertent,
case.
right?
There's another case that I provided to the court, Bell versus State. In that case, a girlfriend began to record her conversation with her boyfriend, who was the appellant. And that conversation that she wanted to record was about money, an argument about money between them. The appellant, Bell, then took the phone from her and kept the phone after the argument ended and the girlfriend left the house. The girlfriend's young daughter was still at the house, and after the girlfriend left, the defendant was intoxicated and forgot to turn off the audio recording. There was then a recording.
I don't like where that's going.
As the recording kept going, it recorded him molesting the girlfriend's young daughter.
Damn, I hate the direction that went in.
The girlfriend then discovered
my spidey senses on that were like, I don't like the direction this is going in. I don't like this at all. Warning, warning, warning. And guess what? That is the fact pattern that went exactly where I thought it was going to go, and I hate it. But those are fact patterns from other cases where law enforcement used a recording that law enforcement did not make or endeavor to make. It was a recording that was made in a different way. And that's why this case law is coming up.
Audio recording next day and handed it over to the police. The defendant was charged with L&L molestation. In that case, the recording of this molestation was obviously inadvertent, and the defendant agreed with that. Only the first conversation about money was what the girlfriend was trying to intend before the phone was taken from her.
And he took
and
the
that
phone from her.
was in the appellant's custody and control at the time of this recording of the L&L molestation. The DCA in that case said that the trial court did not err in concluding that Mr. Bell failed to prove that his girlfriend intentionally intercepted the portion of the recording that took place while she was gone. Unless his girlfriend intentionally violated the statute, he was not entitled to the benefit of the statutory exclusionary rule. Because the recording was...
Just to clarify, because a lot of you are coming and being like, what are they talking about? Counsel is making her legal argument. She is citing precedential cases. So she is citing cases to the court saying in these other situations, remember what I said, the courts don't want to be weird. Don't do anything weird. These other precedential cases where there was an inadvertent recording, the appellate court found that the trial court did not err. So the lawyer is saying, Your Honor, there's no error here. And these situations, different cases, these situations are like our situation. So they're not arguing the facts of this case. They are arguing the facts of the precedential cases. So if you were with me when we went down the missing juror rabbit hole, these are other fact scenarios because that is how the law starts to build. Okay, in this situation, the court found that the phone is in the custody and control of the person who ends up being the defendant, and they didn't stop a voice recording. So it wasn't state action. It wasn't a wiretap. It wasn't a Fourth Amendment search or seizure. And case law builds by different fact scenarios. So counsel is going to cite other cases and other fact patterns because fact patterns are literally all of law. It's the facts here equal this result. Are these facts like those facts? And so that's what court is arguing. It's not about this case, other cases, just so we're clear on precedences. Precedences, that's not a word. Precedent.
But after she warned him she was going to record him, he took possession of the device that recorded his words and actions.
He knew he was being recorded.
And so the court found that the appellant did not establish that the communications were intercepted under any circumstances justifying an expectation of privacy.
That makes sense.
I have one more case that concerns the reasonable expectation of privacy. This is the Huff case that I provided to the court, which is a federal case where the plaintiff, a federal civil case, where the plaintiff inadvertently pocket dialed the defendant, which is something that, has.
Damn it, counsel, we will only accept the word butt dial. Of course, there's a precedential case about a butt dial. Yes, there is a federal case about a butt dial. I'm sorry, this is Florida, a pocket dial.
It's happened to us all. And the defendant listened to and recorded the conversation she overheard while on the pocket dial call. The plaintiff then brought suit for the defendant intentionally intercepting this private conversation. And in that conversation, the plaintiff was basically having a discussion with his wife and with other people as well in the room. The court ruled the plaintiff's statements did not qualify under Title III because he exposed them to the defendant when he pocket dialed her. But the plaintiff's wife's statements did qualify. She can't be held responsible for her husband's pocket dial. But the thing that I think is most important about that case is the court's holding that a person who knowingly operates a device that is capable of inadvertently exposing his conversation to third-party listeners and fails to take simple precautions to prevent such exposure does not have a reasonable expectation of privacy with respect to statements that are exposed to an outsider by the inadvertent operation of that device.
That is good case law for the state. That clear and concise statement from other courts saying, when you are the one in possession of the thing, it is your obligation to operate the thing, and it does not violate your reasonable expectation of privacy if you don't hit the button to hang it up. You are in control. So you can't say, well, I didn't know. That is a good case cite. You can see the court noting it down as well. A good case cite that I'm sure is in their briefing papers as well.
So in that case, the statements didn't qualify as ones that were protected under the U.S. Code. And that's what we have here. We have the defendant failing to take simple precautions of properly hanging up what she knows is a recorded call. So the state would ask that the defense motion be denied.
Final argument on the motion to suppress from the defense.
All right, let's hear the defense argument.
There are two cases, I cited a number of cases, and I know Your Honor's practice reviews in addition. There are two additional cases I provided copies to the state that I am relying on. The first is Kent versus State, 62 Southern 3rd, 1184, and State versus Mozo, 655 Southern 2nd, 1115. May I approach?
You may.
And these would be in their filing papers as well, which we covered the defense's papers. We didn't go through the state's papers much.
So, Your Honor, I want to start with a very general proposition that's important for us to remember. Right to privacy is enshrined in the Florida Constitution. Article 1, Section 23 provides that the right of the people to be secure in their persons, houses, papers, and effects against.
Your Honor, let us remember where the right to privacy comes from. When you have to start with the history of the right, it is because the facts are not on your side. And counsel is arguing as if the facts are not on his side already. So he's just like, you know what? Your Honor, the right to privacy is one of our fundamental rights. Right.
Against unreasonable searches and seizures and against the unreasonable interception of private communications by any means shall not be violated. Article 1, Section 23, the Florida Constitution also provides that every natural person has the right to be let alone and free of governmental intrusion into the person's private life. Fourth Amendment includes similar protections. 934.02 defines an oral communication as any oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception under circumstances justifying such expectation. The courts have held in Florida, as cited in my motion, for an oral conversation to be protected, the speaker must have an objective expectation of privacy along with a societal recognition that the expectation is reasonable.
The court already said that.
Your Honor, State versus Mozo, almost 20 years ago, courts have held that conversations, oral communications taking place in one's home are protected by Chapter 934.
Yes, but
I don't think this point is reasonably in dispute, but go ahead.
Now, the question, obviously, is the objective.
yes, like you can't put a microphone on somebody's front door to record what's going on in the house. There's tons of case law about what you can and can't do to monitor someone within the house without a warrant. So yes, there is a reasonable expectation of privacy within the house. But if you open up a line to the house, like Donna did on a recorded call, it changes things. So,
Portion of this test. And Hence versus State, 4th DCA, and Hence is a situation, Your Honor, where an individual was in an interview room at the police department. He placed a call to essentially a co-conspiratorship, co-defendant, and the recording equipment was powerful enough in that interview room to pick up the other end of the call that is made to Hence.
Did you hear that fact pattern? Dude one gets arrested and is in the police interview room. Dude one gets on the telephone with a co-conspirator and starts chatting with him. And dude two on the phone, co-conspirator, can be heard through the phone by the microphones in the interview room. I'm interested to see where this is going, but also A, earbuds, but B, how often are y'all in public when people are just like on speakerphone? I don't know what that is, but it is my least favorite unless I then get involved in the chisme and want to know what they're talking about. But everybody's sitting around on speakerphone just all out in public. Look, you have a right to privacy. Use it. Just use it. Because I don't want to hear your whole ass conversation. Yesterday, I'm walking around Barnes and Noble, and there was someone having the loudest conversation. And I was like, it's a Barnes and we are it. What? And I had my headphones in and was listening to something. Heard the whole conversation. I was like, stop it. Stop it.
Based on what law enforcement heard from the individual's call, the individual who was calling Mr. Hence, they obtained a search warrant for his cell phone. And on that cell phone, they found images that are illegal to possess, as well as other evidence of a crime that the two of them engaged in.
Don't call your co-conspirator from jail if you don't want police to know who your co-conspirator is.
The Hence court held...
Jenny, I don't think being in a car counts the same way unless you have a passenger in the car who doesn't want to be a part of that conversation. But also, if I call people from speakerphone in my car and my family's in the car, I tell them, you're on the phone. This is who's in the car. I let them know. I don't think the car is the same as public. But if you're sitting in a parking lot with all the windows down and like the roof open and whatever, then public. That's my thoughts. Chat, let me know your thoughts. So.
That, and another important factor, Your Honor, Mr. Hence was aware that the individual on the other end of the phone was at the police department waiting to speak to law enforcement. Court held that Hence had a subjective expectation of privacy, and his expectation was one society accepts as reasonable. Now, one distinguishing factor, I need to acknowledge that, but I submit it's not dispositive, is that while Hence did not know that the individual was sitting in a police interview room, whereas Mrs. Adelson knew that Charlie was in jail and had consented to her call with Charlie being recorded.
That's a good distinguishing.
But the oral communication that is protected by Chapter 934 that is at issue here
I think doesn't
are the conversations that Mrs. Adelson had after Charlie dropped off the call, when she believed the call was no longer being recorded. Conversation, at least with respect to November 7th, is with her attorney and her husband. Both are confidential relationships.
Doesn't the warning, though, about the recording almost directly speak to that issue where I'll read the case that you've given me about hints. Although he knew his friend was at the police station, he never received an explicit warning about you may be recorded if you continue on this conversation.
Donna
Correct, and I'm going to get to that, Your Honor.
Go ahead.
Donna did get a warning.
The testimony, uncontroverted testimony, is that Mrs. Adelson believes she hung the phone up once she realized Charlie was no longer on the call. There's no evidence otherwise.
Donna says she thought she
And I don't think it is reasonable to require an individual in a situation like that, I just had a recorded phone call, let me repeatedly hit the end button.
Sir, there's no evidence your client hit the end button once. But I bet we could extract her phone and find out what actions she took on the phone. Because if she ended a call, a phone extraction should show us if she hit end or not. And I imagine that what she didn't do was hit end on the phone. I bet what she did was say, Charlie, and put the phone down.
Once, that should be enough. She believed that she ended the phone call. Now, hence also address something else that I think is important. Chapter 934.03 is a general intent statute. It does not require that the state intentionally recorded after one party of this jail call
requires
drops
some
off.
state action in the Fourth Amendment because the Fourth Amendment's about state action.
Was the system designed to intentionally record? The answer has to be yes. Investigator Newlin testified, yes, intentionally designed to record. Now, the state, I anticipated that they would argue accident or inadvertence. This is not an accident. An accident is something that doesn't happen frequently. Mrs. Adelson testified.
Rachel, it's also my memory that she said something about staying on the line to see if he would come back, but it wasn't argued in court here, so I'm not bringing it in. But that was my memory, that she thought he might come back, but the prosecution didn't bring it up, and it hasn't come up in court, so I don't know if I'm misremembering it, but I didn't go back and review these calls either. So they didn't argue it, so we'll see. But I think the facts kind of speak for themselves. The fact that the recording exists indicates that she didn't hang up. And if they had proof that she did hang up, that she had hung up the phone, it would be a different argument because that would be untenable if she had. And Donna's testimony on the stand earlier was, I guess I didn't hang it up.
This happened. The call, Charlie dropping off the call would happen frequently. And as Investigator Newlin acknowledged in Defense Exhibit 3 and Defense Exhibit 1 established, this was not an isolated issue. This happened. The system is intentionally designed to continue recording.
Like 911?
Under Chapter 934, I submit that when either side of the call is no longer on the call, that the system has to stop recording, and any additional recording is a violation. That's
the
what
call
we have
doesn't
here.
terminate yet.
This is not an accident.
For whatever
this
reason.
is not inadvertent. Securus Technologies system is designed to continue to record after either one of those parties drops off the call. Investigator Newlin said that it terminates when both parties hang up.
Right.
Well, I submit, Your Honor, that that's not what happens. It continues to record, and it is not reasonable. And
Counsel,
society is not...
Do you have evidence that when both parties hang up, it keeps recording? Because that's a very different circumstance.
Expecting that somebody sit there with their phone and continue to hit the end button to make sure that the call stops on their end. I think that's unreasonable.
But do you have to continue to hit the end button, or you hit it once? It's disconnected.
The testimony is that she believes she did.
But that's not your argument.
So
also, what nobody's argued, and I'm surprised about, is nobody's arguing that this is also a paid system. So when does your collect call end? does the collect portion of the call keep going? Because I would bet it does. If you don't hang up the call, you're still getting charged. So it's not just about the recording, but if you don't make sure you hang up, I'm sure you're still getting charged like $5 a minute or whatever it is. So you're also racking up a substantial bill. And I think that is a point that's interesting to me, because there is quite a bit of motivation, one would think, to look at the phone and be like, well, they're not there anymore, I'm going to hang up, because you're still getting charged collect.
Because this is not a specific intent statute, is the system designed to intend to record? Yes. And there's no evidence that this was accidental or inadvertent. This is not a pocket dial, as the state argued. A dial. We know that Charlie intentionally called his mom. We know that the system intentionally recorded the call.
We know that she intentionally said yes.
Sufficient evidence to establish that this is not a communication that society is, that there's a reasonable expectation that society would accept.
I was being hyperbolic about $5 a minute, but jail calls are quite expensive, and there's like a initiation fee as well. So there's an initial initiation fee that might have changed, and then there is a pretty high toll per minute. There's some legislation federally, I don't know if it's state by state, to change how much it costs, but it's not a reasonable amount for a collect call. It is expensive, in my opinion.
That this call is anything other than something that is entitled to the protection of 934 and the Florida Constitution.
I disagree.
We'll review the cases that were presented by both parties before making any ruling. I'll reserve on the ruling as to today. We'll take a brief 5-minute break before we get into the Arthur and bond motion. We'll be in recess.
Thank you.
All right, we're going to zoom past recess real quick. The court's going to recess before we get into the bond motion. Remember, we already heard one of the witnesses in the bond motion. The main point of the bond motion is that Donna Adelson is not a risk to the community. She is not a flight risk, and she is not getting the medical care that she needs in custody, so she should be allowed to stay in Tallahassee on essentially house arrest. So I'm going to zoom past that quick court break and get back into the bond hearing as we move forward in court. So let's get back to court, shall we? Yes, we shall. I'm bummed that the court is reserving the ruling. However, both counsels provided the court with additional case law today, and this judge does rule pretty quickly. So I'll let you know in the app the second this judge rules. I'm so curious to hear what he has to say. Let's continue in court.
Your Honor, go ahead. Your Honor, the system is the security.
Oh, they went back on the record. Hold on. When I saw the blank wall, I figured they weren't back on the record yet.
59 seconds exactly.
Thank you, Your Honor.
Go ahead.
Your Honor, the system is...
I think counsel asked for a little bit more time to make an argument. The court said he's like, I want 1 minute. And the court's like, you have 59 seconds exactly. Again, I like this judge. I think the attorneys that work with this judge probably very much like him a lot.
The secure system is intentionally designed to continue recording after the inmate disconnects. And the system knew that Charlie had been disconnected because he tried calling back, and the system reflected as investigator Newlin testified account in use.
But the system knew it disconnected.
Let's move on to the Arthur hearing.
One more point. All right, on to the bond hearing.
Is the defense wishing to present its argument as to bond, or is the state going to present first as to proof of guilt evident or presumption grade?
I'd prefer we do bond first, if that's okay with the defense, just because the state does have a couple of witnesses as to the things they brought up in their motion.
More witnesses.
And then I'm not calling any witnesses for Arthur. I'll just be moving some things into evidence, so maybe we could do that last.
Okay.
Mr. Zellman, as to the bond portion of this, do you have witnesses?
We do, Your Honor. State would call Donna Adelson.
You're not the state.
You can retake the stand once
You're the defense.
again. You remain under oath.
The state would call Donna. You're the defense. The state can't call Donna Adelson. Donna's back on the stand. Oh boy. Oh boy. Oh boy. Donna's back on the stand. Donna's going to have a lot to say about not liking jail. Y'all just, law nerds. Oh, Donna. All right. All right.
You are sworn to tell the truth.
Oh boy. Donna's going to be like, Your Honor, jail sucks. I don't like it. Another inmate is extorting me for commissary. I've been assaulted. I don't like being in solitary. It's terrible. But Tony in the chat said, I was not expecting a double dose of Donna.
You may examine when you
Me either.
Thank you, Judge.
The prosecution's not allowed to call her. The defense misspoke. The defense said the state calls Donna Adelson, and I don't know why, but it's the defense. The state can't call her. She has a right against self-incrimination. Buckle up, everybody. Miguelina, should we let the chat know again that Donna's back on the stand? Or the app, just in case?
Ms. Adelson, at the commencement of the hearing on the motion to suppress you said your name for the record, Donna Adelson. Can you tell the court how many times prior to your arrest for the charges that are pending in this case have you been arrested for criminal offenses?
Never.
And
I'm already not, counsel, I'm not going to be persuaded that she has no record. Sometimes people have no record. It doesn't stop them from being involved in violent crime. I don't think she is generally a danger to the community. I think she was probably a danger to her son-in-law. I don't think her saying, I'm not going to like run around and rob people. I don't think that's the issue for this bond hearing. I really think this bond hearing is going to focus on whether or not she's a flight risk.
how long incarcerated at the Leon County Detention Facility? Do you recall?
15 and a half months, 470 days.
You've been counting?
And within that period of time, the 470 days, have you been held in the same location in the Leon County Detention Facility or different locations?
Different locations.
Okay, and your first location was where?
First location was in solitary confinement on a direct observation unit.
Do you know how long you were there?
50 days.
Okay. And where did you go following solitary?
To the N pod, like N is in November. It's an open pod, general population.
And what does that mean, open pod, general population?
So I was with 60 some odd other inmates, all in one open area.
And you had beds in your room, I assume?
There were each sections off about 10 women. So, and there'd be a cement wall, and then there'd be another 10 women and a cement wall. So it was fairly quiet, actually, even with that many women, because we were separated in small groups, so it wasn't that loud.
Okay, and do you recall when you were taken out of the Inn like Nancy pod?
Yes, in August, they said they had maintenance to do, and that we would be moved to the Annex, which is a building outside of the jail.
Okay, and so I'm not going to be specific as to dates, but you were arrested in November of 2023 in solitary confinement for 50 days to whatever date that took you to.
January 9th.
Okay, and then from January 9th all the way through some date in August of 2024.
Correct.
You were in the Inn like Nancy pod. And then you said you were transferred to the Annex. Can you describe the conditions inside the Annex, please?
So the Annex is kind of a temporary type building. It's not a brick
annex.
building. It's kind of like a temporary building, and it's and there are 66 women, all in bunk beds, all open. You're kind of one on top of the next. There's no separation at all.
So one big open room, if
One
you
big
will?
open room with 66 beds, yes.
Okay. And,
more like a
and how
federal-
long did you stay? So from August
more
of
like a federal
2024 until when? How long did you stay in the Annex?
I was moved again on February 3rd, 2025.
Okay. Okay, and you were here when the gentleman was testifying about the call buttons to alert someone if you're having a medical emergency. Was there one of those in the N pod?
No,
Was there one in the Annex?
no.
Okay. I'd like to start the motion for a bond that we filed in this case, as
Not
the court
everybody in jail
indicated
has
earlier,
a,
one of the
medical qualified
issues that we have raised are medical conditions that you're
Sure.
facing. So I'd like to start with your medical conditions and present some testimony to the court about those, okay?
Okay.
Okay. We're not going to go over every medical condition you've had since you've been incarcerated in the jail, but I'd like to start with one that you have that's causing you some pain in your leg and back area. Okay. Let me just start with this. Can you describe to the court the kind of pain and discomfort that you're having with this particular injury or issue?
Yeah, it's I know what it is because I've had it in the past. It's sciatic pain, and I get like
Sciatica sucks.
I get like a pulling kind of shooting pain down my legs.
That sucks.
And you said you've had it in the past. You mean prior to becoming incarcerated at Leon
Yes.
County Jail?
Yes.
Sciatica's the worst.
And during the course of time before you were incarcerated at the Leon County Jail, did you seek treatment for that condition?
Yes, I did.
And what type of treatment did you obtain for that?
So I saw my orthopedist, and he gave me a steroid injection in my spine.
Okay. How long were you suffering from the sciatic condition prior to becoming incarcerated?
How long the last episode was?
Before you were incarcerated in jail, for how many years had you been suffering with the sciatic issue?
So no, I had it last about 10 years ago. I haven't had it all this time.
Okay.
But then it recurred a few months ago.
Okay. And what was the treatment that you were provided prior to your incarceration for your sciatic condition?
It was the steroid injection, and within 48 hours, it was gone. The pain was gone. It was amazing.
And where did they do the steroid injection? Where's that in your body?
In my spine.
Spine. Okay. Is that an outpatient procedure, inpatient?
Yes, outpatient.
Outpatient. Okay.
Light sedation, like
All right.
poly-type sedation from my
And
experience.
during the course of time that you've been in the Leon County Jail,
A
did you
lot.
start to experience the
I've had a
sciatic
lot of
pain again?
Injections
Yes,
into my spine
I did.
before my
And what did you do when you started to experience
multiple
that
spinal
pain?
surgeries.
I wrote a sick call, and I went to see the doctor.
There's not a
Where do you
ton
get
they're
these
going to be
sick
able
call
to do about
forms
it.
from?
From the nurse.
Okay. And when do you have the opportunity to see a nurse with sick call forms?
Well, they come twice a day. They come in the morning and they come in the evening.
Okay. And we'll get to what those times are at a later point. But if you don't get a form from a nurse, is there another way to obtain it that you're aware of?
No, that's the only way I've ever gotten it is from a nurse.
Okay. Do you recall approximately how far into your incarceration you started having the sciatic issues again?
I didn't have it until I was in the annex. So that was sometime over the last, I've been there 6 months. I don't remember the specific date, but I didn't have it before the annex.
Okay. And once you started experiencing it in the annex, did you complete a form to see medical attention?
Yes, I did.
Okay. And as a result of completing that form, did you have an opportunity to meet with someone in the medical center at the Leon County Jail?
I saw the doctor there,
And
yes.
what happened?
And I explained what I had, and she said, we do not treat that type of problem. We could offer you some Tylenol.
And did they provide you with Tylenol?
They did.
And has that relieved you of the pain that you suffer?
No, it's Tylenol. It's not gonna do what I need to have done, no.
Okay. So sometime since you've been in the annex, you made your request for treatment for the sciatic issue. Have you requested treatment more than once?
Yes.
Okay. And have you received any additional opportunities to meet with any of the medical staff regarding this pain?
No.
Okay. What happens when you request treatment and you don't get to see them? Do they tell you that you're not going to be allowed to see them again? What happens?
No. Usually I wait a week, and if I don't hear anything, then I'll write another one, and I'll write, this is a second request, or this is a third request. And then I think they said I think I got an answer. They sometimes just answer it and give it to the pod officer, and she'll hand out papers at night, which is the response to your requests. And on that one, they said, you're already getting pain medication for this. That was the Tylenol.
And the pain medication is just regular Tylenol?
Regular Tylenol.
Okay. At some point, did you have an opportunity to speak to someone in medical care regarding way to resolve some of the pressure
snarky.
in your leg for use of a medical mattress?
Yes. So while I was down with the doctor during one visit, she said, you know, what might be helpful, because you're sleeping on metal and the mattress is maybe a half-inch thick, maybe. She said what would help is if I could get a medical mattress for you. I had never heard that term before, but I said, okay.
Well, in jail, they probably call it a medical mattress. That would be great. It's a thicker mattress because it's assigned specifically to you.
She left the room, she went into another room, and then she came back in and said, yeah, I thought that would be a good idea, but they don't have it here. So my best thoughts for you would be to get a second mattress.
I mean, if you go to prison, they probably have some
and that might give
other
you some
mattress
relief at
options.
night.
Okay. And did you obtain a second mattress?
I did.
And this was while you were in the annex?
Well,
How did you get the additional mattress?
so the pod officer
It sounds like they gave her
asked
one.
one of the inmates to go where they
If anyone is confused that cots in prison are comfortable, I'm just gonna say cots in prison are not comfortable. Also, the bathrooms are also generally open to everybody, so people watch you poop. I think that when they do, like when they did all the dare stuff when we were growing up, depending on what age you are, they should have said, look, you're going to have to go in a room where other people look at you while you poop. You're not gonna have a door. Jail's not for you, folks. So yeah, the beds are gonna be really uncomfortable. I'm having a hard time. Sciatica's the worst, but also there are lots of people who have more difficult working conditions than your in custody conditions, ma'am. So,
They have extra mattresses. They have piles of 20, 30 mattresses there. To go get one of the extra mattresses and put it on my bed so that I had the extra mattress.
Okay. And during the time that you were allowed to have the additional mattress, did you get any relief?
Yes, at night, because I used to get the pains even if I was just lying down. And that definitely relieved some of the pain at night, so that was good.
Okay. And at some point, did they take the additional mattress away?
Yes, so on February 3rd, I was moved out of the annex.
It sounds like they were trying to accommodate her.
Protective custody in the main jail building. And since I've been there, the officer removed the second mattress.
Okay.
She said, why do you have this? And I told her why. And she said, well, you have this.
And
so they took it away.
Okay. And since the additional mattress has been taken away, have you started to experience worsened pain?
Yeah, it's worse.
Okay. And have you requested any medical treatment for that?
Ma'am,
Well,
the judge isn't going to release you from custody because you don't have two mattresses.
I spoke to the doctor.
That's not what's going to happen.
I don't remember the date. Shortly after it was taken away, I was down for a different reason, and she said...
Also, the court can order that she gets physical therapy and that she gets an evaluation and that she gets mattresses. I don't think they're going to let her out for that, but the court can say, yeah, I can order that you have two mattresses, and then there's an order from the court. We've seen other defendants come to court and ask for medical orders, especially defendants who can't get their glasses and what have you. It happens all the time.
I thought it was a good idea, but if you can't have it, you can't have it.
Okay. All right. Now, the relief that you got when you were able to have the additional mattress, did that completely take away the pain?
No.
Okay.
No.
And do you experience this pain when you're walking, sitting? What?
So, in the beginning, I was just getting it when I was walking. So it limited the amounts of walking I could do, but I get it when I'm sitting, I get it lying down, I get it all the time now. So it's not like I have it all the time. It comes and goes, but when it just comes, I could be sitting, I could be standing, it just happens.
Okay. We're going to go into more details about how it took place in a few more minutes, but for now I'd like to talk about, are there any other areas that you are experiencing any pain?
Yes, I have.
Kyle in chat asked, innocent till proven guilty. Yes, which is easier in cases where there haven't been multiple trials. In this case, there have been multiple trials, so there is much known about what's alleged about Donna. In other cases, there is not as much known about what's alleged against Donna. So especially for the law nerds that watched the trial against her son, Charlie, much is known about what she is accused of. So yes, there is a legal standard of innocent until proven guilty. There is also quite a lot of knowledge about Donna as she pens trial. So it gets a little bit harder with Donna. So yes, the jury comes in and she is innocent till proven guilty. The law nerds come in and we're like, ma'am, we've seen some things. We've heard your calls and we've heard the testimony of the people that talked to you in like the 5 other trials that have happened. So with Donna, it is legally true. It is intellectually more challenging for those that know about the case.
I have a problem with my left arm.
So
And
it is intellectually
describe to the
challenging
court
with
what that
Donna.
problem is, what you're feeling, what you're experiencing.
So I have like shooting pain from the top here of my shoulder down the outside of my arm into my forearm.
Okay, and you're pointing.
Donna's had all the same medical stuff I've had. So while I have a tremendous amount of empathy, it is hard. Shoulder pain sucks. It is the worst. Having a torn rotator cuff, not that I'm saying that she does, because I am not a doctor or an orthopedist, but having soft tissue damage in your shoulder is terrible. Could she have pinched a nerve? Sure. But also, it's going to be hard. Donna, I get it, but it's going to be hard. I feel for you. Shoulder pain sucks. Pain sucks. Being in pain sucks. It's going to get harder to have it treated in custody. Ask Harvey Weinstein. He's complained about his medical treatment in custody for years.
Pointing to your left arm, is that the one you're referring to?
It's my left arm.
Okay, and so shooting pain down the arm, anything into your hands?
Yeah, the pain is like, it's like hot. It's like a burning pain, and my thumb, index, and middle finger have gotten like tingling. It almost feels like ants are crawling on them. It's like a numbness
Like
of
numb.
those fingers.
Okay, and is this pain that
Well,
you were
there's the nerve pain.
experiencing prior to your incarceration at Lehigh County Jail?
No.
Okay, about when did this pain begin?
When somebody grabbed her arm, wasn't it? This was when she was attacked.
I was assaulted by another inmate while I was here at the beginning of October.
October of 2024?
Yes,
And when you say the Lehigh County Jail?
yes.
Okay. All right. Since you began experiencing that pain, since October of 2024, have you requested medical treatment?
Yes.
And what has the response been?
They said they would take an x-ray, but in the meantime, I could have Tylenol.
Okay. And you said that was in
The X-ray's
approximately
probably not gonna help
October
for
of
the issue.
2024. Have you been requesting
sucks.
treatment for that pain since October of 2024?
Several times.
Okay.
Yes.
And you heard the testimony of the gentleman previously. At some point, did they do an x-ray on your arm?
Yes.
And when was that?
It might have been February 3rd. No, that's the day I moved. It's shortly after February 3rd. I don't know the date.
The
Was
X-ray's
it
not
after
going to
you were
help a ton.
removed and placed in protective custody?
Yes, it was.
Okay.
So for those of you
Does the
asking,
Tylenol help
it
with
was in her motions that she got attacked by another inmate, that inmate grabbed her arm and put it behind her back and spun her around and was like, "You're going to give me commissary." And then she argued in her, which is probably going to come up in her bond motion, that she's being extorted for commissary by that inmate who's asking essentially for protection money. It's like, if you would like me to not again, then you're going to give me ramen. So Donna was put into protective custody, which she also doesn't like, but they put her in protective custody so it wouldn't happen again. So she's not happy about it. So we're going to hear the rest of her bond motion, but bond for medical issues generally doesn't go very far.
The pain that you're experiencing?
No.
Especially with these charges.
After they performed the x-ray, were you called back into the medical unit?
It was for another reason, but they did call me and they told me that that the x-ray showed no fracture.
Okay, no fracture.
Probably
That's what
not
they
a
were looking
fracture.
for.
That's what they were looking for.
Did they offer any type of physical therapy for your shoulder, anything at all?
No, I asked if they could do anything for it, and they said no.
Okay.
Tylenol.
All right. Do you have any other medical conditions that you wanted us to address in the bond hearing that you're suffering from?
So I have a hearing issue.
Okay.
I have a problem. Evidently have.
I've only heard the defense attorneys say they can't hear in this court. Has she seemed like she, I don't know if y'all have interacted with people who, as they have aged or otherwise, have difficulty hearing. She doesn't seem to have an issue hearing her attorney.
Have very narrow ear canals, and so
My perspective.
Get the wax builds up in my ears to the point that, I mean, I have officers that say to me, "Are you deaf, Adelson?" When I don't respond
You should say
to them,
yes.
it's because I don't hear them.
You should just say
And
yes.
So I
Yes.
did ask for help in the, I asked the doctor if there was anything they could do for me, and I told her what's normally done, and she said, we use Debrox to soften the wax, and then you come down 3 or 4 days later, and we use a bulb syringe to remove it. And I said, that doesn't work. I need a different procedure. And she said, that's all we can do for you.
Okay. And did you know, based on your prior treatment before you came into the Leon County Jail, that it required something other than the flushing system?
Yes, I did know.
Do you recall the name of the doctor that you saw for this condition?
Yes, I've seen him for years. Dr. Molina.
Okay. And Dr. Molino, how long do you think that you saw him for this condition prior to your incarceration?
I mean, several years.
Okay.
4 years, 5 years, I don't know.
Okay, and during the course of his treatment for you, how often would you go to have the wax removed from your small ear canals?
Yeah, every 3 to 4 months. If I waited longer than that, I couldn't hear.
Oh, she was going to rely on the salt water and vibes.
Or did he do something different?
The freedom was going to keep it.
What did he do?
Keep it going.
He used some kind of, I don't know what it's called, but it's some kind of an electronic device that he puts one end in my ear, and he's able to
Wait, where's the other end
remove
go?
the wax
Donna.
using that device, that medical device.
And in your experience prior to incarceration, when you were having that procedure done, did your hearing improve?
Immediately.
Okay.
Yeah, immediately.
Yeah, approach the witness, Your Honor.
You may.
Mrs.
Literally.
Adelson, I've shown you what the
With my
defense was
glasses.
marked as Defense Exhibit 1 for purposes of this hearing, and it's a report from Dr. Molina, your doctor. Could you review that just to yourself for a moment?
7 dogs. For her, a Q-tip probably wouldn't work, to be
Does
fair.
that describe the
Even a hot
treatment that he
shower
was
with a
providing
Q-tip
to
probably
you?
wouldn't work. But
Yes.
Okay, and it includes a recommendation that you continue to receive the same treatment.
She seems to also be able to
potentially
hear-
with another ENT in Tallahassee, is that correct?
discomfort in her personal life versus whether the jail determines that this is a treatment she needs to be sent out for are going to be two very different things. And if she can hear well enough, they're going to be like, you're fine. Like the sciatica and the nerve pain in the shoulder are going to be a bigger issue than the ears.
Yes.
Okay, this time the defense would offer Defense Exhibit 1 into evidence.
Any objections to defense 1?
No, sir.
Defense 1 is admitted.
But I do appreciate that she doesn't seem to be trying to play up not being able to hear at all. She doesn't seem to be going like, she doesn't seem to be feigning she can't hear. So
During the time that you have, without disclosing any of the conversations,
There
of
is
course,
that.
but during the course of the time that you have met with counsel at the jail, have you had difficulty hearing us while we're trying to discuss your case with us?
Yes. I
And what
do.
about over the telephone? Are you experiencing difficulty hearing us in that way?
Yeah, the telephone is a problem.
Okay.
I also wonder how much background noise is the issue, because she seems to hear fine in court, but background noise in custody may be an issue. But again, that's going to be an issue in custody.
Have you actually gotten in trouble by some of the guards at the jail because they've
Dr.
instructed
TJB,
you to do
thank you.
something and you weren't able?
Yes.
Has that happened on more than one occasion?
It happens on several occasions.
We have some APD over at this house, Doc TJB.
And have you experienced over the course of your incarceration that your hearing is getting worse and worse?
Oh, yeah.
All right. This is not a significant, I'm going to move on to something else now, and this is not a significant injury, but I did want to address this with respect to the type of medical care that you are getting at the jail. Did something happen to you recently where you cut your arm?
Yes.
Okay. Tell the court what happened, please.
So I was walking past the washing machine on my way to the restroom, and I bumped into there's like a metal bracket that holds the washing machine in place, I guess, and it was my fault. I bumped into it.
And what happened?
So I cut my arm pretty badly.
So what did you do after you cut your arm?
So the timing was
I mean, the
interesting
treatment
because the med nurse
was a Band-Aid,
there
so-
doing morning meds. So I got onto the bleeding wouldn't stop. It was just pouring out. And so I figured I'll get on the line with the other girls and I'll speak to the med nurse. So I waited my turn and I got to the med nurse and she says, "Whoa, what happened to you?" And I said, "My fault. I just bumped into the machine and I cut myself." So she looked at it and she said, "Yeah, that's a problem." I said, "Yeah, can I get a Band-Aid or gauze or something, some antibiotic cream?" She said, "Yeah, I don't have any antibiotic cream and I don't have a Band-Aid." So I looked at her and I said, "Well, what should I do?" She says, "Well, why don't you use your toilet paper and put it on there?" I said, "But it's gushing. I can't put toilet paper on there." So one of the girls saw me and she said, "Oh my God." And she came running over and she opens up a sanitary napkin and she put it on there.
That's actually probably a better option.
So that it was filling the sanitary napkin with blood. And so another girl came over. She took the bloodied one away and she gave me hers too. And I was applying that. I said to the nurse again, "We're not going to be able to stop it. Holding this, isn't there something you can do?" She says, "The best I could offer you would be to fill out a medical request form." So I said, "You want me to do that now?" She said, "Yes." I said, "Okay, can I have a medical request form?"
I mean, it sounds like the other
She
inmates
says, "Oh, I
tried
don't
to help.
have any." I said, "Well, what am I supposed to do?" And she said, "I don't know what to tell you." She's maybe the night nurse.
Okay. So this was just a couple of days before you were transferred to protective custody, correct?
Correct.
Okay, but do you recall that it was on Saturday, the 1st of February?
It was a Saturday morning, yes.
Okay. And so about what time of morning would this have been if this was the morning med nurse?
It could have been 9 or 10, somewhere in the morning.
Okay, and when she told you that she didn't have any sick call forms for you to request a Band-Aid and you would need to get it from the night nurse, approximately what time does the night nurse come?
So the night nurse comes anywhere from 11:30 to 2:30 in the morning.
11:30 p.m. to what time?
2:30 a.m.
30 a.m.
Right.
And in the meantime, you were supposed to use the feminine pads?
I called my husband. He told me to elevate my arm, to wash it, to try to wash it frequently, just to keep my arm up. And that's what I did. And one girl brought over toilet paper, but that was sticking to the wound, so that wasn't good. So I kept borrowing sanitary pads to hold it.
Okay. And at some point, did the night nurse come?
Yes, she came that night.
Okay. And what happened when she got there?
She didn't have a Band-Aid either.
Okay.
She didn't have antibiotic ointment either. And I said, "This has been going on since early this morning."
Judge, I'm sorry to interrupt, but I just turned around and noticed that some of the state's witnesses have re-entered the courtroom. We had previously invoked the rule for the bond proceeding.
All right. And for anyone who is here to testify concerning bond, please step outside the courtroom. Ms. Dugan, is any witness you're intending to call currently in the courtroom?
I don't see any. I'm calling Miss Wilson and Deputy
Yeah, the no
Collins.
medical kits is... The no
Please
medical kits...
continue with your examination,
Like,
Ms. Fulford.
is
Thank
there
you.
not a Band-Aid
So
somewhere?
the night
However,
nurse came and the night nurse didn't have a Band-Aid either.
No answer.
the other inmates were like, "Girl, we got you." So That's helpful.
Antibiotic, no Band-Aid, and no, and no.
But not having any
the form
Band-Aids
that I was told to ask her for, the sick call form.
Okay.
She said, I don't have them. We haven't had them in a while.
The night nurse.
The night nurse.
So how are you supposed to request, according to the night nurse then, how are you supposed to request assistance?
So I was actually fortunate because there was a sergeant with the night nurse. She accompanies the nurse when she comes there. And she took a look at what I looked like, and the night nurse said, yeah, that's a problem. And so the sergeant said, I'm going to make sure you get a Band-Aid, and I'm going to make sure you get a form. You'll get it by tomorrow. When I go
You're
back
telling
with
me
the
that
night
everyone
nurse,
in the jail
I'm gonna-
tried to
she said,
accommodate
"I'll
this and
run
also
some off
agreed
on the machine, some copies,
that
and
it
I'm
should be
gonna make
taken
sure
care of?
that you get it."
And did she?
The next morning.
Okay.
So you're
next
telling me
morning
the
I
night
got it.
nurse, the other inmates, and the sergeant all said, yeah, we should get that taken care of. We're trying to get it taken care of. And then they got it taken care of.
From the sergeant?
From the sergeant, yes.
Okay. You got the Band-Aid and the call nurse?
Yes.
Call form?
The call form.
Okay.
It sounds like they all tried to make it
Yeah,
help.
where's the witness, Sean?
You may.
So,
Yeah.
and for those of you asking,
Listen, I'm
look,
showing you what the defense has marked.
she bumped into
as
something
defense
and cut her
exhibit.
skin. Our skin changes as we age. It got handled. But again, it's not going to be a reason for bail.
Do you recognize what's in that photograph?
Yeah,
And what is that?
that's a few days after I got cut, and that's the clear Band-Aid that they gave me to put on top.
Okay. After
Oh, she has a
you
picture of
got
her
the bandage to put on over your
the court.
wound, did you get additional medical treatment for the wound?
So no,
The
not
jail
then, about
testified that they checked on you like a week later to make
how
sure it
many
didn't
days
get
later,
infected.
but when I went down to medical a few days later, they said, how long are you wearing this bandage? And I said, I don't know, 4 or 5 days, whatever it had been.
Dr. Russell would have made Band-Aids out of a bed sheet and handled it like a boss. She would have been like, wrap that up, tie it, we're done. Dr. Russell would have handled it in about 7 seconds.
And they
MacGyver
said, this should
style.
have been cleaned and changed every day. Why didn't you have that done? I said, I don't know. This is what they gave me to put on, and that's what I did.
Okay. The photograph, does that truly and accurately depict what your injury looked like the few days after it occurred with the bandage on it?
That's what it looked like.
The defense would offer Exhibit 2 into evidence.
An objection to defense 2.
No, sir.
May I approach?
Your Honor,
may.
the defendant cut her arm. You have a picture.
And at this
of
follow-up
her
visit,
arm.
then did they change your bandage and clean the wound?
They cleaned it, and they put antibiotic cream on it, and
Okay.
they changed it, yes.
And did you get any additional treatment for the wound?
No.
Did you request that you get a tetanus shot?
My husband said, Donna, there was if rust on that metal, which there was, he said, you should ask for a tetanus shot.
And so did you request
So
it?
I requested it, and they did give it to me.
Okay.
So you asked and they handled it.
And then, as far as your medical conditions go, the last thing I want to talk about is something that I would give 2 different descriptions of, but I'm just asking the questions. You're the one providing the information to the court in your testimony.
Okay.
So this shortness of breath or heavy breathing that you're experiencing, how long has that been going on?
It's been going on several months, probably at least 3 months, I would think.
Okay. And you're experiencing it then during your incarceration. Did you have it prior to being incarcerated?
No, I did not.
Okay. What have you noticed about the breathing and how would you describe it? Shortness of breath, heavy breathing, what?
I know, I guess it sounds like heavy breathing. It's shortness of breath. I've never had that before. I'm not.
Her husband, I saw a lot of you ask, why isn't her husband in jail? Her husband and her daughter have never been charged. From what I've seen about this case, there is some evidence and direct evidence tying Donna to all of this and actions taken. I don't think there is that same type of evidence of direct actions taken from either her husband or Wendy. So it's going to be harder to pull them into the conspiracy and the solicitation if there aren't conversations, text messages, or connection to either the middleman or others that Donna had and they don't have. Also with Harvey, there was a spousal privilege there. So if they don't have him in other ways doing things, it's going to be much, much harder to charge them, even if they may have known. They may have known, but there has to be enough evidence to tie them together to it, independent of what Donna says or what Charlie says. So I don't know if there's enough or will be enough evidence to charge them, because part of charging Donna involved conversations that were recorded and an operation to record them and more. So you need a little bit more to tie people in. Donna also handed off money, so there were direct actions taken by her that weren't, and that I've seen no evidence. They have evidence like that with regard to her husband, Harvey, or the daughter, Wendy. I haven't seen any of that. If it exists, I have not seen it. So knowing and participating are different, and proving what somebody knew without any actions, text, emails, is incredibly difficult.
Not a doctor. I don't know. I've gained more than a third of my body weight here. The diet is all carbs, no protein, and when you get spaghetti with mashed potatoes, cornbread, and white bread, that's your dinner. That's very typical of what we get. And we've had no exercise at all. We're confined, especially in the annex. The annex, we've been confined to our beds almost all the time. Once in a while, we get a pod officer that lets us walk, so you can walk in a circle around the girls' beds. But otherwise, there's no, even if you want to get off your bed and just try to do stretches or wall push-ups or anything, she says, this is not an exercise room. There's no exercising here. We don't get taken outside.
Let me stop you. One of these issues at a time. So with respect to the time period when you've been in the annex, which was from August of 24
Donna did
until
not Google what
recently,
prison was
February of
like,
2025.
or what jail was like. I would
Was
say
it your
no.
understanding you're supposed to be taken out?
If Donna wanted different conditions, because again, local custody is different. If Donna wanted different custodial, I don't know if they offered her a plea deal, but prison might have different accommodations. Also, it's, there is a difference between state crimes and federal crimes. Donna, I'm sure that the diet is not ideal. And gaining weight can change your breathing. I am sure it's not ideal. I don't think it's grounds for bond based on the charges against you, though.
Outside a certain number of times.
Well, the inmate handbook says you get a minimum of 3 hours of outside time per day.
Probably not when you're in.
I'm sorry, per week.
Okay.
Probably not
and
when
during
you're
your
in
time
protective
in the
custody,
annex,
though.
did you experience a week where you got
She's in
3
jail
hours
still.
of time outside?
She hasn't been convicted yet, so she's
We
in
haven't gotten 3 hours in 6 months.
local
Okay.
custody. Not
How many times did you go outside
federal
while you were in
custody,
the
not
annex?
Before
Prison
we
custody.
continue, Mrs. Adelson.
Yes.
We have 30 minutes left in the hearing. Ms. Fulford, I understand your client is disputing the adequacy of the care. We do need to move to the most pertinent matters. Please continue.
counsel. I don't want to hear about what's for dinner. I don't want to have a conversation about why mashed potatoes, spaghetti, cornbread, and white bread don't go together. We're not having that conversation today. Can we get to the most pertinent lack of care?
Okay, we're going to move off of that then. I do want to talk to you then about some physical issues that have taken place in the jail. The first one I want to talk about is an incident that took place in the shower, and we're going to do this one briefly. I'm sorry, how much time did you say we had, Judge?
30 more minutes.
And also,
Including
local
argument?
custody is generally not for
Not
longer
including
term
argument.
stays.
Okay.
So
All right.
it's
So,
harder for those who are
the
in
first
longer
incident that
waiting
took
for
place in the
trial.
shower, could you just briefly describe to the judge what happened there?
Yes, so I always, there's 7 shower heads, but I always take the same one because it's off in a corner, so I have a little bit more privacy than you'd have at the other ones.
Yeah, group
So
showering
I
also
would always shower there,
sucks.
and I was under the shower, and I was washing my hair.
She, in her motion, also talked about being assaulted in the shower. So that, I imagine, is what she's going to talk about at the moment.
And I was the only one in the shower. I always go in early morning because there's nobody there. Most of the girls sleep, so I take a shower and I have a little privacy. And so I was washing my hair, and all of a sudden I felt a hand go up my back, like from the top of my butt up my back, and I yelled, "Stop it!" and I turned, and this girl said, "You like it?" And I said, "Get out of here!" And I started to scream, and she ran.
Okay. In the bathroom there, what was this? Which pod was this in?
This is in the annex.
In the annex. Okay. In the annex, are there guards positioned inside the area where you shower?
No.
Inside the area where you use the restroom?
No.
Okay.
And then they moved her. And then they
The
moved
next
her.
thing I want to talk about is what transpired in October of, thank you.
And then they moved
October
her.
of 2024, where you had said previously you were attacked. What were you doing? Where were you at, first of all, at this place?
In October. So I was in the bathroom. It's 10:30 at night. I went in to brush my teeth.
Okay.
There are three sink stations in the bathroom. Each one has 4 sinks. And I was at the center station with my back to the door. And I'm a righty, so I was holding my toothbrush with my right hand. And I was balancing myself with my left hand on the sink. I was just brushing my teeth. That's all I was doing.
And what happened?
And someone came up behind me and pulled my left hand away from the sink and twisted my arm and like jerked it behind my back, like reaching up toward my neck.
Okay.
And
did it hurt?
Yeah, it hurt.
Okay. What happened?
It hurt. And I said, "What are you doing?" And she's, in the same breath that she did that with my arm, she said, "You're going to buy me commissary." I said, "I'm going to what?" And she said, "Unless you want those pretty white teeth knocked out of your mouth, you're going to buy me commissary." So I said, okay. And then she named a package that she wanted, and she's out. She was gone. She just that fast. That fast.
Okay. How bad would you, on a scale of 1 to 10, how bad would you rate the pain at the time that she did that to you?
Oh my God, it was a 10.
Okay.
I didn't know my arm could reach that far back.
Okay. And what did you do after she did that to you?
So, kind of stood there for a minute, and then I just thought, okay, I'm gonna go back to my bunk. And I went back to my bunk and I got under the covers and I cried. I just stayed under my covers. I didn't come out.
Okay. During your entire time in the annex, did this particular inmate remain confined in that area with you?
She was in the annex the whole time.
Okay. And I know that you don't want to talk about who did this to you, because why? Why don't you want to disclose who it was?
There's one thing I've learned since I'm there is you don't, the word is snitch. You don't snitch. You don't tell on anyone because you'll be sorry you did.
That's
and
true.
I've seen that. And so,
She's like, so I give her the commissary.
For a while, I wasn't going to tell anybody. I didn't want to tell anybody. I didn't want. She's a big woman, and I was afraid of her.
Okay. Approximately how tall would you say
I
she
don't
is
doubt that
compared to
Donna's
you?
afraid.
She's over 6 feet. She's
Okay.
over 200 pounds. She's
Okay.
a very large woman.
Okay. Were you afraid of her?
Yeah.
Okay.
Yeah.
I don't doubt
was
that she's
after
afraid.
that.
Okay. And you said that she demanded that you were going to start getting her weekly commissary. Did you do that?
Yes.
Okay. Let me, can I have just one moment, Judge?
Go ahead.
Melly asked, can this be used against her later in trial? This isn't really relevant to her trial. It's relevant more to her motion to be out of custody. I don't doubt that she's scared in custody. Are these the worst instances I've ever seen happen to someone in custody? No, not at all. Should people put hands on each other? No. Do they? Yes. It is almost an inevitability. It shouldn't happen, but it does. Am I surprised that somebody said, you've got money, you're getting commissary, I want commissary? No, that doesn't surprise me
Your Honor,
at all.
in order to
But
move
I don't
this
doubt
along
that
a
she's
little,
scared.
more promptly, I've requested of the state, and they have no objection. At this time, I'm going to offer into evidence State's Exhibit number 3. I'm sorry, I said state by
And then they
mistake.
put her in
Defense Exhibit
protective
number 3,
custody.
Defense Exhibit
And
number
again,
4, and Defense Exhibit number 5.
It seems like the jail has responded within the best of their ability to most of the things that she has brought up. She doesn't like being in protective custody either. Protective custody also sucks because you are isolated. But what is the balance there?
Objection, Ms. Dugan.
No.
May I?
They are admitted. Thank you.
So I don't.
Prior to ordering
I don't
commissary
disbelieve
for
that she's
this,
scared.
this woman who attacked you, were you getting commissary for yourself?
So I have an account, and you can buy up to $40 a week of food, and so I use that account to buy food, but not what she wanted. She wanted packages.
Okay, let's make sure the court understands. When you say buy food, is there?
I saw some of you guys asking. Commissary has all kinds of things. It just depends on the jail, but packaged foods, sometimes deodorants, sometimes things like mascara. It just depends. The commissary and the level of custody, I think they differ between prison and jail, but commissary is you can use your own money, or if people put money on your books, to buy things. In the Murdaugh case, we talked about him trading beef sticks because in one of his jail calls, he was talking about getting up on everybody playing cards, gambling beef sticks. So commissary is often foodstuffs and sometimes other stuffs that generally become a means of monetary value. So you can get it just depends. You can get all kinds of stuff in commissary, but yeah. So that's what it is. And they become a whole part of the bartering system within custody, because custody has its own rules, its own bartering system. And I imagine that changes regionally, but I mean, they've got their own alcohol. It's a whole different ecosystem.
Normal commissary
One that Donna
for the
is
jail,
not
you were getting
well
your
familiar
commissary.
with.
Yes.
Okay, and that's what you were spending $40 a week on for yourself?
Aramark, yes.
Okay, and
he's getting more
what kind of
from
items
it,
are you buying for
seems.
yourself off of that?
I try to get some protein. I buy tuna fish with mayonnaise and
Substitute meals, if you will?
Yes.
Okay, no noodles of any kind?
no.
Okay, all right.
No.
Now, is there a separate way that you can order
Her
commissary?
attorney just asked no noodles of any kind. I guess we know what is being purchased. Did I say alcohol? Yes. Bruno. People ferment things. You can ferment things. So things get fermented. Mm-hmm.
On the outside
Generally in
for
a toilet.
inmates?
Yeah, I can't do that. It would have to be ordered from somebody. You have to ask somebody outside to place the order.
Okay, and when you referred to packages, is that the method that the woman who attacked you said she wanted you to get for her?
That's what she asked me to get her, yes.
Okay, and these packages cost about $40 each, is that correct?
40 and then $10 for packaging or shipping, so it's $50 a package.
Okay, and during the course of your time in the annex, while you were still in the annex, on just about every week, did she continue to find you in the bathroom and demand what packages that you would get ordered for her?
Yes.
And
She must have been keeping an eye on me, but when I was in the bath, those are the only times she would approach me is in the bathroom, and she would tell me what she wanted for that week.
and did you?
Which is why most prisons have open bathrooms where you can see in, or depending on the level of custody, have openings so you can see in, so stuff doesn't go to shit in the bathrooms. But when you do have closed bathrooms, things often go to shit in the bathrooms. So it is a thing. But
make those orders through your husband?
I called my husband. I didn't tell him what happened. I just called him and said, honey, I want some extra food. Would you mind ordering some packages for me? And he said, sure, honey. And he did.
And he did that. And at the time that your normal canteen or commissary would be delivered, is that when the extra packages would be delivered as well?
Yes, all at the same time.
Okay, and in the course of things, you would go pick up your canteen and then her extra packages, is that right?
Yes.
And where did you keep her items when you got back to the annex?
So it was, you have to carry your bin up, and they put the package, they open up a plastic bag and they loosely put all the stuff in the bin, so.
I don't
it was
even know
all
how they
in a
deliver
bin
your
that I would
commissary.
Put under my bed.
Okay, and did you keep her eye care packages separated from your canteen?
Yes.
Okay, and how is it that she would receive her packages? How did she get the
So
food?
she would send, I used to say her minions, she used to pick different girls to come over to me, and they would say, package up 4 soups and 3 bags of chips. And the first time I didn't know what she wanted me to do, and she said, it's for, and she'd mention her name. And I said, well, how am I supposed to do that? She said, just put it in your shirt, I'll meet you in the bathroom. So I would load these things in the top of my shirt, and I would hold the bottom of my shirt like this so that nothing would fall out, and I'd go to the bathroom, and then somebody would follow me in there, and she would take it out, transfer it into her shirt, and walk away.
And that continued from the time that she first yanked your arm behind your back in October all the way till you were put into protective custody, is that right?
Yes.
Okay, when you got into protective custody, in fact, did you receive your last packages for her?
So the last package came, I was put into protective custody on a Monday, and Tuesday, the commissary came with those packages and brought them to me.
Okay, and do you have that extra food in your protective custody room now?
They're sitting there. I don't eat that stuff, so it's all sitting on top of my bunk.
It's made up of noodles and chips and
I
things
imagine that the guards will redistribute that for you.
Okay, all right. I want to talk briefly about your time in protective custody. How big is the room that you're in?
Okay, ma'am.
6 by 9.
Okay, and are you in this room by yourself?
Yes.
And is the door, with the exception of when they allow you to come out, is the door kept closed all of the time?
It's supposed to be kept closed.
Okay, all right, and you're given, I'm kind of leading here, Judge, to try and get us through this, but you're allowed to come out of that room 1 hour per day on Mondays, Wednesdays, and Fridays, is that correct?
That's correct.
And on Tuesdays and Thursdays, you get to come out for 20 minutes, is that
20
right?
minutes.
Okay, and on the weekends, you don't get to come out?
Not at all.
Okay, make sure you don't talk over me, okay?
I'm sorry.
That's okay, we're talking over each other.
Okay, I'm sorry.
So Saturday and Sunday, you don't come out at all. During your hour 3 days a week and your 20 minutes 2 days a week, is that when you're given the opportunity to take a shower?
Yes.
If you have time to walk, that's when you walk?
So on an hour day, I'll walk for 40 minutes or about, and then I'll take my shower at the ends of that, so I get my shower in.
Okay, and laundry also, that's what you use that
All
time
of that,
for?
yes.
I know
Other
she
than
wants
that,
to
you're
be
locked
released.
inside that room?
Yes, I am.
But in the balance of what
Now-
she's charged with and what
It was your understanding
she's
when you were put
alleged to
into
have
protective
done
custody
vis-a-vis
that
what's
there's not ever supposed to
happening,
be anybody out around you, is that right?
this
what
is
I was
not going to be
Okay, but
persuasive.
protective custody is actually attached to a pod, is it not?
Yes.
And what pod is that?
M-Pod, like Mary.
Okay. At some point, did you learn that this individual who attacked you was also, at least for some period of time, in that same area?
I'm not sure where she was. She might have been.
Okay.
I didn't see her.
You didn't see her?
I
Okay.
heard that she was there, but I didn't see her.
Okay. Now, you have testified earlier that different guards have kind of different rules that they follow inside the jail. Is that fair to say?
That's fair to say.
Okay. During the time that you've been in protective custody, when you were told you should not be around anyone else in the pod or otherwise, have there been times when guards would have you around other inmates?
Yes.
Okay. Was there an occasion where another girl came and knocked on your door wanting you to give her food?
Yes.
Yes, okay. And what happened when you said you would give her food?
I said I have all that extra food. I don't mind giving it to people.
I bet people are going to be knocking on her door.
Well, that's what I said to her. How am I gonna
They now know you
get
have
this
chips and
to you?
noodles.
And so she gave the guard a high sign, and the guard buzzed the door open, and it was her and a friend of hers, the two of them, and they'd only stepped in my foot, came in, and I gave them some soups.
Okay. Is that the only time that you've been around other people since you've been put in protective custody, or have there been other situations?
There have been other times, like yesterday, the officer buzzed my door, so I guess there was something she wanted me to do, so I opened my door, And I came out, and there were maybe, I don't know, half a dozen girls watching TV. I walked past them, and I asked the officer, "What did you want?" And she said, "Miss Adelson, I didn't mean to buzz you. Just go back to your room." I said, "Okay." So I turned around and went back.
Okay. We have to move along a little bit faster here. So one of the things that's been a big
I do appreciate
for you
her
is lack
attorney
of
being like-
sleep. So we're going to just kind of go through this quickly for the court. But you testified previously that the nighttime medications come between 11:30 p.m. and 1:30 or 2 a.m. Is that correct?
Yes.
Okay. And part of the nighttime medications that you get, is there something in there to assist you to go to sleep?
Yes.
Okay. And then you get the medication. About how long after that is it before you can go to sleep?
From the time I get it, probably a half hour.
Okay, all right. And what time are you woken up for breakfast?
Between 3 and 3:30.
Okay.
Last night was 3:10. Just within that half-hour range is when it comes.
Okay, and once you're woken up for breakfast, are you capable of going back to sleep?
No.
Have you tried to go back to sleep?
Oh, my God. Yes, I try.
So
I'm sure some of you are going to ask, why in the ever-loving world are they giving anyone breakfast at 3:30 in the morning? Again, she is in local custody. Local custody is for when you are still dealing with the court process, haven't been sentenced yet, haven't gone to trial yet. Sometimes people are sentenced to local custody on misdemeanors and crimes under a year. But for all of you asking, why is breakfast so early? I'm going to tell you. Generally because a large part of the operations of local custody are getting people back and forth to jail. And those jail days are incredibly early. And depending on how large the staff is and how large the custody facility is, they're going to feed everybody at the same time because they've got to get people out for court. So if you've got to get on to the court bus to get out early, they are going to feed everyone early. Some custodies, they will have the pod or the group that's going to court and they will be the ones getting woken up early, and then others will not. But it really, really just depends on how large the facility is and how much staffing there is at the facility. So because they need to accommodate court transports, the schedules are a lot different than they are in like prison, where people aren't going back and forth as regularly to court because it is local custody and court is such a central part of local custody. So it really just depends on the staffing. So yes, it is a very, very early breakfast time. And I am sure it just messes with people's sleep schedule. But is there a reason for all of that stuff? Yes, there is reasoning for all of it. But the scheduling is wild.
So that period
Real
of
early.
that time that you get from the time you fall asleep after your night meds until you're woken up for breakfast, that's the only sleep that you're getting while you're incarcerated?
That's it.
How has that affected you?
So, listen, I know older people don't need as much sleep as younger people, but I need more than 2 hours a night. I need more than a good night is 3. One night I had 3.5 hours. It's not enough sleep to stay focused. I mean, I feel like I'm foggy sometimes because I'm just sleepy. I'm tired, and I can't go to sleep. They've got people screaming and yelling. They bang on the doors. They shake the doors. It sounds like a drum in there. It's horrible. So I can't sleep with all that noise going on. And
Okay. Do you have legal documents that we have provided to you or prior counsel has provided to you that you need to review to assist in the preparation of your defense?
say that to me again.
Sure. Do you keep legal documents with you that you're supposed to be reviewing to assist to prepare for your defense?
Sure. I've got two bins full of them.
Okay. Are you having difficulty completing the tasks that we're asking you to do because of your lack of sleep?
Yes.
Okay. All right. I want to talk to you for just a second. You're able to make calls to your lawyers off of your tablet, correct?
Yes.
And those are supposed to be attorney-client privilege calls,
Off
correct?
of your
Yes.
tablet.
Okay, and they're not recorded according to what's said on the recording when you make the calls, is that
That's
right?
right.
During the time that you were in the annex, were you in a situation where you could be away from everybody so that you could make those calls without anyone hearing?
No, I
It sounds
had
like
to make
she's-
the calls under my blanket.
Now in solitary.
Because you couldn't hear me, and I certainly couldn't hear you. So I would go under my blanket with the tablet, and I would call you that way.
That didn't keep the other inmates who were standing right next to you from hearing.
It is what it is.
Okay, was there a
I don't
time when
disagree
you
with
and I were
Donna
speaking?
on that. There's
and
not a
when you
lot
pulled
of
the cover,
privacy.
was a guard there listening to your call?
Yes, there was.
And during the time that you and I are having conversations, do you also experience the same kind of problems with the phone that you had heard that Charlie had while talking to you, where the calls are dropped, et cetera?
We've had it numerous times.
Okay. Are there times where we're not able to hear each other on the phone calls?
Yes.
Is there static on the phone calls?
It's static, and
Does
now
the jail not
you've
have
been
an
complaining
in-person
because I have this
visiting room?
this shortness of breath, so you say I'm breathing very heavy, and it's hard to hear me.
Okay.
So it's difficult.
All right. Let me ask you a few questions.
I mean, Donna,
we're
there's a
requesting
microphone right in
that
front of your
His Honor
mouth, and maybe I am being overly critical, and chat and comments will let me know if I am. There's a microphone right in front of her mouth. She's saying that when she's on the phone, her breathing is so heavy she can't hear her attorneys. There's a microphone sitting in front of her, and I have not heard breathing that has been so noticeable that we're distracted by it. And this is a chat that can get distracted by breathing. We have been. There's been witnesses on the stand breathing onto the mic like they've just run a marathon, and all of us have went, oh my God, stop it. There's a judge that we're all thinking of that just sighs right into the microphone, and all of us go, stop. Stop. So, of all of the complaints, she can't hear the jail calls is not really landing with me, to be fair.
allow you to be out on bond pending your trial so that you can assist in the preparation of your defense. If His Honor ordered that you reside here in Leon County and not leave Leon County until the conclusion of the trial, would you agree to do that?
Yes, of course.
If he placed you on an electronic monitor, would you agree to take that?
Yes.
Okay. If he required that you have a curfew from 7 o'clock at night until 7 o'clock in the morning, would you comply with the curfew?
I would do that.
Do you have the ability to do
What
these
do you mean
things?
7 to 7
Yes.
curfew? If you have murder charges, you're not getting a 7 to 7 curfew. You're getting full house arrest except for lawyer meetings. You're not rolling out and going to Starbucks.
The ability to get housing here in Tallahassee where you could live with your husband.
Sure.
Okay. And if he said that, you can leave
Yeah, they
outside
didn't
of
let
the
Diddy
curfew,
out either,
you can leave to go
ma'am.
meet with your lawyers, medical appointments if you need medical appointments, coming to court, those type of things. Would you comply with those orders as well?
Yes, I'd be grateful just to get a night's sleep. It would be great.
Okay. If he ordered that you had to surrender your driver's license during the pendency from now until the end of the trial and not drive, would you agree to comply with that?
Yes, I would.
Have just one moment, please. For the medical conditions that you have complained of during the time that you were speaking with the doctors and they said that they didn't give you the treatments that you were requesting, did they ever offer that they would have a doctor from the outside perform the treatment for you?
No.
I don't have anything further.
Student cross-examination.
Yes, sir.
Oh, I'm very interested to hear the cross-examination from the prosecution on this. Again, she is on the stand for her bond hearing about the conditions of bond. So the cross-examination isn't going to go beyond those boundaries, and we will see it really stick to conditions of bond. I expect probably be pretty short.
All right, so the incident in the shower after you left
Laura,
the inmate.
I'm not judging anybody that feels bad for Donna. Everyone's going to have their own level of how they feel. There should not be mistreatment in custody. I don't know if Donna has been mistreated in the way we've seen in other cases in custody. They are not ideal circumstances. They aren't. I think she is probably quite scared and anxious and feels vulnerable. But also, I don't know if the balance of that is to release her where she can flee, harm herself. There's also a balance of you need to stand trial for what you've done. Even in Tom Girardi's case, they have sent him out for evaluation to see if prison is going to be the right result for him when he is sentenced, to see if they can meet his medical needs. There is room for that. But also, some of the conditions she's complaining of are, it took me 6 hours to get a Band-Aid and I'm not getting enough sleep. Okay, that is unfortunate. That is unfortunate. However, I don't know what else they can do. She had instances with other inmates. They put her in protective custody. Is that an ideal solution? No. Is it probably the only workable solution? Yes. But do I think that Donna's a risk of flight and a risk of harm to herself based on her calls? I would be concerned. I would be concerned.
Know that you did not like what she was doing by telling her to stop. Did she ever try that again?
No.
And that inmate's no longer, or you didn't disclose the name of that inmate, but you did tell the investigator that that inmate is no longer in jail with you, right?
She's no longer there. She left shortly after that.
Okay. As far as the arm twist incident from October of 2024, you said you reported that in February of 2025?
Yes.
Okay. And you wouldn't give the name, you said you wouldn't give the name of her to the investigator either, okay?
No.
But if you would give her name, that instead of you being separated from the pod, she could be separated from you and you could be back with the general population.
Yeah, but she's not the only one that could hurt me. That's why I wouldn't do it. She had a half a dozen girls that came up to me.
Was there ever any physical violence by her or anyone she's friends with after that October 25,
it's a reasonable concern.
Incident?
No, that was it. That's it.
The reasonable concern
by
is
being in
the
solitary.
DA asked, you were told if you told jail staff which inmate it was, that they would separate that inmate from you instead of you being separated in isolation. And she said, yeah, but it's not just her. There are also others. It's a reasonable concern, but there's not that many ways to mitigate that concern.
Confinement, does it give you an opportunity to have a quieter space where you can prepare for trial?
I guess it would be a quiet space if I could get some sleep and I would be able to concentrate on what I'm supposed to do. Yes, that would be helpful.
Do you also get in-person visits with your attorney in jail?
I do.
Okay, and when that happens, are you in a room alone with him or her or both?
Yes.
Okay.
Yes.
And y'all are able to
In-person.
have conversations then that are private?
Yes.
For the sciatic nerve, in December of 2024, were you offered a Solumet, a steroid injection for that pain that you declined?
I am going to object to the use of the medical records by the state based on a prior objection.
Student, do you have an ability to show that these records were not a part of what was obtained by Investigator Newlin that is still disputed?
No, these are part of what was obtained by Investigator Newlin, but my understanding is that the defense opened the door to this by asking her all of these times she was seen by medical staff and what basically was not done for her.
As to that, I will permit the witness to answer. You may answer, Ms. Adelson.
Could you ask me one more time?
Yes, ma'am. For the sciatic pain that radiates down your right leg, were you offered a Solumedrol, a steroid injection, and then after that a Medrol, so a steroid dose pack, that you declined until you were able to speak with your physician?
No. I told her that in the past I had gotten a steroid injection in my spine, and she said, we don't do that. I could offer you, and it was a Medrol dose pack, I think.
A Solumedrol injection?
I could offer you that, but we don't do that. And having had sciatica twice in my lifetime, I know what's been done each time, and I know that worked. And so
you said no.
She said, we can't do that. We don't offer that. You would need to see a specialist for that.
Okay.
So
I'm going to show you this
they said you
page.
can do a Medrol pack, and you said, I want to do an injection. And they said, we can't do that. And you said, well, then no.
3:22 p.m. Does it say, offered patient a Solumedrol injection and then starting tomorrow a Medrol dose pack? Patient requests to decline until she can speak with her physician.
I don't know what a Solumedrol injection, but she told me they don't give steroidal injections in the spine. She says we don't do that. And I don't recall her offering an injection. I do remember she said I could give you other medication. But I've been there. I've done that. I know what happens with sciatica, and I know what needs to be done. That's not going to be the answer.
For your arm and shoulder pain, isn't it true that you reported you had mild pain in your left arm and shoulder?
No, I heard a gentleman say that before. I couldn't believe it. I told you that I had severe burning pain down the outer part of my arm. I never used the word mild pain. So I don't know where they got that from, but that's not what I said.
Okay. I'm going to show you the encounter from February 3rd, 2025 at 2:29 p.m. Under musculoskeletal, does it say positive for left upper extremity limited ROM range of motion, comma, mild pain?
That's what it says, but that's not what I said. In no way is that pain mild.
And so that's just what the doctor would have written down, but you're saying that's not what you told
She
the
disagrees with
doctor.
the
I
medical
just,
notes.
you know, had that been given to me and I read it and I had to sign it, I would say I never said this. But I'm telling you, I never said mild pain.
Okay.
It's shooting hot pain down my arm.
For that injury, you did have an x-ray. They did go over that x-ray with you and let you know that there was no fracture or dislocation.
There was no fracture, that's what she told me. I didn't think it was a fracture. No.
Or dislocation of your shoulder or arm?
No, there's just pain.
And they also went over your chest x-ray results with you to let you know that your chest x-ray appeared clear?
Yes.
Okay.
Holly, I agree with you. She probably doesn't.
You ultimately received the Band-Aid and
MRI.
Neosporin for the cut on your elbow?
Yes, I got that on, I think it was Saturday. When did I get that? On Monday?
Okay, so within a day or two of the cut occurring?
Yes.
And you said that if you are given a bond, you will reside in Tallahassee, you will follow court orders. But when you were afraid of being arrested, right, Shirley Adelson's trial, isn't it true that you hoped that you could get to the airport before you were arrested?
Exactly what she said on the
I
phone.
wasn't afraid of being arrested.
What were you trying to get to the airport in time
We
for?
hope we can make it in time.
In that jail?
I hope we can get out in time.
My husband and I literally
That's what she
shocked.
said. That's what she said. I hope we can get out in time. I hope we can make it in time. They're coming. I hope we can get out in time. Get out in time, I think, were her exact words. And the prosecutor's like, yeah, but when you were afraid of being arrested, you weren't hoping you were not going to miss your flight. I'm going to back up the question, and I'm very curious about the answer.
You will reside in Tallahassee, you will follow court orders. But when you were afraid of being arrested, right, Shirley Adelson's trial, isn't it true that you hoped that you could get to the airport before you were arrested?
I wasn't afraid of being arrested.
What were you trying to get to the airport in time for? In that jail
My
cell?
My husband and I were literally shocked and traumatized at what had happened to Charlie. And he said, we need to just get some peace. We need to catch our breath. We're going to go away somewhere. And I thought it was a good idea.
But only somewhere that's a non-extradition, only somewhere that's a non-extradition country. Y'all. Only non-extradition. We just need to get some peace. Not a castle in Scotland. Only a non-extradition country. We need to just find peace.
Because I couldn't think straight. I really couldn't think straight. I was so upset, and so was he. And it was his idea. He said, sweetheart, let's go, just get away. We're going to just get away somewhere so we can have some time to think.
Think about what?
Okay, so your testimony is that you weren't trying to go to Vietnam because you wouldn't be able to be extradited from there.
So my husband actually had said, you know, we've been to Vietnam before.
The husband's getting herked right under the bus. Whoop! Just under the bus. You didn't take a 2-month ticket. Also with the, well, she said the sciatica didn't kick back up till she was in custody. I don't know how long the flight from Miami to Vietnam is. It seems like probably quite a lot of trial, but okay.
With friends, we were on vacation, and it really was like a place of peace. And so he said, if we go to a non-extradition country, then if the law enforcement decided that they wanted to arrest you or me, whatever, both, he said, we won't be sitting in a foreign prison waiting months to go back. We can buy a ticket and we can go home. And my understanding was that I could go home and I could turn myself in if that's what they wanted.
Okay, but you were...
I'm just, chat, you might get mad at me. You might, I'll take it. I'm just going to say, of all of the explanations that we've heard, it's not the worst explanation in the world. It's not the worst explanation in the world. I know that you don't believe her, but of all the explanations, she's going to try to say, look, I wasn't fleeing. I just think that I could just hop on a plane and come on back if it was a problem. I don't want to be sitting in prison in an extradition country. It's not the worst explanation in the world. And I can see from Donna's perspective, like, why would law enforcement make us do something? If we just say, I'll hop on a plane and fly back, I don't think it would be a problem. I can see her saying, I can see her A, believing herself, and B, it's not, I know a lot of you aren't going to buy it, but of all of the explanations I've heard for shit, this is not the wildest explanation in the world. But I do think she was fleeing. I don't think she would have intended to come back. I do think she probably said, I don't want to end up sitting in prison anywhere. Not just in the US, but anywhere. And if you get an arrest warrant elsewhere, you're definitely going to sit in prison until they extradite you. They knew that they were going to be arrested, which her explanation also takes into account. Her explanation takes into account the reality that she was going to get arrested. Again, I don't think that she was planning on coming back. She had an estate attorney helping to get her affairs in order. But I understand the reasoning, and it's not the worst explanation I've heard people give in court. It's, she's had some time to think about a reasonable explanation, or that's really how she felt. Do you guys think she was going to get on a plane and come back? Y'all, come on. I don't doubt that she was like, well, if worse comes to worse, we'll just get a flight.
We're hoping to make it out of America in time before you were arrested, right?
Yes.
I wanted to get away.
I wanted to get away.
He wanted to get away. That's what we wanted to do. And it wasn't, we spoke to our attorneys. I asked them. They said there's no pending. We purposely called them to make sure it was legal to do it. And they said,
I don't doubt she called her attorneys, and her attorneys aren't wrong, by the way, to say there's no arrest warrant for you. There's no warrant for you. You are not legally obligated to stay within the state of Florida. That also was true. I still think she was fleeing. But that also is true. There was nothing to hold her here. We talked about this during the Petito search with why Brian Laundrie wasn't arrested. And prior to him disappearing out of his parents' house, there was no warrant. He was a suspect, but there was nothing to arrest him on. Donna didn't think there was anything to arrest her on. But also she was getting her affairs in order. But yes, this is yet a different attorney. She has multiple. So I'm not surprised she's saying all of it. I'm not surprised.
There's no, there's no pending charges.
And to everybody singing Lenny Kravitz, I Want to Get Away, 10 out of 10, excellent timing, law nerds.
There's no warrants, so you want to go?
There's
go.
no warrants if you want to go.
So you ask your attorneys and they tell you that, I'm going.
But Dan did tell you, as you say in the jail call, that knowing what they're thinking up there, I don't know if you'll...
Where's the Southwest ad when we need it? Want to get away? Want to get away? But yeah, she's like, no, I wanted to get out. And they said, there's no warrant for you now. If you want to go, go. I imagine they also said, if you think there's going to be a warrant and you want to go now.
You'll make it out in time. I really don't. But that he said you might, or you might get to the airport.
I'm going to back this up just a little bit. These are the conversations. Some of this conversation is on those jail calls. So some of the content of this conversation has already been brought to light because of the jail calls. But the DA is quoting the jail calls.
That's what they wanted.
Okay. But you were hoping to make it out of America in time before you were arrested, right?
Yep.
I wanted to get away. He wanted to get away. That's what we wanted to do. And it wasn't, we spoke to our attorneys. I asked them. They said there's no pending. We purposely called them to make sure it was legal to do it. And they said there's no, there's no pending charges and there's no warrants. So you want to go. And so you ask your attorneys and they tell you that, I'm going.
But Dan did tell you, as you say in the jail call, that knowing what they're thinking up there, I don't know if you'll make it out in time. I really don't. But that he said you might, or you might get to the airport and they'll stop you. It could happen.
That's what he said.
Right. So you went to the airport knowing that they could stop you at the airport. You could end up being arrested.
Yeah, that's what Dan said.
Right. And when you were looking...
She went to the airport knowing she could be stopped at the airport. And then when she was stopped at the airport, she was like, what is this about? Why do you want my phone? I don't know what this is. You didn't?
At places to go a couple of days after Charlie Adelson's trial, you were specifically looking, though, for countries that did not have extradition with the U.S.
For the reason I just told you.
Right. And the reason that you're saying that you were looking for countries with no extradition was so that you could get back faster in order to...
I'm telling you what, if she sat on the stand and said, look, if I got extradited, they would put me in coach, and I'm not flying in seat 19C, I wanted to be able to book my own first class ticket back, I don't know if I would disbelieve her. Like, I don't know. I think if she said, I'm not getting extradited and flying coach back from wherever I go, I don't look, I might believe her. She's like, I need to book first class. Are you kidding me? Ugh, no lay flat bed. For all of you that are like, I don't fly coach. The Real Housewives of Salt Lake City, it became a plot line that Lisa Barlow would not fly in coach. That's it. She's like, I want the points. Then again, a jury might also believe that she thinks that. I'm not, honestly, Though the jail call is real damning, which is why they're trying to suppress it, because the jail call is real damning about her planning to flee, I think.
Arrested in the U.S.
No, that's not what I said. It's because, I don't know, maybe we watch too much TV or too many movies, but I've seen movies.
You don't watch enough TV if you're laundering money by washing it with water.
Where people are stuck in like third world prisons and waiting and waiting and waiting. And my feeling was, this is not what we want to happen. If the state says they want us to come back, we'll buy a ticket, we'll come back on our own terms. We don't have to be else somewhere. We'll come back home and turn ourselves in.
Couldn't you have done that no matter what country you went to?
She didn't think so.
No.
No?
No.
You couldn't have found out that you had a warrant for your arrest and come back if there was an extradition
Well,
policy?
not if they would, I'm not in law enforcement, but it appears that they would notify law enforcement in that country, and then they could hold you in a jail for God knows how long. And I didn't want that to happen. So he said, well, that's why we'll do it this way, honey. That way, if they do notify us, so we get a phone call from our attorney or from law enforcement, then we'll buy a ticket, we'll go home.
Okay.
And
She's
so
going to
it would have
argue
been on our terms. That was the point.
It would be on our terms. She's going to argue if when this goes to trial, if the phone call doesn't get suppressed, her argue is going to be she wasn't trying to flee, because you're allowed to use evidence of flight as consciousness of guilt. She's going to argue we weren't trying to flee. We needed a vacation. We were stressed. Our son had just been convicted. We needed to get out of the country. It was fight or flight, and we bought the tickets. So we needed to get away. Because she's going to argue it's not evidence of wrongdoing and it's not evidence of consciousness of guilt, which is how flight can be used. And so part of them trying to get the jail call suppressed is so that she can make that argument, because she was still arrested at the airport. Those facts are still going to come in. But if you suppress the phone call, it makes that argument easier for a jury to be like, oh, well, I mean, I see what you're saying. Maybe you just needed a vacay. The call makes that harder.
That was the reason that he thought that was a good idea.
And your
Before you continue, Ms. Dugan, we are over time. If you please can get to your most pertinent questions.
Yes, sir. I guess your testimony ultimately, though, is that you were not trying to go to a country with no extradition because you were trying to avoid being held accountable for this charge.
Because she didn't want to fly coach.
Being held, I didn't do this.
Okay.
Being held accountable for this is not what happened.
Being arrested for this case.
Being arrested?
Right. That was not what you were trying to avoid by trying to go to a non-extradition country.
We were trying to get our heads on straight and just breathe.
That's all I have. Thank you.
Any redirect examination for Mrs. Adelson?
Just one question, Judge.
You may proceed.
The testimony was you were offered an X-ray. You were never offered an MRI for your shoulder, were you?
No.
Thank you.
You may step down.
The
Mrs.
Chad
Adelson.
also believes that Donna Adelson needs an MRI.
Deputy
Chad
Police
is with you,
Assistant
counsel.
Police.
Chad also says she should have an MRI. Chad's like, right.
Does the defense have any other documents or evidence or witnesses that it intends to present?
Defense?
I don't have any other witnesses that I want to present. We did file a request to take judicial notice of the motion and order in the Adam Frash case where a request was made in a charge of first-degree murder for a bond for Mr. Frash, and that was granted. Has Your Honor had an opportunity to review that?
I did. The records of the circuit court, they don't have to be judicially noticed. What the other judges have done in the past certainly are a matter of record. Procedurally, we are in a different posture than Dr. Frash was, than your client, but any argument that you believe is reasonable, you may make concerning it.
Okay. The only other thing I wanted to do, Your Honor, is as an officer of the court, I wanted to represent We attempted to obtain a copy of a no-fly order because that letter was received after Mrs. Adelson was taken into custody, and the only response we were able to get was that there's not from the U.S. Department of Homeland Security Traveler Redress Inquiry Program, was that there's not an open dispute of a no-fly order. So I didn't want there to appear to be a misrepresentation by myself in the motion and us not being able to present anything to the court. That's as much as they would say in response to our request.
The defense argued in their motion that Donna Adelson is subject to a no-fly order. So they're trying to say we tried to get proof of that, but we can't get proof of that. I don't know who would give them proof of that, but she's trying to make clear to the court, which I appreciate the thoroughness, make clear to the court that they argued it, but they don't quite have the same, or they don't have like a literal order for that.
And then finally, I was glad to see that Mr. Google here is present, and I'm sorry I don't remember he's under sheriff, I think now, Mr. Google, in charge of the jail, and I just wanted to...
Did she say Mr. Google? Wait, really?
Represent to the court that I did inquire about outside care, and the reason I questioned the witness about additional care from other doctors is I did inquire as to whether we could have her taken to see other doctors to get treatment that she could not get in the jail, and Mr. Google advised me that with a court order that could take place, but we were never advised that without a court order she was able to get medical treatment that she was requesting.
Oh, those are two different things, counsel. This is where the confusion is. The attorney said if we want her to get outside care, we need a court order. And that's true. Lawyers can't just call up the jail and say, take my client to the orthopedist on Thursday. They have a 10 o'clock appointment. That needs a court order to the jail. But generally, if the jail has diagnosed an issue that they can't handle, they will then refer out if they think it's necessary. So it's kind of two different issues, which her counsel, as a defense attorney, would probably be aware of. Defense attorneys are normally very much in the know of currently what's going on in jail because they hear it from their clients regularly. So there are two different things there. But yes, the defense can go to the court and say, we need a court order to go for this medical treatment, and then go get the medical treatment. So if they want her to have an MRI, they should be able to get a court order for it. It's not an outrageous or difficult request, I don't think. And it seems reasonable.
Dugan, you may respond to the bond motion and present any evidence you have concerning presumption of guilt evident or, proof of guilt evident or presumption. Great, go ahead.
I have two very quick witnesses for us.
So the government now gets to present their witnesses. I'm going to try to go quickly because I'm going to start running up against a hard stop. So we are going to have to zoom.
To the medical or to the security concerns practices. State calls Chelsea Wilson.
For those of you asking why is she in shackles in court, there is no jury there, so that's not uncommon. I'm going to zoom through the gap while she calls her witness.
Do you swear or affirm the testimony
today.
you're about to provide will be the truth?
Yes, Your Honor.
You may take your seat.
Ma'am, can we see your
You may
Manny?
examine when you're ready.
Ma'am, we want to
Can
see
you
your
state
manicure.
your name and spell it, please? Chelsea Wilson, Chelsa.
Chelsea, I'm not sure what you do or why you're a witness, but I'm very interested in what your nails are.
Awilson.
And where do you work?
Leon County Sheriff's Office.
What do you do there?
Specifically, I am assigned as criminal investigations for the jail.
All right. Did you investigate an incident reported by Donna Adelson in February of 2025?
Yes.
That occurred back in October of 2024?
Yes.
And was that the incident where she said that an inmate twisted her arm in the bathroom area and told her that she wanted the canteen?
Correct.
Okay. Is there any video footage in the area where that took place?
No, not
it's
in
the bathrooms.
Okay. Did she
Which is why
disclose
she
to you
goes
the
down
name
to the
of the
bathrooms.
inmate?
No.
Did she disclose whether the inmate had ever been violent again, or any that is somehow related to the inmate in custody as far as being a friend or family member?
My understanding is a one-time incident.
If she had disclosed the name of the inmate, what could be done to hopefully keep that situation from happening again?
No, well, if we knew the name of the inmate, we could take measures to make sure that they were not housed together, that they were not in for example, classes together. I don't know if she's interested in classes, but measures could absolutely be taken to make sure that they were not able to have physical contact with each other for her safety.
If we don't know that inmate's identity, though, and we can't take her out of the area where Miss Adelson lives in the jail, is the only option then to take Miss Adelson out of the area and put her in an area where she cannot not be threatened again?
Unfortunately, yes.
Yeah, for her safety.
And did you let her know that? And if so, how did she respond?
I did during the investigation, trying to get the inmate's name who twisted her arm. I did explain to her that I would be able to move her back into a pod where she's able to move around more, where she's able to be social, for example. And her response essentially was that she felt
that would be a
although
problem.
she's not able to move around much in protective custody, she felt safer there, and that it does give her a little bit more peace and quiet to review legal materials for her upcoming trial.
That's all I have, thank you.
Yeah.
Cross-examination.
I don't have anything.
You may step down.
Wonderful. Next witness.
State calls Bobby Collins.
For those of you asking in the chat, this trial is set to start in June. Probably be about a week of jury selection. We'll see.
Do you swear or affirm the testimony you're about to give today will be the truth?
Yes, I do.
You may take your seat. You may examine when you're ready.
This is the
Can you
DA's
state your
next
name and
witness.
spell it for us, please?
Lieutenant Robert Collins, Robert Collins.
Thank you. And can you tell us where you work and what you do there?
I'm
he's a sheriff's
assigned
department.
at the detention. I oversee the classification unit.
Okay. How does the jail, the Leon County Detention Facility, handle when inmates are pressuring or threatening to buy them food from canteen?
Well, we interview the inmate, we gather information, providing what information that they give us. We will separate them out of harm's way and place the inmate separation, possibly follow up with incident reports or disciplinary reports.
Okay. And is there always an officer in every pod that an inmate can report an incident to, whether it be a security issue or a medical issue?
Yes, at all times.
Okay. Have there been any allegations made to the officers at Leon County Jail by Donna Adelson about any type of financial shakedown or threat in exchange for canteen, aside from the one made this month regarding the arm twist in exchange for canteen?
Not that I'm aware of. I only reviewed 2 incidents reports from February 3rd.
Okay, those were the ones made this month on
That
February 3rd?
is correct.
Okay, and those were the incidents that the defense cited in their motion?
Correct.
Okay, that's it, thank you.
Cross-examination.
I don't have anything. Thank you.
And
You
that's
may
it.
step down, Lieutenant.
That should be
Thank
the
you.
end of witnesses then. And the court
Student, do you
has
have
to
any evidence
balance
that you wish to enter pertaining to
safety and
Arthur
flight
as first
concerns.
evidence?
I do, Judge.
the strength of the case against the defendant.
At this time, I'd move, and I'll just go
Whether there is any reasonable way to have her out of custody and achieve all of those goals.
through all of them at once.
So the
States
court's
Exhibit
moving in
1,
documents.
which is the probable cause affidavit for Donna Adelson. States Composite 2, which
Also, the reason we're not seeing a ton of witnesses in this is the court has presided over the other trials. So the court is so well familiar with this case, different than the bond hearing in like the Corey Richens case. The PCA and other things are going to be sufficient for this court in this circumstance. And that's why we're not seeing all of the other witnesses like we did in the Corey Richens case to show the strength of the case against Donna Adelson, because the court's well aware.
are the transcripts from Charlie Adelson's trial, which Your Honor presided over. States Exhibit 3, which are a PDF of slides from Chris Corbett's PowerPoint presentation that only feature the analysis of Donna Adelson's travel the night of July 18th, 2014. The open line jail call that we've referred to today from November 7th, and the transcript of that states 4.
So this
the
all goes to the weight
transcript
of the
that
case
call,
against
which
Donna,
is states 5.
and the strength of the case against Donna.
States Exhibit 6, which is a chat with Vietnam Visa on WhatsApp by Donna Adelson. States Exhibit 7, which are excerpts from WhatsApp conversation between Adelson and Donna Adelson. And then finally, States Exhibit 8, which is a letter from the Markell family to the court, which defense has reviewed regarding their wishes for bond.
Concerning the state's exhibits, does the defense have any objection or anything to raise?
With respect to States Exhibits 4 and 5, renew our objection, as we believe the call should be suppressed, as well as the excerpt from the call and the transcript. So we would object on that basis.
Relates to whether the court will consider Exhibits 4 and 5 that will be tied to the order of suppression as to all other matters. Is there any objection?
No, Judge.
The court reserves whether Exhibits 4 and 5, and I believe which other ones were you contesting?
Just 4 and 5.
4 and 5 will be admitted. All other exhibits offered by the state for the purposes of Arthur and bond will be admitted at this time.
The thing is, they have Donna's phone, so it's much easier to decrypt WhatsApp messages when they have the phone. A lot of you are like, wait, WhatsApp? Getting WhatsApp from WhatsApp is different than getting it from her phone. So getting it from her phone is going to give them a lot more information. And they had a lot of devices, hers and her husband's in this case.
Time. Ms. Dugan, do you have all of these available?
I do.
The case can approach.
Okay, and then 1 through 7 are all on flash drive.
And the
Your
state's
device will
provided us,
snitch on you.
I downloaded a copy of the thumb drive earlier, so we have those as well.
So good.
All right, Ms. Dugan, you may make your final argument concerning the Arthur standard and also bond.
Yes, sir. I guess I'll go with Arthur's standard first. As to state to the transcript from Charlie Adelson's trial, I think that the parts of these trial that were most relevant to whether we've met the standard in Donna Adelson's case are the emails that show Donna Adelson's motivation to commit the crime when she voices her hatred towards Dan Markell, strategizes ways to get Wendy Adelson and her sons to live in South Florida. The thousands of dollars worth of checks we saw in that trial.
I forgot about the emails. I didn't forget about the checks. I did forget about the emails. I got distracted by Skittles. The freeze-dried Skittles right now are buy one, get one free at my Target or buy one, get one. Yeah. For like $5 at Target here. I don't know if that deal applies across the country. But the state is going to lay out the strength of the evidence against Donna. So part of their argument is these are all the things we have that tend to show that it is more likely than not that Donna did what we've charged her with, which is, again, murder in the first degree, conspiracy to commit murder, and solicitation of murder. So that's what we're going to get. I had forgotten about the emails.
As to state to the transcripts from Charlie Adelson's trial, I think that the parts of these trial that were most relevant to whether we've met the standard in Donna Adelson's case are the emails that show Donna Adelson's motivation to commit the crime when she voices her hatred towards Dan Markell, strategizes ways to get Wendy Adelson and her sons to live in South Florida. The thousands of dollars worth of checks we saw in that trial that were written to Magbanwa, signed by Donna Adelson when Magbanwa never worked for the family in any capacity. Magbanwa's testimony that Charlie Adelson was about her being the middleman between Charlie Adelson and the hitman for this murder, and how on July 18th, 2014, which was the night of the murder, that Charlie gave her money at his home, which she then delivered to the hitman. Magbanwa saying that she learned that night, the night of July 18th, that Charlie Adelson and his parents had just been at the home. It was her understanding that Donna Adelson had washed the money and the money was damp. For the State's Exhibit 3, which is the travel analysis, basically these slides show that Donna Adelson and Harvey Adelson's travel from their home in Miami to Orlando on the night of July 18th, 2014.
As somebody who prosecuted a number of conspiracy cases, if you are paying, check is going to be one of the easiest ways to trace who's paying. So yes, there were checks written from Donna to the middleman and cash given from Donna to Charlie to the middleman. And yes, she literally washed it and it was wet. But the checks written are not going to help, along with the emails expressing hatred for the victim and motive, which is the custody battle. So writing a check is going to, I don't even know if people write checks anymore. This was in 2014. But writing checks isn't going to help. So when we talk about whether there is direct evidence of what the husband was doing or what Wendy was doing, the type of direct evidence that we're talking about are the things that the state's listing out now. The emails, the conversations, the checks, those sorts of things.
At a certain point, Donna Adelson texts Charlie Adelson, "I'm outside your house," or "outside your house." Charlie Adelson then responds a little while later with 10 minutes. Cell tower analysis shows that Charlie Adelson is inconsistent with his house 10 minutes later. And when you look at the time it took for Donna Adelson to travel from the area of Charlie Adelson's home to the next point with location data for her north of Charlie Adelson's home, it shows that it should be about a 45-minute trip. But it shows that it took her 1 hour and 54 minutes. That shows there was 1 hour and 9 minutes unaccounted for during the time when she would have been waiting for Charlie Adelson at his house and could have stayed there for about half an hour once he arrived. And that could be consistent with her taking some of the money to Charlie Adelson's home, as Mabanwa describes. Exhibit 4 is the open line jail call we've already heard today. On page 8, she does say, after speaking with Dan this morning, after knowing what they're thinking up there, I don't know if we'll make it out in time, I really don't, but Dan says you make it to the airport or they may stop you. It could happen, but it's worth a try. She then says on page 16 that later.
I realized we didn't touch on it earlier. For those of you like Dan Rashbaum, one of the attorneys who was Charlie Adelson's attorney, who's the attorney that was yeeted off the case with regard to all of the conflict, or removed himself from the case with all of the conflict, that attorney. The attorney that talked to Donna about fleeing right after his client Charlie was convicted.
They've looked it up over and over because things change, whether there's from Vietnam. They could go to Korea or China because there's no extradition there. We are looking for places where there's no extradition. State's Exhibit 6, which is the...
I mean, with Korean skincare, how are we not picking Korea? I don't know. I've got questions. I've got questions. Like we were medi-spying. What?
Chat with Vietnam Visa on WhatsApp. In that first message, that service tells Donna Adelson that all of the messages are encrypted and no one can read them. She began on this WhatsApp trying to get the visas during the afternoon of November 7th. That's less than 24 hours after the trial transcripts and state deposit to reflect that there was a jury verdict in Charlie Adelson's trial. Donna Adelson says in that conversation that she needs an emergency fast-track visa for her and her husband. When given the option of 30 or 90-day visa, she chooses 90, unless she can only do 30, and in that case, she'll do it and just extend it. She then sends passport pictures and pays for the visas.
So you guys are saying they mean North Korea, not South Korea.
Okay,
I retract everything I said. But also, if South Korea is the option, South Korea.
Nervous because she hasn't received the visas yet, and she's typing all of that in all caps. She says her flight is booked at that point, which is the one-way trip to Vietnam with the layover in Dubai. That's within days of Charlie Adelson's verdict. The chat shows then that she got the visa just in time, I think the day before the flight, and then she ended up being arrested on the jetway in Miami right before she boarded the one-way trip to Vietnam. We also have the excerpts from the WhatsApp with Charlie Adelson, State's Exhibit 7. This is a conversation that the court has seen before. We've had a motion hearing about it, I believe, where basically we were able to get these messages in 2023 when Donna Adelson was arrested and we seized her cell phone. This is from the WhatsApp with Charlie Adelson on her phone. These are WhatsApp messages, though, that occurred in August of 2016. And there's a conversation between Charlie Adelson and Donna Adelson where Charlie Adelson is basically workshopping ideas that maybe the killer was a coke dealer and that Danny was just buying drugs from him. And in they don't mention anything about extortion, which ended up being Charlie Adelson's defense at trial, that he didn't intend for this to happen, that he was extorted, and that he didn't do this.
They were workshopping defenses on WhatsApp. I mean, at least he stuck with it, I guess.
And finally, the letter from the Markell family. Given the totality of the evidence in this case, the state does meet the burden under Arthur. The state has met its burden for every defendant who has been charged in this case and had an Arthur hearing. They have all been held in custody until trial. And none of them tried to flee to a non-extraditable country to avoid being charged before arrest. If court somehow believes the state falls short, though, the defendant should still be held no bond because she is absolutely a flight risk, given her past actions. More so now than ever, now that she has actually been charged. What we saw her talking about on the jail call and doing in the visa chat and going to the airport for and being arrested there, that was all before she was even arrested, when she just knew that the charge was coming. Now she has been charged, she is facing life in prison, so I think she's more of a flight risk than ever when you consider a totality of all of that information. As to the bond argument, we heard from, the Mike Hayden, who's the medical administration. All of the defendant's complaints have been evaluated. Medical staff has treated them. She's been able to see a doctor in a day or two. That is faster than most of us who are out of custody could see our doctors. She was given Band-Aid and Neosporin for the cut on her arm when she bumped into the laundry machine. Sometimes accidents like that happen, and that could also happen to her out of custody as well as it could happen to her in custody to bump into something and get a cut. We heard about her breathing and pain issues. Doctors ordered x-rays to make sure nothing more was going on, and the x-rays were negative. Medical staff can provide treatment for any medical needs, whether it be on-site or them having to go to a hospital, but they also need evidence of what's wrong and what needs to be treated beyond the inmate just saying that they hurt. And to see a specialist, there does need to be a necessity. If there's a necessity, Leon County Jail will recognize that and make the necessary referrals. Ms. Adelson has complained about the jail being too loud. The food is not good, but she is in jail. It's not the Four Seasons. All of her necessities are being met, and she should bring and should.
Counsel, are you reading the chat? Because I think I saw this argument in the chat. In the chat. I didn't realize it was a spoiler. I thought you all just had the same sentiment. No, I think you all just had the same sentiment. But Your Honor, we know that the food's not good.
Should she bring a medical necessity to the staff's attention, they will continue being met.
And she can get a court order for specialists.
As far as security is concerned, she wouldn't provide the identity of the inmate that caused the concern. If she would, then she could remain where she is while the other inmate is taken out. However, because she won't disclose, the only option right now is her being in protective custody. But as she did.
Lyndon in the chat said Donna scoffs at the Four Seasons. Yes, only the Ritz. Only the Ritz for Donna.
Tell the investigator that does, even though I'm sure it's not very exciting, its downsides, it is a quiet place where she can prepare more for trial. And so she's saying that she prefers that right now. The state asked that she continue to be held no bond at Leon County Jail because she's safe there and it will guarantee her presence at trial.
Final argument from the defense.
With respect to Arthur and every other defendant prior to Ms. Adelson being held and Arthur being met, Ms. Adelson isn't the prior folks. She's not the ones who showed up at Carl's residence with a firearm who planned to kill him and then did shoot him at very close range and take his life. She's not them. There's proof there. They can meet their burden there, clearly. That's not what Mrs. Adelson is even alleged to have done. In this case, did they hold Charlie? Yes, they did. They met his burden too. The proof against Charlie is very different. I'm representing, Your Honor, a woman who stands before this court, and the argument out of the state's mouth literally is what I put in my motion. She said some bad things about her future ex-son-in-law prior to the divorce being granted.
And paid the middleman.
She cut some paychecks out of Charlie Adelson's business, and it was her job to cut the paychecks. And at his instruction, she cut paychecks to Catherine Magdanawa. When her daughter called to say that her soon-to-be or her ex-husband had been shot and killed Ms. Adelson got in her car with her husband and drove from Miami to Tallahassee, and they're elderly folks, and that's a part of the record. It's a natural course of travel from Miami up to Tallahassee to go through the Orlando area. The state actually said in its argument that the time that lapsed between when they show the cell phone records of Donna Adelson and being near Charlie Adelson's house, and then when Charlie says he's going to get back, could be consistent with Mrs. Adelson stopping there and giving them this alleged pre-washed money. Could be consistent is not the Arthur standard. It's proof evident, presumption great. And they simply...
Proof evident or presumption.
Or presumption great.
Go
And
ahead.
they don't have that in this case, Judge. What they have is the strongest, could be consistent with. Their entire case against Mrs. Adelson is speculation. The problem here is not one problem, that health issues are not being taken care of, or sleep is being deprived, or, you know, she's not getting the food that she likes. Nobody's complaining about the fact that she's not getting food that she doesn't like. She's gained a third of her body weight. They can't protect her in the jail. They've testified themselves. There are no cameras inside the area where they use the restroom, the area where they take the shower, where these washing...
Can you imagine the issues with having cameras in the restrooms?
Machines are. There are no guards in there. There's no video in there. So if she disclosed the name, which she's willing to do in camera to the court with nobody else present because she knows she's going to be retaliated against, they can't protect her from retaliation. If they put her back in the annex and some girlfriends or friends of this woman that she rats out finds out that she's back in there, they can take her down in the bathroom, and the guards who are sitting behind a glass being protected themselves aren't even going to know it's happening until it's too late. So providing the name doesn't do that. I have a
Before you
client...
go on, Ms. Fulford, as to the sheriff's role in this, he has a constitutional responsibility to all inmates. Also, your client has the ability to pursue a writ of mandamus if the sheriff will not fulfill his obligations. Is there a reason this has not been pursued if the situation is, as you allege through your motion and testimony?
Because that's not the only issue we have, Judge, which is what I was getting to. What we have before us is a woman who's 75 years old. She's elderly. She has health issues that aren't being addressed, but there's more. She's not getting any sleep. She's given medication between 11:30 and 1:30 at night, maybe getting to sleep by 2 o'clock in the morning, waking back up at 3 or 3:30 in the morning. We're not asking that she get special treatment. She's on trial for her life in a town where everybody believes she's guilty. That for 10 years, it's been the same story, that the mafia mother has planned out this homicide and had Dan Markell killed on this evidence that could be consistent with.
I think the mafia might be insulted by that. I had no idea that they are calling her the mafia mother, because I've never seen the mafia wash money with actual water. I'm just saying.
And that's not what we have. We can't prepare her for trial under these circumstances. Can we go and visit with her at the jail? Yes, we can. Do we have contact visits with her where we can prepare? Yes, we do. But we can't be up there 5 days a week. We can't be up there 7 days a week. We can't be there for lengthy hours. We're not the only ones who are requesting that time. When we got the records from the medical records from the state last week, there was one time that the jail was able to squeeze us in for 1 hour to go through the medical records with her. Over 300 pages of medical records. And we had other things to do in that time for us to meet with her. And I'm not criticizing the sheriff's office, and I'm not criticizing the jail. The circumstances are what the circumstances are. But if she remains in the jail, we simply cannot have her prepared to testify and assist with preparation of her defense. I cannot have an attorney-client privilege call with her there. It's the most frustrating thing in the world. This phone system that they have, they say that's not recorded, and we get cut off. It says we're making third-party calls. Neither one of us has made a move. Nothing's happening. We get cut off in the middle of the calls. She has this labored breathing. If they can't find anything in the x-rays, I'm certainly not a doctor.
See, Taylor, I think there's probably things people call Donna Adelson. I was going to say the mafia mother is probably not one of them. It doesn't even make sense to me. Also, if you are the mafia mother, you're going to be protected in custody, I would think. But overbearing, maybe. Mafia mother, probably not.
I don't know why she's got it, but I have to start yelling to have her to stop talking because she's breathing so loud, I can't hear a thing she's even saying.
Can you imagine these doing a Zoom call?
She did not flee prosecution.
Donna-
She was
Donna
told,
talking to her, being like,
and witnesses for her were
"Stop, I can't
told
hear."
there was no prosecution. There was no warrant for her arrest. That it was perfectly fine, and the state knows this. Their own investigator told a family friend, there's no warrant, they can travel. They didn't attempt to flee being prosecuted. They were told there was no warrant.
Is this
for
part
her
of the
arrest.
evidence that's in the record, or you're just making argument generally about this?
I'm making an argument generally at this point, Judge, but the state knows it. If they're going to claim that she was actually fleeing, they know better. They know that their own office said it was okay for her to travel. And where did she get to? Absolutely nowhere. And they have absolutely zero evidence to rebut her testimony that she was not going to flee prosecution. She was just going to get away to clear her head. In fact, she thought she wasn't being charged. And that's all the evidence that she had. Now, if we were coming...
She thought she wasn't being charged.
...before you and she had actually fled and someone had to bring her back, I wouldn't put my name on a motion saying, give us a bond.
They stopped her.
But this isn't the first time that people have gotten a bond. Even people who fail to appear ultimately get bonds sometimes. Your Honor's aware of that. That does take place. People who violate their can get put back out while their hearing is pending for that.
Ma'am, not in murder cases, though. Not in murder cases, though.
Violation of probation. If she has already surrendered her passport, she doesn't have a visa, she agrees not to drive, an electronic monitor is placed on her, she resides in Leon County, has to check in with pretrial as many times as you say she has to check in, can only leave for limited purposes, she's not going anywhere. And we're not asking, let's let her go back to Miami where she has an international airport that she can hop on and be gone before anybody knows that her bracelet is going off. We're asking that she be held right here, that she be court-ordered to stay here with a monitor on, be allowed to be away from that home, to go to doctor's visits, get any medical treatment that she needs, come to court, be with her lawyers, and prepare her trial. We're not asking for a fancy hotel or anything else. And quite frankly, that's a little bit insulting considering the health conditions that she has to suggest that she's looking to be put up somewhere. The one thing the state fails to remember is she's presumed innocent. No, the Leon County Jail is not a Four Seasons hotel, but she's not supposed to be punished yet, right? She hasn't been convicted of anything.
There is a difference between pretrial detention
and she's been punished at this point. When you take not one of these things, but all of these things together, she doesn't stand a chance of being actually ready to testify for trial. That cannot take place under the conditions that she's facing. She's in extreme pain.
And that's the same argument Diddy's lawyers made. We can't prepare for trial. We can't prepare for trial. We can't access our client well enough. We can't prepare for trial. Is it easier to prepare for trial when your client's out of custody? I'm sure that it is. I'm sure that it is. Is it unusual to prepare for custody or prepare for trial as a defense attorney with a client that's in custody? No. But she's making her arguments.
She's not getting any sleep. Her diet is garbage. It's just not going to happen, Judge. And you know, if we were asking for something lenient, I could see the state's opposition. But we're not. We're asking for you to hold her outside of the jail in the most stringent conditions she could possibly be monitored.
She can also
just to allow her to be with her attorney, get her doctor's
specialists.
appointments, and get ready for the trial that her entire life depends upon. And I would argue the state has not met its burden. Thank you.
Very well. I will review the admitted exhibits before making a ruling. We are in recess. This concludes the hearings. You may
And we're
take
done.
Mrs. Adelson downstairs.
Thank you, Your Honor.
Thank you, Judge.
And we're done. All right. That is the end of this day in court. And again, if you all are like, a lot of these arguments sound the same, yes, they do. They are very common arguments to be made on a bail motion. The other defendants have been denied bail. I think there's evidence here that the defendant tried to flee when it became clear that she might be prosecuted, and the court can use that against her in considering the bail motion. So we're going to hear from the court. They generally rule pretty quickly. I'm going to keep an eye on it, but the court generally rules pretty quickly. I'm really more interested in the ruling on the wiretapping argument. I think she's going to be denied bond. I think the court will say, if you need court orders for additional medical care, I will make those orders. And I think that is a reasonable accommodation that is not hard to happen. There's also the possibility of a writ. So today we heard the arguments for bond and we heard the arguments for suppression. When the court rules, I will be covering it. I wish I could answer questions. I've gone over my hard stop, which is going to make things very squishy for me. So I have got to zoom. Thank you for your super chats. I was in the chat trying to respond to them in the chat bar as I could. Thank you to everyone who gifted memberships, including B2 for the 20 gifted memberships. Members, I will see you later tonight, probably at 7. It might be a little bit later. I will keep you in the loop. If I need to bump that time back, I'll come in to the chat and let you know, but I'll open up that chat soon. We should be streaming tomorrow, but I will let you know in the Lawnerd app because I'm also trying to get T to a doctor's appointment. So there might be a little squishiness for tomorrow's stream, but I will keep you posted. I am sorry to have to run at the end of court. It's been a busy hearing and I wanted to chat through it with you. And then I ran up against my hard stop. So Lawnerds, you're the best. I will talk to you soon. Members, I will see you tonight. If you've not joined the membership, you can do that here. If you are in the Lawnerd Lounge and are not a member here on YouTube, you will get notified there. So I will see you tonight. Chat, thank you for being amazing. I know this case is hard. Donna brings out real strong feelings in folks, and I get it. It's really hard in a case where you've seen so much of the evidence come in trial after trial after trial, because I try to keep an open mind, but we've seen a lot with Donna. And it's harder, but we'll see how strong the evidence is when it gets to trial. It is a lot of circumstantial evidence, except for those checks. They're going to try to argue they were business expenses, and that didn't work in Charlie's trial. I don't think it's going to work in her trial either. All of you guys, thank you to our new and onboarding moderators. It's so good to see you in the chat. Some new faces for the chat. Well, familiar faces for the chat, but some new wrenches. So I appreciate it because we're going into trial season and it's gonna be busy. Lawnerds, you're the best. I will see you soon. All right, we out. Lawnerds, I'll see you. Get the Lawnerd app. It's gonna be the best way to stay in the loop with schedule changes. All right, see you guys. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Lawnerd.